fresh matter.
Fresh matter ಕೊಡಬಹುದು. One matter is settled, you know.
My lord, I am for the appellant, National Highway Authority of India. 2019 matters, my lord. Some of the matters are admitted, other matters connected are in stage for admission and kindly.
Tomorrow come for admission.
Tomorrow's date of it.
Please give it, we'll see. Please give it, we'll see. You don't ask for tomorrow. One matter is settled, you tomorrow for RFA, first appeal.
Matrimonial case, my lord, matter is settlement. We've taken Friday, my lord. Matter is settlement. Matrimonial case. We've taken on Friday. Please.
Yes.
Kindly. Serial number 48, Lord. I am for the respondent. I seek 1 week time, Lord. Other side, I have informed. Next week, 14th, Lord. Please. Respondent 1 to 3, Lord.
Manavendra Reddy is the
He has directed to me to be present before the court members first.
for making submission.
Yes, members. On behalf of Manavendra Reddy.
Serial number 48 at the request of learned counsel for the respondent. Release this matter.
14th, Lord.
Final hearing. On 14th of November.
Please.
Yes.
Serial 28. Serial number 28 minutes. I have informed the other side. They have requested it.
Here.
Colleague is here. Monday or Tuesday they have requested. I said I'll be seeking time. They said it would be convenient for them if it is posted on Monday or Tuesday. I have talked to madam.
Kindly maybe on Monday or Tuesday.
The request of learned counsel for respondent for 3. Release this matter
Monday or Tuesday, madam.
on 11th of November.
Any day.
Yes.
Serial number 35, my lord. I am filing application for impleading as a respondent number 3. I informed to counsel for appellant.
ಅವ್ರಿಗೆ ಇರ್ಬೇಕು inform.
ಇಲ್ಲ ಹೇಳಿ ಸರ್ ಹೇಳಿ.
Just 35.
Informed. Yes.
Meeting on whose behalf?
I am filing application for impleading as a respondent number 3. Impleading respondent number 3, madam. Filed, madam. So a week time may be granted for.
ಆಗೋದಿಲ್ಲ.
ಇಲ್ಲ ಅವ್ರಿಗೆ ಹೇಳಿ ಸರ್.
Where is Mr. Ambekar?
I am appearing on behalf of.
You are for Mr. Ravi.
ಇಲ್ಲ ಇಲ್ಲ.
Who's for the respondent?
Nidhi Patil?
No, when matter is called up, please. Yes.
Serial number 34. May I request my lord's week's accommodation appearing for the respondent. I have informed the.
Ravindra Reddy. No objection.
Any date may the next week, 13th.
Serial number 34 at the request of learned counsel Sri A.M. Nagaraj.
Yes, R4 to 80. After 15.
13th of November.
Please. My lord, serial number 26 minutes. Kindly have it tomorrow or day after tomorrow. 26, it's hearing on IA. It's covered by Supreme Court judgment. 26 and 20.
Serial number 26, the request of learned counsel for the appellant.
Tomorrow or day after tomorrow.
Want it tomorrow
Tomorrow or day after tomorrow.
on the 7th of November.
My lords, and serial number 50, final hearing, my lords. Kindly have it on 19th, I'll argue on that day. Final hearing matter, 50. I am ready in this matter. I'll just compiling citations. 19th, I'll argue it. 50.
Number 50, the request of learned counsel for the appellant. Release this matter on
19th minutes. 19.
19th of November.
Now,
Akuda.
Please.
I'm
Well, it's one submission. Serial number 26, can let me post on 8th, madam. Day after.
Yeah.
26th. Now it has been posted on 7th.
ನಾಳೆ ಬೇಡ, ನಾಡಿದ್ದು.
Nadit.
8. All.
Serial number 1 of pronouncement of orders on IA 2 of 24. Vishal Pratap Singh.
IA number 2 of 2024 filed by the appellant under section 389 1 of Code of Criminal Procedure is partly allowed. The order of sentence dated 20th March 2024 passed in SC number 87 of 2014 by the District and Session Judge Yadgir shall be suspended on the following conditions. Appellant shall be released on bail on executing a cell bond of rupees 2 lakhs with one surety for the like sum before the registry of this court. Appellant shall appear before this court or any other court as and when directed to do so. The appellant shall deposit the entire fine amount before the trial court within 4 weeks from the date of receipt of the copy of this order. Appellant shall not leave the country without the prior permission of this court.
Non-compliance of office objections for fourth time. CL number 2, Viran Goda Mali Patil.
Week time is granted. It's a request of learned counsel for the appellant for complaint of office. Please say.
CL number 3, Viran Goda Mali Patil.
Stay here.
Hello.
Please say.
4 to 6, my lord, 2 weeks time may be granted.
Huh?
4 to 6, my lord. 2 weeks time may be granted.
At the request of learned government advocate for complaint of office. 4, 5, 6.
Please.
CL number 7, Mantesh Patil.
Finally, 2 weeks of granted. The appellant for complaint of office.
Order CL number 8, Government Advocate Manvendra Reddy for appellant number 2.
In this matter, my lord, lordship is directed the other side to file the memo, my lord. But last occasion, my lord,
I appear for the claimant's respondent. Notes. This matter on the last date of hearing, I was directed to file a memo. If I may kindly pass on the memo. Etc. One second. The claimants have withdrawn the entire amount, my lords.
Huh?
The claimants have withdrawn the entire amount. So far as,
They have satisfied.
yes, my lords,
Satisfied
all of the amount is satisfied.
Huh.
In light of that, my lords, I was directed to file a memo. And the appeal would stand infructuous in.
Yes. Yes, Mr. Government.
yes, ma'am. Second appellant is the beneficiary, my lord. They made the submission that, my lord, in the EP, they already satisfied the
Correct.
award. They filed the memo, my lord, you have to pass the order on this, on the basis of this memo.
Sign ಮಾಡಿಲ್ಲ.
And
Copy ಕೊಡಿ. Copy ಕೊಟ್ಟಿದ್ದೀರಾ?
yes, my lords, I have served him a copy. Sorry, ಕೊಟ್ಟಿಲ್ಲ, ಅವ್ರು ಇನ್ನೂ ಬಂದಿಲ್ಲ.
Deputy Chief Engineer, South Central Railway. They have satisfied.
Is the beneficiary have satisfied?
Satisfied.
Yes, my lords, the beneficiary has satisfied the amount.
Manvendra Reddy.
He's held up in other court this
Huh?
morning.
Counsel for the response for claimants
Yes, ma'am.
has filed a memo dated 6/11/2020 along with documents to show that the second appellant beneficiary has satisfied the award by depositing the sum of rupees 48,68,925 before the executing court. So, the power of attorney holder of the claimants, the Atul Kumar, son of Damodar Das Darbar, filed an application to withdraw the award of the rights. And accordingly, the executing court allowed the application and permitted the claimants to withdraw the entire amount and thereafter closed the execution petition as fully satisfied. Full stop. In that view of the matter, learned counsel for the respondent claimants submits that the prayer made in the miscellaneous first appeal has become infectious. Full stop. Next paragraph. Consequently, the miscellaneous first appeal stands disposed of in view of the facts stated herein above. So, ordered accordingly.
Please.
Serial number 9, additional SPP.
State appeal, my lords, the offense is 302. Notice is to be issued to respond number 1 to 3, my lords. Yes, madam. Yes, madam. Reissue notice.
Reissuement.
Yes, ma'am. So 302 and offenses. State appeal, my lords.
Issue fresh notice to the respondent to consent. Kushnur police station, police,
Yes,
huh?
yes.
To the what was the direction?
Push direction.
To Kushnur police, returnable by
28th November.
28th of November.
Please.
Serial number 10, BK Ramat.
Non-receipt of bail, police, non-receipt of police report, man.
Same, huh?
This is complaint appeal, man.
It's a acquittal against appeal.
Huh?
It's a acquittal against complainant appeal, my lords. The notice have to be,
There also notice was.
yes, ma'am.
Yes,
Police.
yes, ma'am.
Yes,
And report is not received.
no, not received.
You have to take fresh steps.
Yes, fresh.
Huh?
Yes.
When was it last issued? Kalaburagi.
Section of it. 1 to. Yes, response number 1 to 3. To be served through the Commissioner of Police, Kalaburagi.
Hmm.
Returnable by
29th of November.
29th of November.
Ali, the rural police. Rural police is it?
Ah, sir.
Kalaburagi rural police.
Yes.
It is not come under the jurisdiction of police commissioner,
ಇಲ್ಲ ಬರುತ್ತೆ ಸರ್.
superintendent of police ಅಲ್ಲ.
ಇಲ್ಲ ಈ ರೀಸೆಂಟ್ಲಿ ಇದು ಮಾಡಿದೆ ಸರ್. ಕಮಿಷನರ್ ಆಫ್ ಪೊಲೀಸ್.
ಕಲಬುರ್ಗಿ
Rural.
ಇದರಲ್ಲೇ ಈ ಸಿಟಿಲೇ ಒಂದ್ ಭಾಗನ ರೂರಲ್ ಅಂತ ಮಾಡಿದ್ರು. But that also comes under the commission.
ಕಮಿಷನರ್ ಬರುತ್ತೆ.
Case number 11, RJ Busari.
Additionally,
Please, madam.
please get it clarified. If it doesn't come under the jurisdiction of the commissioner,
Please,
we will modify the court.
please,
Huh?
please.
Case number 11, RJ Busari.
Appear for R2, my lord. R1 is served, my lord. I'll get the instruction from the R1, my lord. WhatsApp have it next week, my lord. There is a direction to consider the representation. He served, my lord. I have not received instruction from R1, my lord. Have it next week, my lord. By that time, I'll get the instruction.
The request of. So, learned government advocate is directed to take note for respond number 2. Yeah.
Two already taken, my lord.
Direction agide, you have not filed a memo of appearance.
But I'll file it.
At the request of learned government advocate, really matter on 13th of November
Please,
for complaints,
please,
for reporting complaints.
please.
Case number 12, Ganesh Subhash Chandra Kalaburagi.
Lord respondent is present. He is not ready for divorce. Matter may be admitted and ಅವನು ಆಗಲ್ಲ ಅಂತಾನೆ ಬಿಟ್ಟಿರಕ್ಕಾಗಲ್ಲ.
Your Lordship, it is a wife's petition.
Clear.
Yes, in chambers, Your Lordship. In fact, it took time.
ಮುಂದ್ ಬಾ.
ಮುಂದೆ ಬಂದು.
ಏನು ಯೋಚನೆ ಮಾಡಿದೆ? Then you please make your submissions. Yes, sir. We are ready.
Matter may be admitted. I will.
There is nothing. Yes. Great to be heard. So please make your submissions. Yes. Yes.
One short
Your Lordship.
tomorrow.
No. Yes. Your Lordship, it is a second round of litigation, Your Lordship. Previously, the wife appellant has filed a petition. Yes. The wife appellant has filed a previous petition, Your Lordship, under section 13 of Hindu Marriage Act, seeking divorce, Your Lordship. That was disposed of, granting liberty to the petitioner to file a suit seeking the nullity of the marriage, Your Lordship. Previously, Your Lordship, the appellant wife has filed a, Your Lordship, matrimonial case seeking divorce under section 13 of Hindu Marriage Act, Your Lordship. In that, she has taken a contention that the marriage has not happened. It is only the registration certificate which has been produced. And on that contention, she has filed a petition. Your Lordship, that petition was disposed of, granting liberty to the appellant wife to file a suit seeking nullity of marriage, Your Lordship. After that, the present matrimonial original suit has been filed, Your Lordship, seeking nullity of marriage. The present petition has been previously a husband has also filed, Your Lordship. That is, the respondent has also filed a petition seeking conjugal rights, Your Lordship, restitution, conjugal rights. That was dismissed, and a specific observation has been made, Your Lordships, in that it is at exhibit P3, Your Lordships. Records have come, Your Lordships. Exhibit P3, Your. From page 4, if I am permitted to read out. Exhibit P3 is the judgment, your lordships, passed in a petition filed by the respondent seeking restitution of conjugal rights. P3. Your lordships. From page 4, if I permitted to read the reasoning portion, your lordships. I will read it from reasoning portion, para 8, your lordships. Yes. Petition is one under section 9 of Hindu Marriage Act 1955. The petitioner, in order to prove his case, himself examined as PW1. He has reiterated the entire petition arguments in his evidence. The petitioner has mainly contended in his petition as well as evidence that he got married registered with the petitioner on 13/10/2017 before sub-registrar Kalaburagi. After the marriage, they led married life for 1 day. Mother of respondent suffered heart disease and he has directed to leave the respondent in her parental house. Accordingly, he left respondent in her parents' house. After 2 months, petitioner asked respondent to join his company, but she refused it. The respondent has categorically denied the said allegations and contended in her objection that respondent got married or forcibly by blackmail by snapping her so-and-so photo when she became unconscious and after she has provided cooked drinks placed with sleeping pills. She further contended she did not join the company of petitioner and she did not lead married life with petitioner a single day. Though the petitioner has contended that he had led married life with respondent 1 day, but there is no any eyewitness to support said contention of petitioner. On the other hand, the petitioner himself has contended in his petition that since mother of respondent suffered heart disease, he left respondent to her parents' house. Under the circumstances, the respondent voluntarily leaving his house does not arise at all. If really the petitioner has married with respondent, what is the reason for respondent to refuse the join of the company of petitioner only after 1 day of the marriage? It shows that the registered marriage of the respondent with petitioner was forcibly made and respondent never joined the company of petitioner and she never led married life with the petitioner. The petitioner has falsely contended in his petition that he performed marriage with respondent and led life with her for 1 day. The document exhibit P1 marriage certificate reveals that the petitioner and respondent had got performed registered marriage and the exhibit P3 in which the petitioner and respondent appearing jointly having garlands in their neck, but only on the basis of exhibit P1 and P3, it cannot be said that the respondent has joined the company of petitioner and they led married life and petitioner is entitled to seek the company of respondent to seek conjugal life with respondent. Under the circumstances, I am of the opinion that when the parties have not at all led matrimonial life and no marriage has consummated between the parties, then the question of respondent voluntarily leaving the house of petitioner does not arise at all. Hence, I answer the above point number in the negative. And the petition has been dismissed, your lordship. This judgment has never been challenged, your lordship. The observation made therein has never been challenged. In fact, at para 24 of the impugned judgment, your lordships, there is no single document or photographs, your lordships, having performed the marriage. There is no photographs at all, your lordships, of the marriage. It is only the registration certificate on the basis of which he claims to be the husband of the appellant. In this matter, your lordships, 3 evidence has been led. One is himself, another is the, your lordships, so-called, your lordships, Pujari, who, your lordships, alleged to be have performed the marriage. In fact, he is not able to, your lordships, in the cross-examination say what all ceremonies he has performed. That has been observed, your lordships, even in the judgment also. The contention is that the marriage was conducted outside. The marriage was conducted in some temple. As per his, your lordships say. Huh? Yes, yes. And no other witnesses have been no, your lordships. Brought to the witness box. No, your lordships. Except the Purohit and one of his friend, your lordships. Huh? One of his friend of the, your lordships, respondent. Apart from that, there is no photographs, witnesses, there is no receipt of the temple, your lordships. Wherever they perform marriage in the temple, they issue a receipt, your lordship, for performing marriage. There is no receipt at all. Apart from the certificate of registration, there is no, your lordships, evidence. Even that has been recorded, your lordships, by the, in the impugned judgment. If I permitted to read the relevant portion, Page 32 of my appeal memo, Your Lordship. Para 26. As discussed above, DW3, who is priest of the temple. Page 32, Your Lordship, para 26. As discussed above, DW3, who is priest of the temple, deposed how he performed the marriage, what rituals he had followed. If the marriage is arranged by the parents, relatives, and well-wishers of both the parties, one can expect all the rituals are to be followed. But when two young hot-blooded teenagers fell into love and decided to marry, it is hard to believe that they will marry each other by following all the rituals and rites. Even most of the marriages are being done by exchange of garlands, tying tamarind piece with thread as a tali. So in such circumstances, one cannot expect observing all the rituals of the marriage followed in the arranged marriage. Your Lordships, petitioner and respondents are Hindus, Your Lordships. In order to solemnize the marriage, Your Lordships, all the customs has to be strictly followed. Even that observation has been made by the Supreme Court, Your Lordships. If I may rely upon the judgment with regard to Your Lordships compliance of Section 7 of Hindu Marriage Act, if the marriage is not solemnized by following all the custom and rituals, it cannot be, Your Lordships, the boy and girl will not hold the status of husband and wife. Your Lordship, with regard to compliance of Section 7, Your Lordship. With regard to section compliance of Section 7, if I am permitted to rely upon the judgment of the Honorable Supreme Court. Page number 3, Your Lordship, relevant portion. It is on the right bottom corner, Your Lordship, page number 7. Section 7 of the Act reads as under. 7. Ceremonies for a Hindu marriage. A Hindu marriage may be solemnized in accordance with the customary rites and ceremonies of either party thereto, where such rites and ceremonies include the Saptapadi, that is the taking of 7 steps by the bridegroom and the bride jointly before the sacred fire. The marriage becomes complete and binding when the 7th step is taken. Section 7 of the Act speaks about the marriage of Hindu marriage. Subsection 1 uses the word solemnize. The word solemnize means to perform the marriage with ceremonies in proper forum. Unless and until the marriage is performed with appropriate ceremonies and in due form, it cannot be said to be solemnized. Further, subsection 2 of Section 7 states that where such rites and ceremonies include the Saptapadi, that is the taking of 7 steps by the bridegroom and the bride jointly before the sacred fire, the marriage becomes complete and binding when the 7th step is taken. Therefore, requisite ceremonies of the solemnization of Hindu marriage must be in accordance with the applicable customs or usage. And where Saptapadi has been adopted, the marriage becomes complete and binding when the 7th step is taken. Where a Hindu marriage is not performed in accordance with the applicable rites or ceremonies, such as Saptapadi when included, the marriage will not be construed as a Hindu marriage. In other words, for a valid marriage under the Act, the requisite ceremonies have to be performed. And there must be a proof of performance of the said ceremony. When an issue, what is the
ceremonies that have to take place according to your custom.
Your lordship, Saptapadi is part of our customs, your lordship. Your lordships, in fact, I have stated that such a marriage has not been performed, your lordships.
You are saying, if you want to rely on this judgment. then
True, your
it is For
lordship.
you to have said, these are the ceremonies in our custom, Saptapadi should have been, is necessary.
Yes, your lordship.
Have you taken that stand?
Your lordship, specific contention has not been taken, note. Specific contention has not been taken, your lordship, with regard to that. Your lordships, I have taken, as my contention is that marriage itself is not performed, your lordships, they have not pleaded with regard to your lordships customs and rituals.
Your initial, your contention that there was no marriage at all is to some extent sought to be challenged by submitting certain information, including the
Ceremonies.
examination of the Purohit who conducted the marriage. So the initial burden, which was on the respondent to show that there was a marriage, he has satisfied that by summoning the Purohit who conducted the marriage. Now, the next question is, if you are raising a contention that they have not followed any rituals, then you should have stated what are the rituals that were required to be followed. Whether Saptapadi is a part of your ritual.
In the, your lordships, in the cross-examination, we,
Things.
if I permitted to read the cross-examination of DW3, your lordship.
Yes. In fact, it should have come in your examination in chief.
Yes.
In your examination in chief, you should have said that these are the customs and rituals that are required to be followed
True,
for marriage to be valid, and that they have not been followed. That you have not done.
Pleading, we have not taken. Cross-examination of DW3, your lordship.
Yes. DW.
I'll read the chief and the cross, your lordship, of DW3.
Rajshekhar Swami.
Yes, yes, your lord, Rajshekhar. I am priest Swami by profession. I was called by the defendant to perform his marriage as a priest. And as requested, I have performed the marriage of defendant with plaintiff as on officiating priest on 30/6/2017 at Ramtir Temple, Anand Road, Kalaburagi. All the religious and customs were followed in the marriage. Both the parties took bath in the morning, Surgi Snana, and thereafter Aarti was made and sacred fire was lit and bride was asked to wear touring anklet and bangles, and kumkum was put upon her forehead, and thereafter chanting mantras, Mangala Sutra was tied by the defendant to the plaintiff, and thereafter Akshata was performed, and all the religious and customary performances were made. Thereafter, lunch was arranged. Hence this affidavit.
Problem here is, in addition to this one, the marriage is registered.
Yes, your lord.
So there is a presumption.
Your lordships,
The
though we,
marriage is registered.
yes, your lordships. In fact, the registration of marriage was not known to the appellant herself, your lordship.
Can't go on saying that I didn't know. The Purohit who conducted the marriage has spoken in the witness box. Now, to counter that, you are now saying, no, rituals are not followed.
Your lordships, in fact, it is not.
Now, in addition, the marriage has been registered. There is a presumption drop because it's a legal document.
It is only a registration, your lordship. Marriage has not been performed.
There are two types of registration permissible, which is recognized in law. One is after the marriage conducted, it can be registered. That is one way of getting the marriage registered.
Yes.
The other one is under the Special Marriages Act, you make an application to the sub-registrar asking for the conducting of the marriage in the presence of the sub-registrar. That is not the process followed here.
No,
So this registration certificate that has been issued is legally valid. So therefore, there is a presumption
Your Lordship,
that a registration of the marriage has taken place in accordance with law. How will you get over this?
Your Lordships, that registration of marriage itself has been challenged, Your Lordships, on the ground of fraud and Your Lordships, blackmail, Your Lordship. That is the contention which she has taken.
What is the prayer in the petition?
Yes. It is therefore it is prayed to allow this petition by dissolving the marriage of the petitioner with the respondent, alleged to be taken place on 30.
ಯಾವ್ದು ಇದು 19 of 2020,
Yes, OS 19 of 2020.
19 of 2020.
Yes.
Yes,
Therefore, it is prayed to allow this petition.
to decree the suit of the plaintiff as against the defendant as under.
Yes, Your Lord.
Huh?
Yes, Your Lord.
Hold it. It is therefore prayed that the honorable court be pleased to decree the suit of the plaintiff as against the defendant as under. ಅದೇನಾ ಬೇರೆನಾ ಇದು?
ಬೇರೆ ಇದೆ sir.
ಅದೇ ತಾನೆ? Plaint.
Yes, Your Lord.
19 of 2020 ತಾನೆ?
Yes, Your Lord. 19 of 2020.
19 of 2020.
Correct ತಾನೆ?
Oh, yes, declaration,
Ah.
suit for to declare that the marriage is illegal, wrong and void.
Your Lordship, I have another copy.
OS 90 of 20.
19.
ಹೌದು.
19 of
OS 19 for 2020. ಅದೇ
prayer. The rituals were conducted on 36 2017.
As per this,
Rituals
Yes, yes, ma'am.
were conducted in the
In the temple,
on 36.
30th,
When was the certificate of marriage issued?
Your Lordship,
in
sir,
October,
October.
October,
June ನಾಗ್ ಆಗಿರೋದು.
after performing the marriage. 13/10/2000.
Date ಆಯ್ತು.
ಎರಡು ಮಿಕ್ಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಲ್ರಿ in your prayer. You have not sought, you have not challenged the memorandum of registration of marriage.
ಇಲ್ಲ, again.
Though you have stated, there is no date.
date of registration of marriage as well.
Please see, please see your prayer.
Yes, it be declared that the marriage dated 30th
17.
as performed between plaintiff and defendant as per memorandum of marriage submitted before the sub-registrar. Kalaburagi is wrong and illegal and void, and there is absolutely no marital relationship between the plaintiff and defendant. A decree for perpetual injunction restraining the defendant to claim as a married husband as against the plaintiff, and as such prohibitory orders may kindly be issued to the defendant restraining him from interfering in any manner in the day-to-day life.
Okay, now prayer number 1 is important.
Yes, sir.
You have sought for a declaration that the marriage conducted on 36 2017
Is wrong and illegal.
is void.
Yes.
Huh?
Yes, your Lord.
What about the memorandum of marriage? You have stated there, but you have not stated the date.
Yes, sir.
Huh?
Memorandum of register we have stated in the prayer, Your Lordship, not mentioned the date.
Therefore, what is the requirement for you to fulfill
Yes, Your Lordship.
for getting a certificate of memorandum of registration of marriage cancelled? You cannot do it. You ಬರ್ದೇ ಇದ್ರೆ he will not register. ಹೌದು, ಮಾಡೋದಿಲ್ಲ. ಅದೇ, all that should have been done by the appellant. You are seeking declaration. You should have undertaken all this exercise. You should have examined the sub-registrar.
And in fact, pleading has been taken.
Not in fact denying that you did go before the sub-registrar. Have you denied that you have not even gone before the sub-registrar?
Your Lordships, under Your Lordships, under the toxication of some Your Lordships medicines, I have been taken ಅಂತ ತಗೊಂಡಿದ್ದೆ ಸ್ವಾಮಿ, ಅದು ಬಿಟ್ರೆ.
ಹೆಂಗಿದೆ? Intoxication ಅಂದ್ರೆ she will not be able to get up and walk.
That is the contention which she has taken, Your Lordships.
So the burden is heavily on you.
In fact, with regard to date of marriage, Your Lordships, now they have come with the contention that Your Lordships, in the month of June, the marriage has been performed. Whereas in the month of June, Your Lordships, marriage has been performed. Whereas in the previous petition, for restitution of conjugal rights, they have stated that Your Lordships, marriage has been performed in the month of October 2017.
October.
ಹೌದು.
ಹಾ.
ಇಲ್ಲಿ ಬಂದು ಹೇಳಿದಾಗ 30th June ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಹಾ.
For that reason, Your Lordships, we have taken that date as in the prayer. Also, we have mentioned the same date.
ಎಲ್ಲಿದೆ? Where is it?
Your Lordships, it is reflected in the judgment, Your Lord.
Huh?
It is reflected in the judgment, Exhibit P3.
October ಅಂತ.
13, he got married, registered with petitioner on 13/10/2017.
That is.
Even, Your Lordships, the date of institution of the petition is on 20th/7/2018. And he has stated that Your Lordships, petitioner is married with one Deepika about 7 months back.
That cannot, it may be a general statement without giving the date. Now they have given the date specifically. And the Purohit has said, yes, I have conducted the marriage on that day.
Your Lordships, cross-examination of the Purohit if permitted to read.
The burden falls heavily since the marriage has been registered.
Yes, sir.
You have to get over such registration of marriage. Then it will become all the more difficult for you.
Your Lordships,
Like the other cases where the contention is that marriage took place in the temple. Now, since the marriage is registered, and that cannot be done without the presence of the appellant.
there is a photograph, Your Lordships, and a signature in the memorandum of.
Register signature ತಗೊಂಡಿರ್ತಾರೆ.
It is forcible ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. Forcible ಅಂತ ಹೇಳಿದ್ದಾರೆ. She has not even led a single day, Your Lordships, married life. She has not led a married life even for a single day. Even there is an observation in your lordships, by the family court in the previous proceedings, that it is a forcible, your lordships. That observation has never been challenged by the other side.
Now, whether that finding would become binding in a suit where you are seeking such a declaration.
That in fact, even with regard to your lordship's performance of marriage, also there is an observation that it shows that marriage has not been performed. Though it is not a definite finding your lordships, in the previous proceedings, it has been.
How far is it binding now? That was a petition for restitution of conjugal rights. Therefore, what is the law?
ಇದು ಒರಿಜಿನಲ್
ಈ-
ಸೂಟ್
Wife.
ಯಾರು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದು ಒರಿಜಿನಲ್ ಸೂಟ್
ಯಾವ್ದು restitution of conjugal rights ಅಲ್ಲ
ಅಲ್ಲ
earlier
Divorce petition ಅಲ್ಲೇ. Divorce petition.
ಬೈ ವೈಫ್
Wife.
See, earlier filed,
ವೇರ್ ಇಸ್ ದಟ್ ಪಿಟಿಷನ್
Exhibit P5, your lordships.
MC 63/2019.
exhibit
P5. P5.
MC number
63/2019.
63/2019.
Under section 13(1)(1)A of Hindu Marriage Act. 1(1)A, small a. Seeking divorce on the ground of cruelty. That was dismissed.
Where is that observation?
Observation with regard to your lordship.
The petitioner ought to have got filed a suit against respondent seeking to declare a marriage with respondent as null and void, but not filed the suit in the present form.
Present.
So although the petition was filed under
Section 13.
section 13, your contention was there is no marriage.
No marriage at all. She has
Therefore, this finding is given.
yes, yes. Consistently, she has taken the same, your lordship's pleading, even before the divorce petition and in this. With regard to veracity of the evidence of the praised, your lordship.
Yes.
With regard to veracity of the praised DW3, in the cross examination, your lordship, if I are permitted to read. 30/6/2022 ಮಧ್ಯಾಹ್ನ 12:20 ಗಂಟೆಗೆ ಅಕ್ಷತೆ ಸಮಾರಂಭ ನಡೆಯಿತು. ಈ ವಿಚಾರವನ್ನು ನನ್ನ ಪ್ರಮಾಣ ಪತ್ರ ಮೂವತ್ತು 6/2017 ಮಧ್ಯಾಹ್ನ 12:20 ಗಂಟೆಗೆ ಅಕ್ಷತೆ ಸಮಾರಂಭ ನಡೆಯಿತು. ಈ ವಿಚಾರ ನನ್ನ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಹೇಳಿಲ್ಲ. ದೇವರ ಅಕ್ಷತೆ ಬೆಳಗ್ಗೆ 6:30ರಿಂದ 10 ಗಂಟೆಯವರೆಗೆ ನಡೆಯಿತು. ಈ ವಿಚಾರವನ್ನು ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಬರೆಸಿಲ್ಲ. ವಿಕಾಸ್ ಮತ್ತು ಆತನ ಸ್ನೇಹಿತರು 2 ದಿವಸ ಮುಂಚೆ ಬಂದು 30/6/2017 ಅಕ್ಷತೆ ಹಾಕಲು ಬರಬೇಕೆಂದು ಹೇಳಿದರು. ಅವರು ಯಾವತ್ತು ಬಂದಿದ್ದರು ಎಂದು ನಾನು ನನ್ನ ಡೈರಿಯಲ್ಲಿ ಬರೆದುಕೊಂಡಿಲ್ಲ. ನನ್ನ ಲೆಟರ್ ಪ್ಯಾಡ್ ಇರುವುದಿಲ್ಲ. ವಧುವರರ ಮಾಹಿತಿ ಕೇಂದ್ರ ಇರುತ್ತದೆ. ಈ ರೀತಿ ಲಗ್ನಗಳನ್ನು ಮಾಡುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸಾಕ್ಷಿಯು ಕರೆದಾಗ ಹೋಗುತ್ತೇನೆ. ಕಳೆದ 18 ವರ್ಷಗಳಿಂದ ಮಾಡುತ್ತಿದ್ದೇನೆ ಎನ್ನುತ್ತಾರೆ. ಸುಮಾರು ಇಂತಹ 10-15 ಮದುವೆಗಳು ಮಾಡಿಸಿದ್ದೇನೆ. ಮದುವೆ ಮಾಡಿಸಿದ ಬಗ್ಗೆ ವಧುಮಕ್ಕಳ ಜೊತೆ ನಿಂತು ಫೋಟೋ ತೆಗೆಸಿದ್ದೀನಾ ಅಂದರೆ ನೆನಪಿಲ್ಲ. ಅದನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದೇನಾ ಎಂಬುದು ಗೊತ್ತಿಲ್ಲ. ಮದುವೆ ಸಮಯದಲ್ಲಿ ಮಂತ್ರ ಉಚ್ಚಾರಣೆ ಮಾಡಿ ನಂತರ ಅಕ್ಷತೆ ಹಾಕಿಸಿರುತ್ತೇನೆ. ಯಾವ ಮಂತ್ರ ಎಂದು ಕೇಳಿದಾಗ ಸಾಕ್ಷಿಯ ಮಂತ್ರವನ್ನು ಹೇಳಿರುತ್ತಾರೆ. ಯಾವ ದಿವಸ ಎನ್ನುವುದು ನೆನಪಿಲ್ಲ. ಅಕ್ಷತೆಯ ಮೇಲೆ ರೂಪಾಯಿ 1100 2100 ಕಾಣಿಕೆ ಕೊಟ್ಟರು. ಈ ವಿಚಾರವನ್ನು ನನ್ನ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಬರೆಸಿಲ್ಲ. ನನಗೆ ಹುಡುಗನ ಕಡೆಯಿಂದ ಲಗ್ನ ಪತ್ರಿಕೆ ಕೊಟ್ಟಿಲ್ಲ. ಆ ಕಾರ್ಯಕ್ರಮದ ಫೋಟೋ ತೆಗೆದಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ನನ್ನ ಫೋಟೋ ಬಂದಿರುತ್ತದೆ. ಅದನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದಾರೆ ಎಂದು ಸಾಕ್ಷಿ ಅದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎನ್ನುತ್ತಾರೆ. ನಾನು ನನ್ನ ಆಧಾರ್ ಕಾರ್ಡ್ ಅನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಕೊಟ್ಟಿಲ್ಲ. ಸ್ವಾಮಿಗಳ ವೇಷಭೂಷಣ ಬೇರೆ ಇರುತ್ತದೆ ಎಂದರೆ ಸರಿ. ನಾನು ಸ್ವಾಮಿ ಅಲ್ಲ. ನನಗೆ ಯಾವುದೇ ಲಗ್ನ ಮಾಡಲು ಬರೋದಿಲ್ಲ. ಯಾವುದೇ ಲಗ್ನ ಕೂಡ ಮಾಡಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನಗೆ ಸಾಕ್ಷಿ ನುಡಿಯಲು ಎಷ್ಟು ಹಣ ಕೊಡ್ತಾರೆ ಎಂದರೆ ಹಣ ಕೊಟ್ಟಿಲ್ಲ ಎನ್ನುತ್ತಾರೆ. ನಾನು ಮದುವೆ ಮಾಡಿಸಿದ್ದೇನೆಂದು ಸಾಕ್ಷಿ ನುಡಿಯಲು ಬಂದಿರುತ್ತೇನೆ ಎನ್ನುತ್ತಾರೆ. ನಾನು ಅವರು ಮದುವೆ ಮಾಡಿಲ್ಲ ಎದುರುದಾರರ ಮಾತು ಕೇಳಿಕೊಂಡು ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಿದ್ದೇನೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್, the date of marriage and the information with regard to performance of marriage as informed by the alleged two friends of the respondents, even that date is also not mentioned. There is no document, your lordships, to show that on that date the marriage was performed, apart from the statement of this priest. There is no marriage performed, your lordships. There is a certificate of registration.
At the cost of petition.
Yes, yes,
Yes,
I understand, your lordship.
That since the marriage has been registered, that was more difficult for you to prove that no, the marriage itself has not taken place.
Under the Hindu, your lordships, the registration of marriage, the ceremonies and your lordships, though I have not taken that specific contention, your lordships, the performance of ceremonies and rituals are holds, your lordships, higher than the registration of the marriage, your lordships. Unless those conditions are satisfied, your lordships, registrations will, your lordships, not override the ceremonies and rituals.
It only shows the acceptance of you regarding marriage, and that you went before the sub-registrar and they said, yes, our marriage has been performed, kindly register it. It has been registered. How do you overcome all this?
These are the only pleadings which they have taken, your lordships, and the observation in the previous projects, that's all we have produced.
You have to make such allegation in respect of registration of memorandum of marriage, then it will be too difficult. How do you allege fraud in respect of the registration of the marriage?
Forcibly ತಗೊಂಡೋಗಿದ್ದಾರೆ ಅಂತ ಅಷ್ಟೇ. That is the only pleading.
Not before the sub-registrar.
In the evidence, she has stated that, your lordships, for the purpose of 371J certificate, she has taken her. And thereafter, your lordships, they got to know that the certificate.
371 J ಗೆ ಯಾರು sub-registrar
ಇಲ್ಲ.
ಆರ ಬದಲಾಯಿಸ್ಬೇಕು.
ಅಲ್ಲ, ಇವರು ಹೇಳಿದ್ದು ಇವನ್
Why we told that girl it will be very difficult on the merits of the matter. He is not able to understand.
Yes, sir.
Limitation.
With
Declaration.
1 year, sure.
Within 3 years.
Yes, sir. 2019 is the petition, your lordships, for divorce was filed. 2019, your lordship.
1 year or 3 years? 1 year. 1 year.
1 year. For the
Limitation.
for seeking declaration.
Other declaration 59 ಪ್ರಕಾರ general class 3
3 years.
ಇದಕ್ಕೆ 1 year. ಇದರಲ್ಲಿ
Section 12 ಅಲ್ಲಿ, your lordships, it is, if we are saying that the customs and rituals are,
ಬರ್ತದೆ 1 year. But within 1 year you have not filed a suit.
your lordships, we have filed a petition. Instead of filing this suit, we have filed petition under section, your lordships, 13. After that, we have filed this present petition.
Linear, section 12.
Hmm.
It is also observed by the,
Section
Family court.
12,
there is 1 year.
the petition is presented more than 1 year after the force had ceased to operate.
Section 12 of the marriage act.
In the marriage.
Really. ಇದು ಜನರಲ್ ಇದರಲ್ಲಿ 3 years, ಇದಕ್ಕೆ 1 year.
ಹೌದು.
Within 1 year you have not filed suit.
Your Lordship, 2019 ಅಲ್ಲೇ ನಾವು ಇದು ಹಾಕೊಂಡಿದ್ದೀವಿ, seeking divorce.
Divorce, you have admitted that there is a relationship between us.
That is the observation made in this. In fact, even in that divorce petition also, we have stated that marriage has not been performed. For that reason, it has been dismissed, and thereafter we have filed the present suit.
That limitation cannot be excluded.
Hmm.
For purpose of calculation of limitation, to file a suit for declaration on voidable marriage.
On annulling a marriage. On the grounds specified in clause C of subsection 1, shall be entertained if the petition is presented more than 1 year
1 year.
after the
Marriage.
force to operate. Or as the case may be, the fraud had been discovered. After the force has ceased to operate. It's also a finding given against you.
Yes.
Huh?
Yes, Your Lordship. Your Lordships, now marriage has not been performed, Your Lordship. She is not ready to live with him. She has not led a single day, Your Lordships, of marital life with him. She has filed a divorce that has been dismissed, Your Lordships, on the ground that she has taken a contention that marriage itself is not performed. She is left with no other option but to file a suit, Your Lordship. In fact, the knowledge of registration was made known to her after the notice was received seeking conjugal rights. First, a petition for restitution of conjugal rights was filed. After receipt of notice, Your Lordship, she has filed the petition for divorce.
When?
2019, Your Lordship. 19. 2018 is the date of your year in which restitution of conjugal rights was filed by him. After receipt of notice, she has filed the suit for divorce. She was not aware. Notice.
Alinda 1 year.
1 year. 2019, we have filed, Your Lordship. Immediately we have filed. Divorcing. Divorce.
Ground of cruelty.
Ground of cruelty. Your Lordships.
This was filed in the year 2020.
Yes, Your Lordship. 20.
20.
Immediately after disposal, Your Lordship. 2020.
cannot make the same allegations regarding the cause of action, since there is a registration certificate of the year 2017, October 2017.
17.
Then let's go to the reasoning part of the impugned order.
Yes, sir. From para 8, page 16, Your Lordship. Paragraph 8, page number 16 of my appeal memo, internal page 7.
Yes.
These issues are interlinked with each other. Hence, I have taken up these issues together for discussion in order to avoid the repetition of the evidence and facts. Herein the fact that earlier defendant filed petition for restoration of conjugal rights against this plaintiff, and the plaintiff filed petition for divorce against the defendant, and both petitions were dismissed are all admitted facts. The case of the plaintiff that no marriage had taken place between her and the defendant on 30th/6/2017. They are not wife and husband. There is no marital relationship between them and defendant on 13/10/2017. By playing fraud, misrepresentation and coercion, took her to the sub-registrar office Kalaburagi, obtained her signature forcibly on declaration form, which is memorandum of marriage, and manipulated the joint photos affixed on the memorandum of marriage with an intention to declare that she is legally wedded wife, and the marriage date is wrongly shown as 30th/6/2017. Though no marriage has taken place on that day, and the persons who signed as guardian of the plaintiff are all friends and relatives of the defendant, and also the petition filed by the defendant for restoration of conjugal rights, wherein this court has observed that the marriage has not been taken place. There is no relationship between them as husband and wife, and she wrongly filed petition for divorce in MC number 190 of 2018 instead of filing suit for declaration. Per contra, the defendant contended that they fell in love and got married on 30th/6/2017 at Ramtit Temple, Kalaburagi, and when the plaintiff filed petition for divorce, admitting her relationship with defendant as her husband, she cannot contend that there is no marital relationship between them, and he played fraud on her to get registered the marriage. PW1 deposed on par with governments in her affidavit of chief examination. In the course of cross-examination, she denied that their marriage had taken place on 30th/6/2017. But when it was suggested that to her that it was performed at Ramtit Mandi Kalaburagi, she deposed that it is forcible marriage. These evidence falsify her contention that no marriage had taken place on 30th/6/2017. And the date of marriage shown in the memorandum of marriage is wrong and illegal. And on 13/10/2017, by playing fraud, her signature was obtained in the office of sub-registrar of marriage, Kalaburagi. She further deposed that she has not lodged any complaint against the defendant for alleged force, coercion, and threat by the defendant to register said marriage in the office of sub-registrar. If really the said marriage was registered forcibly in the office of sub-registrar of marriage by playing fraud and misrepresentation, she would have lodged a complaint, but she has not lodged any complaint. It also falsifies that the defendant had played fraud, misrepresentation, and coercion and got registered the marriage. She admitted that she filed petition for divorce. In the cost title, she has shown defendant name as her husband, and in the affidavit for chief examination, in that case also she has shown defendant as her husband. Herein, she has produced exhibit P3, certified copy of judgment in MC number 190 of 2016, filed by this defendant against the plaintiff for restoration of conjugal rights, wherein the defendant herein contend that their marriage was taken place about 7 months back, and it was registered on 13/10/2016 in the office of registrar of marriage, sub-registrar Kalaburagi. The plaintiff, being respondent in that case, denied the said allegation and also contended that said marriage was got registered forcibly, and he made her unconscious by administering sleeping pills in cool drinks, and he got snapped her so and so photos and blackmailed and performed registered marriage. If her contention is true, she would have lodged complaint. Admittedly, till filing petition for divorce in MC number 63 of 2019, she has not lodged any complaint against the defendant. It is sufficient to say that her contention that it is forcible marriage. Further, exhibit P3 reveals that it is observed therein that if really the plaintiff herein has married to defendant, what was the reason for her to refuse to join the company of the petitioner after 1 day of their marriage? That shows that registered marriage was forcibly made. Of course, the defendant had not challenged this order judgment. Exhibit P4 reveals that plaintiff filed a petition for divorce after defendant filing petition for restoration of conjugal rights as per exhibit P3, and both cases are disposed of on 6/3/2020. On going through the exhibit P5, it is seen that she had taken very same contention in this plaint also. The said case was also disposed of on merits after contest by the defendant. In that petition, it is described that she is the wife of Vikas. Of course, nobody can put the name of stranger as a husband unless there is a marital relationship. But merely because of that, it cannot be said that she has admitted the marriage. On the other hand, petition averment revealed that she had disputed marriage. Said suit was dismissed on the ground that when she has claimed that the marriage is forcible marriage and also sought for divorce on the ground the petition under section 13(1)(a) is not maintainable. It is a plaintiff who has to prove that no marriage had taken place on 30th/6/2017 and registered their marriage on 13/10/2016 as forcible one. As discussed above, if really there was a force, fraud, or coercion on the part of the defendant, the registered marriage, she would have lodged complaint to the police immediately. It is not her case that she is not aware about the registration of the marriage, but according to her, by playing fraud, it is got registered. When she had knowledge that said marriage is forcible one, what prevented her to take action has not been explained either in this case or in the petition filed by the defendant for restriction of conjugal rights or petition filed by her for divorce. The defendant in his chief examination deposed on par with written statement averments. In the course of cross-examination, he deposed that marriage was performed on 30th/6/2017 at Ramdev Temple, Kalaburagi. At the time, they followed the rituals. I'll skip the your lordship, sir. Apart from this oral evidence, he examined one Gorakhnath RW2. He deposed that he was invited for the marriage of plaintiff and defendant. He attended the marriage on 30th/6/2017, solemnized on Ramdev Temple, Anand Road, Kalaburagi. Said marriage was performed by following the rituals of their customs. In the course of cross-examination, he also deposed as under. He also examined DW3 Rajshekhar, who said to be the priest of their marriage. He deposed that he was called by the defendant to perform his marriage as priest, and he performed the marriage of defendant with plaintiff on 30th/6/2017 at Ramdev Temple, Anand Road, Kalaburagi. And religious customs were followed in the marriage. Both took bath in the morning, and thereafter Aarti was made and sacred fire was lit, and bride was asked to wear ring, anklet, and bangles, and kumkum was put upon her forehead. And thereafter, chanting mantras, Mangal Sutra was tied by the defendant to the plaintiff, and thereafter Akshata was performed for all the religious and customary rituals were followed. In the cross-examination, he deposed that Akshata function was performed at 12:20 p.m. on 30th/6/2017, and the defendant along with his friends came to the temple 2 days earlier, asked him to perform the marriage on 30th/6/2017. He is doing priest work since 18 years. He was priest in about 10 to 15 marriages. He remember whether he had taken the photos with the bride and bridegroom. He further deposes that at the time of marriage, he chanted mantras. When it was questioned him which mantra he chanted the mantra in open court. He also stated that they gave 2100 to him. Marriage card was not given. Marriage photo were taken by them. He admitted that Swamiji are wearing different dresses, but he denied that he is not Swami. He does not know ceremonies of marriage and he has not performed any marriage. In the course of cross-examination, nothing is elicited why he can depose false against the plaintiff. Though the plaintiff has contended that no marriage has taken place, nowhere she has stated how she acquainted with the defendant. Unless she was known to the defendant, it is highly impossible for him to take her to the sub-registrar office forcibly. He has produced exhibit R3, total 7 photos, wherein they both found closely, and in other words, she appears in APM. In the course of cross-examination of DW1, it is suggested that it is edited photos. On going through these photos, it does not show that it is edited photo. In the course of cross-examination DW1, it is suggested that his house was near so and so, and plaintiff house was also there and near the house of plaintiff. Of his uncle so and so was also there and is unmarried. He used to visit the house of said so and so. So he came into acquaintance with plaintiff and said so and so. And brother of plaintiff were friends. Because of that, he used to visit the house of the plaintiff, and whenever the mother of plaintiff went to her duty and her father was also not in the house, he used to visit the house of the plaintiff. This suggestion goes to show that plaintiff and defendant were known to each other. When it was suggested him that while going, he was taking juice and other items to her, he deposed that if she has asked him to drink it, he was taking. He denied that he was administered sipping pills in the juice to her and got her conscious at the time he used to take her so and so. And later he was threatening her of loading so and so if she does not manage. Herein it is not the case of the plaintiff that the defendant used to visit his uncle's house, which is situated near the house of her parents, and met her occasionally with malafide intention to marry her. And he used to serve cold drinks to her and putting tablets in the cold drinks in order to get her unconscious and made her to drink the same. And when she became unconscious, he used to so and so and forcing her to marry him. Further, it is not stated in her affidavit for chief examination also. When such being the fact, any amount of evidence cannot be considered. Of course, in the petition filed for her for divorce, as found exhibit P5, all these facts has been narrated. but that cannot be considered in this case. On the other hand, on going through the cross-examination of RW1, as discussed above, it is very clear that plaintiff was acquainted with the defendant prior to the marriage. They were more close and each other. The cross-examination of RW1 as discussed above sufficient to say that the photos produced by him were taken when they met each other. Further, in the course of cross-examination of DW1, it is suggested that she refused to marry him, saying that she belongs to Jangam caste and he belongs to so and so caste, and used to threaten her, saying that if she did not marry him, he will die by leaving death note against her and her mother, and also threatened her of taking her life. Because of that, she has not lodged any complaint before police. These facts are also not stated in the plaint. So the reason given by the plaintiff for non-lodging complaint against defendant cannot be accepted. But it appears that it is a creation of the learned counsel for the plaintiff to come out from the consequences of non-lodging complaint immediately against the defendant. DW1 further deposed that after the marriage, she stayed with him for about 15 days. Thereafter, she was used to go to her parental house and also coming back. These cannot be accepted because in this petition, for restitution of conjugal rights, he stated that after the marriage, they led married life only for 1 day. Even in the course of cross-examination of RW2, nothing is elicited to say why he can depose false against the plaintiff. Of course, the defendant has not produced any photos or receipt issued by the temple authority about the performance of their marriage in the temple. But in the course of cross-examination, he deposed that the receipt issued by the temple is with the plaintiff. He also stated that all the photos were taken in the mobile of the plaintiff, so it is with them. Herein, it is very pertinent to note that though there is no pleading, it is suggested to RW1 that brother of plaintiff and uncle of defendant were friends. Because of that, the defendant came into acquaintance of the plaintiff and also used to visit the house of plaintiff. And such being the fact, what prevented the plaintiff to examine his brother? If her brother is examined, truth would have come out whether it is forcible marriage and the defendant had played fraud on the plaintiff. But she has examined her mother, who deposed repeating the plaint of amendments in her affidavit for chief examination. In the course of cross-examination, she deposed that she does not know that the marriage of the plaintiff had taken place with defendant. It shows that her ignorance. If really marriage had taken place, she would have denied it. Even nowhere she has stated when they come to know that the defendant played fraud and got registered marriage and obtained the signature of the plaintiff in the declaration form. So her evidence did not help the plaintiff to prove her case. Further, PW3 deposed that by playing fraud, the defendant on 13/10/2017 took the plaintiff to the register office. They manipulated their joint photos and affixed on memorandum of marriage. But nowhere he has stated how he came to know, when he came to know the same. He deposed as if she is aware of the same. So his evidence also do not help the plaintiff to prove the case. Further, she has not examined the officer who has registered the marriage. As discussed about, DW3 was the priest of the temple, deposed how he performed the marriage, what rituals he had followed. If the marriage is arranged by the parents, relatives, and well-wishers of both the parties, one can expect all the rituals are to be followed. But when two young, odd-blooded teenagers fell into love and decided to marry, it is odd to believe that they will marry each other by following all the rituals and rites. Even most of the marriages are being done by exchanging garlands, tying tamarind piece and thread as a tali. So in such circumstances, one cannot expect observing all the rituals of the marriage followed in arranged marriage. On going through the evidence of PW3, I do not find any reasons to say that no such marriage has taken place. On the other hand, when the plaintiff kept quiet till the defendant filed petition for restoration of conjugal rights, and she has not lodged any complaint against the alleged fraud, which shows that they have married in temple. Later, it was registered in the office of sub-registrar. It is not the case of the plaintiff that their marriage has not been performed in accordance with the customary rites and ceremonies. If her contention that her marriage has not been performed with customary rituals, on that ground she seeks for nullity of marriage, the matter would have been different. But it is not her such case. Herein it is very pertinent to note that prayer itself is very vague. She has sought for declaration to declare that marriage date shown as so and so in the memorandum of marriage as date of marriage performed between them is void. She has not sought for declaration to declare that her marriage is void and illegal. If according to her the marriage date is wrong, which is her marriage date itself shows that she has admitted that she married the defendant. So the relief sought by her cannot be granted and marriage cannot be declared as null and void. Section 12(1) of Hindu Marriage Act reads as thus. Para 29 unit. On plain reading of section 12(1), it can be said that on the grounds mentioned therein, the marriage can be declared as void. Herein, none of the ground mentioned in the petition comes under ground mentioned in section 12(1). Paragraph 30 unit. So it is very clear that even to claim relief under section 12(2)(1), the parties has to present the petition within the period of 1 year after the force had ceased to operate or fraud has been discovered. Herein, on going through the plaint of amendments, corroborated by evidence of plaintiff and witness, it is very clear that plaintiff was aware about the alleged fraud on 13/10/2017 itself. She would have filed suit on or before 13/10/2018. Of course, she filed a petition for divorce on the same ground in MC number 1 and 2019 as per exhibit P5 and 6, but that petition was also was not filed within 1 year. So even if it is assumed that defendant had played fraud on her and got registered marriage, she has not filed suit within the period of 1 year. Therefore, I hold that plaintiff has failed to prove that her marriage dated so and so is wrong and it is void marriage. On the other hand, it is proved that they married in the Ramti temple on so and so and got registered the same in the office of sub-registrar on so and so. In view of this, I answer the issue number 1 in the negative and issue number 2 in the affirmative.
What are the grounds that you have raised in the suit?
Yes, sir. Paragraph 3, your lordships. It is submitted that defendant on 13/10/2017 by playing fraud, misrepresentation and coercion to the plaintiff, to the sub-registrar Kalaburagi, and obtained the signature of the plaintiff forcibly on the declaration form of memorandum of marriage. The joint photo affixed on the said memorandum of marriage is totally manipulated with the intention to declare that the plaintiff is the married wife of the defendant. The date of marriage shown in the said memorandum of marriage as 36/2017 is totally wrong and illegal. The signatures obtained by the defendant as guardian on behalf of the plaintiffs are all relatives and friends of defendant. There is no signature of the parents of the plaintiff on the said memorandum of marriage. Therefore, the very memorandum of marriage submitted before the sub-registrar Kalaburagi is wrong and not a valid document. The marriage is not performed between the plaintiff and defendant as per customs and usages. Therefore, the marriage as claimed by the defendant as against the plaintiff is totally void marriage under the provisions of the Hindu Marriage Act. It is submitted that the defendant approached to this honorable court by the petition under section 9 of the Hindu Marriage Act in MC number 190 of 2018, contending that the marriage was performed on 13/10/2017 and that the defendant has stated in the said petition that he led married life for 1 day. The said petition for restoration of conjugal rights submitted by the defendant was rejected by this honorable court as per order dated 6/3/2020. This honorable court has elaborately discussed and made observation in the judgment, which is reproduced as under. The document exhibit P1 marriage certificate reveals that the petitioner and respondent had got performed a registered marriage, and the exhibit P30 in which the petitioner and respondent appearing jointly having garlands in their neck. But only on the basis of exhibit P1 and 3, it cannot be said that respondent has joined the company of petition and they led married life, and petitioner is entitled to seek for the company of respondent to seek conjugal life with respondent. Under the circumstances, I am of the opinion that when the parties have not at all led matrimonial life and no marriage was consummated between the parties, then the question of respondent voluntarily leaving the house of the petitioner does not arise at all. Hence, I answer the point number 1 in the negative. The judgment passed by this honorable court in MC number 190 of 2018, dated 6/3/2020, has not been challenged by the respondent. It is binding on the respondent. It has been clearly observed and held that
We can do is we can see what are the grounds raised to attract the provisions of section 12. You please point out what are the grounds raised in terms of section 12.
yes, your lords.
And what evidence has been led by the plaintiff to prove that. You please see section 12, which has been extracted in page number
Yes, sir.
35. We saw one sentence where she said no rituals.
Customs and usages are performed. Yes, your lord. Yes, your lord.
On ground raised.
Yes, sir. Voidable marriages. Any marriage solemnized, whether before or after the commencement of this act, shall be voidable and may be annulled by a decree of nullity on any one of the following grounds, namely, that the marriage has not been consummated owing to the importance of the respondent.
This is also one ground that you have raised.
Importance we have not taken. We have not taken.
So it has to be only on the ground of importance.
One, your lordship. That is one.
1 year.
And B, your lordship, that the marriage is in contravention of conditions specified in clause 2 of section 5, or that the consent of the petitioner or whether the consent of the guardian in marriage of the petitioner was required.
Barang- Child
Clause
marriage.
2 of Section 5.
Yes.
The time of marriage,
Neither,
neither party is incapable of giving a valid consent to it. Huh?
yes, your lordship, to it in consequence.
Consequence of unsoundness of mind. Though capable of giving valid consent, has been suffering from mental disorder. Has been subject to recurrent attacks of insanity. ಯಾವುದು ಬರೋದಿಲ್ಲ.
ಇಲ್ಲ, ಅದನ್ನು ಬರೋದು,
ಯಾವ್ದು ಬರೋದು?
ಇದನ್ನು ಬರೋದು. That the consent of the petitioner or whether the consent of the guardian in marriage of the petition, ಇದನ್ನು ಬರೋದು. That the respondent was at the time of marriage, ಅದನ್ನು ಬರೋದು. 12(2),
So ಇಷ್ಟೇ, these are the only grounds.
yes,
Huh?
yes, your lordship.
Longer, which is the ground?
Section 7, if I am permitted to read you.
Huh?
Section 7.
Yes.
Ceremonies of Hindu marriage, your lordship. A Hindu marriage may be solemnized in accordance with the customary rites and ceremonies of either party thereto, where such rites and ceremonies included the Saptapadi, that is the taking of 7 steps by the bridegroom and the bride jointly before the sacred fire. The marriage becomes complete and binding when the 7th step is taken.
Insofar as this provision is concerned, if it is followed by registration of the marriage in the office of the sub-registrar, what is the position?
Even that has been discussed in that judgment, your lordship, which
Registration of marriage, well, it is only when marriage is solemnized in accordance with Section 7. There can be a marriage registered under Section 8. If there has been no marriage in accordance with Section 7, the registration would not confer legitimacy to the marriage.
marriage. Relevant portion is at your lordship, so page 4. Yes,
So you should have specifically pleaded that in your custom, now the problem is that both of them belong to different castes.
yes, sir.
Both
So-
are Hindus.
Huh?
Both are Hindus.
But both,
It's all right. See, even amongst Hindus, that is why the provision itself says. Provision itself. Therefore, a specific plea had to be raised by the plaintiff.
Yes, which are the customs.
Here again, the problem is they come from two different castes.
yes, your lord.
So therefore, if in one community, this requirement of Saptapadi is there, and in the other one it is not there, then what should happen? And of course, you have not pleaded. There is no specific pleading. Despite the fact that you have raised a contention that all the required customs and rituals were not
Followed, your lordship.
followed.
Yes,
You are not specific. That you could have at least led stated during your
Yes.
examination in chief. Adunu madilla. Now, how can you place reliance on this statement? When there is no basic pleading that yes, in according to your custom, Saptapadi was the requirement.
I ought to, your lordships, let the evidence of
Summary rites and ceremonies of either party. So at least,
ಒಬ್ರಲ್ಲಿದ್ರು ಆಗುತ್ತೆ.
the burden was on you to say that according to your customs, Saptapadi was the requirement without which there
Marriage will
cannot
not-
be a marriage.
Marriage.
You have not raised that contention.
Specific pleading, I have not taken. In the previous proceedings, your lordships.
Basically, marriage is actually not conducted. Only for the purpose of securing visa.
It is mutual consent.
Okay.
Yes, yes.
They simply made this
Registration of marriage.
registration. That is not the case here.
Your lordships, in this case, in fact, it is a state.
You are required to plead and prove that your customs required the saptapadi or these rituals, and they were not performed, and therefore there is no valid marriage. Unless you specifically plead and prove, you will not be able to take advantage of this judgment. 142 period. Adunu avaru they filed a joint
Mutual consent.
application. It is actually by mutual consent.
Yes, yes.
But the Supreme Court thought it fit to make certain observations.
Yes, your lordship. But if Saptabadi is a mandatory ceremony, your lordships,
Therefore, it was for you to
show
plead
that
and prove.
Saptabadi is part of our ceremony, I was required to plead yours. And one more thing, your lordships, with regard to the petition which was filed by the respondent for restitution of conjugal rights, he has specifically stated that the marriage was held before the sub-registrar. He has not stated anything about your lordship's marriage has been performed in the month of June.
No,
Your lordships, he has stated that in his petition. If I permitted to read paragraph 2, your lordships.
On the time of the first petition that he filed.
Yes.
Allindaanu ಹೇಳಿದ.
ಇಲ್ಲ ಹೇಳಿಲ್ಲ
Marriage
ಸ್ವಾಮಿ.
took place, yes.
ಇಲ್ಲ
He
petition.
has stated that marriage has taken place. Thereafter, it was registered ಅಂತ ಮುಂಚೆನೂ ಹೇಳಿದ್ದಾರೆ.
ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ. ಪೆಟಿಷನ್ ಕಾಪಿನೇ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿಯಲ್ಲಿ ಹೇಳಿಲ್ಲ ಅವರು.
ಎಲ್ಲಾ ಕಡೆನೂ ಹೇಳಿದ್ದಾರೆ ಸರ್. It has come in the judgments also.
ಮುಂಚೆ ಕೇಸಲ್ಲಿ ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ. ನಾನು if I permitted to read the entire petition. Your lordships, unfortunately, that has not been produced before the
ಯಾವ್ದು?
family court. The petition which was filed by the respondent for restitution of conjugal rights.
The order itself it is there.
No, your lordship, with regard to,
ಯಾವ್ದು exhibit?
ಇಲ್ಲ ಅದು ಮಾರ್ಕ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ ಇದು. ಇದು ಮಾರ್ಕ್ ಆಗಿಲ್ಲ.
Judgment.
ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಜಿಸ್ಟ್ ಹೇಳಿದ್ದಾರೆ. ಇದರಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದ್ದಾನೆ ನೀವು. ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಲ್ಲಿ.
Have a copy.
Yes, yes.
Certified copy. But which is that judgment exhibit?
Exhibit P3, your lordship. It is the petition filed by
ಇದೇ
he has not uttered a word with regard to a marriage having performed in a temple.
Huh?
Marriage having performed in a temple before 3 months of the registration, he has not uttered a single word. He has said that your lordship's marriage has been performed before the sub-registrar in that previous proceedings, your lordships.
ಅದ್ರಲ್ಲಿ ಹೇಳಿಲ್ಲ.
It is an important fact, your lordships, which he has admitted, your lordships, in the previous proceeding that the marriage has happened.
It is your suit. You have raised all this,
Yes, I have not taken that specific pleading.
isn't it? Why did you then say there was a marriage that took place?
30th 6 2017.
It was not necessary. You can't wriggle out of that one. You yourself have stated.
As claimed by them, your lordships, it cannot be held that the marriage has taken place on so and so.
So please give a copy of that.
I'll put it. Yes.
ಇಲ್ಲ.
In that petition also, he has produced all the marriage certificate, memorandum of marriage, photos.
In your petition, you have, in your suit, you have stated so.
I have stated that, your lordships, in the certificate of marriage, it is shown as 36/2017.
Ram Tirtha temple then.
Memorandum of marriage ಅಲ್ಲಿ marriage ಆಗಿರೋದು.
ಎರಡು ಡೇಟ್ ಹೇಳಿದಿರಾ, ನೀವೇ ಹೇಳಿದಿರಾ.
ಇಲ್ಲ, memorandum of marriage certificate ಅಲ್ಲಿ date of marriage is shown as 36/2017. For that reason, your lordships, that date has been mentioned. If at all, your lordships, the marriage has been performed on 36/2017, it is an important fact, your lordships. Registration is a subsequent act.
Correct.
That ought to have been, your lordships,
The requirement in terms of section 8. Section 8 makes provision for registration of such marriages.
yes. Yes, but in the previous proceedings, your lordships, he has specifically stated that marriage has been performed before sub-registrar.
Correct.
He has not stated anything of marriage having,
ಇವಾಗ ನೀವೇ ಹೇಳಿದಿರಾ.
your lordships, we have stated that
It is stated in the
memorandum of,
certificate itself.
yes.
And now, as you have pointed out, you have not taken up a specific plea that this was the requirement.
Saptapadi, with regard to requirement of Saptapadi, I have not taken specific pleading, your lordships.
Even in this judgment, it says, if that is the custom required, so the provision itself makes it very clear.
Yes,
So therefore, it was for you to have pleaded and proved. That burden you are not discharged.
yes. Sir. If it could be remanded back to the, your lordships, trial court, I will lead further evidence with regard to that, and your lordships, make an attempt. Because, your lordships, section 12 will not be applicable, your lordships, for the non-compliance of section 7. Because there is no, your lordships, bar to take that ground, your lordship, even after lapse of 1 year. As the
ಒಂದಿದೆ ಇವಾಗ question of limitation that has been pointed out.
limitation will not applicable, your lordships, to take a ground for non-compliance of section 7.
ಇದಲ್ಲ,
No, ಇದೆ.
the petition, the suit itself.
ಇಲ್ಲ, ಸೂಟಿಗ್ ಬಾರ್ ಇಲ್ಲ ಸ್ವಾಮಿ, ಸೂಟಿಗ್ ಬಾರ್ ಇಲ್ಲ. There is no bar. There is 3 years, your lordship. General
No.
for
1 year.
ಇಲ್ಲ 1 year for taking grounds under section 12. If importance, consent, if for those grounds, if I am taking,
Fraud ಇದೆ.
Fraud ಇದೆ.
Fraud ಇದೆ.
Fraud is there.
ಅಲ್ಲ ಅದನ್ನು ಇದೆ, for the purpose of section
Saying the round under section 7.
7, there is no bar, your
That does not come within this prescribed period.
under section 12.
Section 12.
Yes,
ಅದಕ್ಕೆ 3 years ಬೇಕಾಗುತ್ತೆ ಅಂತ.
yes, yes.
Even 3 years has elapsed.
No, your lordship.
Yes.
Very 3 years, 27 days from the date of 36/2017. 3 years, 27 days.
If registration of marriage is taken, your lordships, it would be within 3 years. It is 21 days difference, your lordship. That
ಅಲ್ಲ,
ಅಲ್ಲ.
ಮ್ಯಾರೇಜ್ ಆಗಿರೋದು 36
2017. ನಾವು ಪೆಟಿಷನ್ ಹಾಕಿರೋದು 21/7/2020.
3 ವರ್ಷ 27 ದಿನ.
27 ದಿನ. ಆದ್ರೆ ಅದಕ್ಕೂ ಮುಂಚೆ ನಾವು ಸ್ವಾಮಿ ಬೇರೆ, ಐ ಕ್ಯಾನ್ ಕ್ಲೇಮ್, your lordships, under section 14. Because I previously I have filed a petition under section 13. And after disposal, your lordships, I have filed this petition. It is not that I have not come before the court at all for a period of 3 years.
Section 14.
Yes, your lord, limitation act.
Exclusion of time of proceeding bona fide in court without jurisdiction.
ಅಲ್ಲ, ಅದು ಸೆಕ್ಷನ್ 12 ಬರುತ್ತೆ ಅದು. Exclusion of time in legal proceedings.
ಹಾ.
Section 12 of limitation act.
Yes.
In computing the period of limitation for any suit, the day from which such period is to be reckoned shall be excluded. Section 12 out.
That day, what he's saying is, he had filed a petition earlier, and therefore section 14 would
Yes.
get attracted.
Yes.
Bona fide in court without.
Another civil proceeding,
Yes.
whether in a court of first instance or of appeal or revision against defendant, will be excluded where the proceedings relate to same matter in issue and is prosecuted in good faith in a court which, from defect of jurisdiction or other cause
Yes.
of a like nature,
Yes.
he is unable to entertain it. Yes, what is your
If
submission?
section 14 is applicable, where marriage period minimum 1 year is required. If petition is filed within 1 year, if petition is filed within 1 year,
1 year ಬರಲ್ಲ.
1 year ಒಳಗೆ ಹಾಕ್ಬೇಕಾದ್ರೆ
That
he has
is,
to seek leave.
if you are invoking the grounds under section 12.
ಹೌದು, ನಮ್ದು ಅದರಲ್ಲಿ 1 year ಇದೆ.
That is, if the ground under section 12, what
Yes.
about section 7?
ಅಲ್ಲ ಇಲ್ಲಿ ಯಾವ ಸ್ಟೇಟೆಡ್ ಆಲ್ ದಿ ಮ್ಯಾರೇಜ್ ಏನಾಗಿದೆ ಅಂತ ಹೇಳೇ ಬಿಟ್ಟಿದ್ದಾರೆ ಅವರು. ನಾವು ಚೀಫ್ ನಲ್ಲಿ ಹೇಳಿದ್ವಿ,
But the
ಮ್ಯಾರೇಜ್ ಈ ತರ ಮಾಡಿದ್ರೆ
is
ಕಷ್ಟ-
taken
ಹಾ.
that the customs and rituals that are required to be followed
followed.
is not followed.
It is followed. I have proved.
Contention ತಗೊಂಡಿದ್ದಾರೆ sir,
ಅಲ್ಲ
in terms of section 7.
ಹೌದು.
Contention has been taken in the plaint. So therefore, if there is a ground other than section 12, in fact, on going through section 12, we do not find any ground that would apply in the present facts and circumstances.
Yes.
So what would be attracted is only section 7. Section 7 limitation in.
The limited, he has not taken the ground now.
We will not go into all these aspects.
Yes.
Now his contention is, if that is the only ground,
ಸಪ್ತಪದಿ ಆಗಿಲ್ಲ ಅನ್ನೋದು ಒಂದೇ ಗ್ರೌಂಡ್ ಇದೆ.
and if I have not taken specific grounds, pleaded the specific grounds, please remand the matter for that purpose and tell.
He ought to have taken, because once he has approached the court, now he came to know limitation, all those things will come in.
Huh?
Limitation also come into play now.
We will not go into the question of limitation.
Now we will take the limitation period, because petition, even when he had got the knowledge, from the date onwards, the limitation process will continue.
ಅದಕ್ಕೆ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು, see, this in the impugned order, the court has not considered the fact that earlier a petition was filed, so section 14 gets attracted.
They have to raise the all grounds.
All these grounds can be reconsidered. Along with that, you give me an opportunity to raise a specific plea.
That is correct, man.
So I have stated in the plaint that the rituals were not followed. And in terms of section 7, according to our custom, Saptapadi was required to be conducted and it's not conducted.
He has not stated.
Yes.
But respondent has stated how the marriage performed. ಎಲ್ಲ ಹೇಳಿದ್ರೆ ಏನೇನ್ ರಿಚುವಲ್ಸ್ ಇದ್ದು ಮಾಡಿದ್ವಿ ಅಂತ ಹೇಳಿ.
Let's read the provision once again.
ಓದಿದೆ
Now, we are repeating it because both of them belong to different castes.
Yes.
Please understand this.
Yes, correct.
If both of them belong to the same community, then there is no difficulty. The word used there is either. Please read it. Please, 7.
Ceremonies for a Hindu marriage. A Hindu marriage may be solemnized in accordance with the customary rites and ceremonies of either party.
There too.
here in the case, it is, marriage is not an arranged marriage. It is not an arranged marriage.
Correct.
It is a love marriage.
I
So following as rightly discussed by the family court, in such circumstances, some of the ceremonies have been followed.
this, their latest judgment of the Supreme Court, which the learned person is relying upon. What do you do with this? See, but you have to be very sure.
Yes, sir. That Saptapadi is part of our customs. Yes.
Otherwise, there is no useful purpose by remanding the matter.
It is the practice, your lordships. In fact, I have verified, your lordships. I have verified with the parties also.
Ah.
Even their parents' marriage has been performed as per your lordships. Saptapadi has been performed even in their marriage also. The parents of the girl.
But what is the requirement as if we, since he's pointing out, they belong to two different castes.
Either to you, as your lordships.
ಇರ್ಬೋದು. But it also implies that it is not a arranged marriage.
Definitely it is not.
In those circumstances, what to do?
If your lordships,
They are not interested in
rituals and customs, yes, sir.
ceremony. They are only interested in getting married.
If your lordships are Hindus, your lordships, and if they claim themselves as a husband and wife and one,
In every community in Hindu,
correct.
it is not required that Saptapadi has
Yes,
to be followed.
yes, 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 yes,
That is why the words are carefully used there.
yes, yes. And if there is your lordships mandatory requirement in a marriage, that Saptapadi has to,
ಕಸ್ಟಮರ್ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಹುಡುಗನ್ ಕಸ್ಟಮರ್ ಇಲ್ಲ ಅಂತಂದ್ರೆ
either ಅಂತ ಇದೆ ಸ್ವಾಮಿ, ನಮ್ಮಲ್ಲಿದ್ರೆ,
that is why
yes.
we should always look into the provision and try to read having regard to the facts of the case. ಈಗ ಇದು 1956 ಅಲ್ಲಿ ಈ ಪ್ರಾವಿಷನ್ ಗಳು ಮಾಡುವಾಗ no one thought about this kind of love marriages. Therefore, we have to deal with the same provisions having regard to the present facts in the society. Every day, several such marriages take place between two young teenagers. Where do they follow all these customs?
True, your lordships. I
Can
understand.
the parents come before the court and say, no, they have not followed the ritual and therefore declare it as null and void?
Your lordships, it is the right to say that your lordships, the act has to be performed is to the husband and wife.
Correct.
And if one of the parties says that your lordships, that such a act has not been performed and it is a mandatory and in our community, and if he proves that your lordships, such a act has not been performed,
ಕಮ್ಯುನಿಟಿ ಅನ್ನೋದು ಈಗ ಪ್ರಶ್ನೆ.
yes, there is your lordships practice.
ಇರ್ಬೋದು ಅವ್ರದಿಂದ ಇದ್ರೆ at that point of time you agreed. You did not want all that. And today you are trying to say, no, there was some custom. If you were so particular, why did you run away and get married? I'm sure there will be many judgments.
I will also
Other
make
than,
this.
what you have pointed out today, it does not go into many aspects. Huh? Many judgments are there. There were many other earlier judgments of the Supreme Court which say it is not vital. Probably, they cater to such a scenario where the couple run away and get married.
It is a peculiar circumstances, your lordships, in this case, Your lordships, she has not led a single day of marital life.
ಅದ್ ಬೇರೆ.
ಇಲ್ಲ ಅಂದ್ರೆ ಈ circumstances ಅಲ್ಲಿ.
Let us not mix up the grounds.
Yes. Legal issue.
ಅದರಲ್ಲಿ that will fall under section 12. But it goes along with a word saying important. Do not know whether the two can be split.
Yeah, it is separate, your lordships.
Huh?
Under a ground of importance, there is, ಇಲ್ಲ ಇದೆ ಸುಮ್ separate ಇದೆ.
That the marriage has not been consummated owing to the importance of the respondent.
Of the respondent.
It's a single sentence.
Yes.
Without any break.
Yes, sir. Voidable marriages, any marriages solemnized whether before or after the commencement of this act shall be voidable and may be annulled by decree of nullity on any of the following grounds.
Yes.
One is importance, the marriage is, if the marriage, one is importance, your lordship. Importance.
Huh?
One is
There.
importance.
Not consummated owing to the importance of the respondent.
Yes, yes.
It cannot be split. ಈ 13 ಅಲ್ಲೂ ಇದೆ.
ಇದೆ.
But that is why ಅಲ್ಲಿ I don't think this word due to importance is added. ಎಲ್ಲಿ not consummated ಎಲ್ಲಿದೆ ಅದು? Not consummated ಎಲ್ಲಿದೆ ಗ್ರೌಂಡ್? 13 ಅಲ್ಲಿ ಇಲ್ಲ.
12(1)A ಬರುತ್ತೆ.
ಅಷ್ಟೇ. But that is tagged along with that word importance. Read and prove not only such omission, but also that rights and ceremonies were indispensable. There are many judgments. He'll be entitled to file one more petition on other grounds. But it is still open for us. Because they have been living separately for so many years now. You can still file a petition on the other ground.
Your lordships, after having taken a contention that marriage has not been performed.
ಮಾಡಕ್ಕಾಗಲ್ಲ. See, that contention of yours has been negative. Suppose we also negative and dismiss the appeal. It is still open for you to raise a challenge on the other grounds. That you have been living separately
More than 2 years.
for more than 2 years without provision.
13(1)(b).
You are not interested.
Deserts.
You are not going to join just because this appeal is dismissed. You are not going to join in.
Yes.
Then is it not open for you to file a fresh petition on a different ground?
Your lordships, the pleadings which you have taken will come, your lordships, will become a.
No, now you accept that yes, court has declared that there is a valid marriage. You are not entitled to raise other grounds?
Yes, we are entitled. Will tag, your lordships, she will be tagged with a divorcee. As a divorcee, your lordships, that is the one thing, if marriage, if it is held as a marriage is not held, that is one thing, your lordships, which they fear. It is not that.
It's already a judgment rejecting this plea.
But the ground has a file, liberty.
ಅಲ್ಲ, ಇದ್ದೇ ಇರುತ್ತೆ.
Take liberty from this court. You can say that.
That is also another option.
Yes, sir.
If you want to withdraw with liberty to raise file a fresh petition on other grounds, it is still open for you.
Yes, it could be taken up tomorrow, your lordships, I will meet.
ಏನಪ್ಪ ನಾವು ಇವ್ರಿಗೆ ಅಡ್ವೈಸ್ ಮಾಡಿದ್ರೆ ಈಸ್ ಆಲ್ಸೋ ನಾಟ್ ಏಬಲ್ ಟು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ವಾಟ್ ಇಸ್ ದ ಯೂಸ್ ಆಫ್ ಪರ್ಸೂಯಿಂಗ್ ದಿಸ್ ಕೈಂಡ್ ಆಫ್ ಸಿಚುವೇಶನ್ ವೇರ್ ಡೆಫಿನೆಟ್ಲಿ ಶಿ ಇಸ್ ನಾಟ್ ಗೋಯಿಂಗ್ ಟು ಕಮ್ ಬ್ಯಾಕ್ ಟು and you have not challenged the dismissal of your petition for restitution of conjugal rights. There is a finding that there is no marriage. What is the use of we are asking him? He is not able to understand, and you are also not advising him properly.
I advised him.
What is
But
the
he
consequence,
is
sir?
not, I told everything.
What is he going to get by doing this?
He is not understanding. In detail, I also advised.
ಆಕೆ ಬರೋದಿಲ್ಲ ಅಂತ ಎಷ್ಟು ಹೇಳಿ ಇದು ಮಾಡ್ತಾರೆ, ನೀನ್ ಸುಮ್ನೆ ಪರವಾಗಿಲ್ಲ ಹಿಂಗೆ ಇರ್ಬಿಡ್ತೀಯ ಜೀವನ ಪೂರ್ತಿ. ಒಳ್ಳೆ ಮಾತಲ್ಲಿ ಅರ್ಥನೇ ಆಗಲ್ಲ ನಿನ್ಗೆ. ನಾವು ಫೋರ್ಸ್ ಮಾಡಕ್ಕಾಗುತ್ತಾ ಆಕೆ ನೀನ್ ಬರೋದಕ್ಕೆ? ಒಂದು ರೆಸ್ಟ್ರಿಕ್ಷನ್ ಆಫ್ ಕಾಂಜುಗಲ್ ರೈಟ್ಸ್ ಪೆಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ನೀವ್ ಹಾಕಿರೋದು, ನೀವು ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ. ಯೋಚನೆ ಮಾಡು ಅಂತ ಹೇಳಿ ಕಳ್ಸಿದ್ರೆ ಹಿಂಗ ಬರೋದು. We would once again request you to put some good advice into him. Otherwise, both of them will be suffering like this. Anyway, she will be entitled to file one more petition on a different ground.
My submission is that
That they have been living
whatever
separately.
within my limit,
Huh?
whatever within my limit, I advise him. If I say anything more,
No, you should understand
tomorrow I
the
will take him.
consequence.
Told everything.
ಸುಮ್ನೆ ಈಗ
ಹೇಳಿದ್ದೀನಿ ಅವನಿಗೆ.
she is definitely not going to come to him. That is very sure. The only reason why we thought to ask that girl was, he said she is frightened because of the parents.
Yes.
She is doing this one. That is why we called her separately and we have asked her. She said no. ಏನೇ ಆದ್ರೂ ಅವ್ರ ಹತ್ರ ಅಂತೂ ಖಂಡಿತ ಹೋಗೋದಿಲ್ಲ. Extensively. at the request of learned counsel for the appellant, release this matter on 11th of November,
Correct.
Monday.
Yes.
Huh? Please
Yes.
talk to him again. Yes. For the extension, third extension. Anyway, we have given date for Monday. Early.
Serial number 13, Prashant P. Vajantri.
I'm for the petitioner, my lord.
Yes.
Lord, the petitioner was appointed as headmaster on 21/11/99, my lord. Lord, his probation was not declared, my lord. After 21 years, my lord, he was discharged from service on the ground that he has remained absent to duty without holding any inquiry. And also, my lord, without the prior approval of the first respondent.
Filed the IA for early hearing, my lord. That copy is received today, my lord.
Lord, the matter was heard on last occasion.
And they will ask me fix the date for hearing, my lord.
On last occasion, matter was, my lord, heard, and then a direction was issued to seek instruction regarding.
Different bench.
Please,
We have-
please. My only submission is, my lord, that he has been discharged after 21 years, my lord, without holding any inquiry.
But if the KAT has not found favor with you, there should be something.
Yes, my lord, but the KT proceeded on the footing, my lord, that there is already an approval from the first respondent. That is not an approval as contemplated under Rule 6(1), my lord, of the probation rules.
List this matter for final hearing.
Let it be in the same stage, my lord. Next week, my lord, it may be called, my lord. Please.
19th of November, 2024.
Please.
IA number 1 of 2024 is accordingly disposed.
Serial number 14, habeas corpus petition, Ilappa Road.
Matter, my lord. Filing, my lord, further reports, my lord. Or that we issued the, my lord, notice, my lord, to the 3 persons, my lord, including that, my lord, is making allegation that who is kidnapped that girl. But parents is arrested and they are in the judicial custody. But we are also not waiting for the that he is coming to and meet the indirectly or through any mobiles and all. We all requirement, my lord, we made the inspect that is also filed the reports also. My lord. Suspected, they given the some suspected mobile numbers also, my lord. We also, my lord, seized those mobiles and CDs are also recovered, but no, my lord, information from the victim. But page number 35, my lord, we given the detail information to the magistrate, my lord.
Last time I thought
Then Nantra, page number 37, my lord, it stopped. Further, my lord. In detail, my lord, we have to state before the magistrate, my lord. We also visited to the even Andhra Pradesh. Lookout notice is also given. Hyderabad and Mahbub Nagar. All the page number 66 are the photographs.
when they were taken into custody?
They taken the custody, my lord, or no, 31.
Huh?
31, my lord.
Where have you stated?
Or in the, that is a order, my lord, that judicial magistrate order, my lord. Page number 51. Thirty-one, 10/2024.
Fifty-one is
Sorry,
outpatient.
yes, my lord, sorry, my lord, that is. That is magistrate, my lord, order is there. 42 is the, my lord, arrest information to the, my lord, relatives, 42.
They are parents of the accused, my lord, accused one.
Then,
Ah.
you were saying ಅವ್ರನ್ನ arrest ಮಾಡ್ಲಿ ಸ್ವಾಮಿ ಎಲ್ಲ ಸರಿ ಹೋಗ್ತಂದ್ರಿ.
At the instance of my lord's direction. Earlier, they did not arrest. Only after my lord's.
ಈಗ ಇಲ್ಲಿ what the use?
Now, next, my lord, the safety of the victim, minor victim.
Huh?
Minor victim, safety of the minor victim.
Huh.
And A1. A1 is at large still. A1 is at large still.
ಇಲ್ರಿ ಇದೆ.
Sorry, my lord, that is, my lord, remind, my lord, that reminder, no, that page number 33, my lord.
33.
Yes. This is the submitted to the magistrate, my lord, then is sent to the judicial custody.
ಹಾಕಿಲ್ವಾ ಇಲ್ಲಿ order copy
That
ಹಾಕಿಲ್ವಾ?
order sheet is not produced.
You have it with you?
These don't have, order sheet is there. Huh? Order sheet. ಇಲ್ಲ.
ಆಯ್ತ್ರಿ ನಿಮ್ಮ ಇದರಲ್ಲಿ ಸ್ಟೇಟಸ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ where have you stated that such an order has been passed
Yes,
and
Lord.
they have been taken into custody. ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ?
Yeah. 31,
ಈ ನ್ಯಾಯಾಂಗ ಬಂಧನಕ್ಕೆ ಕಳಿಸಲಾಗಿದೆ ಅಂತ.
Lord, page number 3, my lord. Lord, number 4, second para, my lord.
ನಮಗೇನಾದ್ರೂ ಮಾಹಿತಿ ಇದ್ರೆ ಅವ್ರಿಗೆ ಅಸಿಸ್ಟ್ ಮಾಡೋದು. ನಮಗೇನಾದ್ರೂ ಅವ್ರ ಅಕ್ಯೂಡ್ ನಂಬರ್ ಇವ್ರ ಬಗ್ಗೆ ಹುಡುಗನ ಬಗ್ಗೆ ಮಾಹಿತಿ ಇದ್ರೆ ಅವ್ರಿಗೆ ಹೇಳಿದ್ರೆ ಹುಡುಕ್ತಾರೆ. ಗೊತ್ತಿಲ್ಲ.
ಯಾರು?
Thirty-one ten.
Yes, my lord.
Huh?
Yes, my lord. Page number 76, my lord. We also requested the jailer, who has, my lord, anybody's called or come to meet him. Page number 76, my lord. We requested on 4/11/2024. Last para.
ಏನ್ರಿ ಯಾರು ಬರ್ತಾರೆ? ಅವರಿಬ್ರಂತೂ ಬರೋದಿಲ್ಲ.
ಅಲ್ಲ ತಂದೆ ಅಟ್ಲೀಸ್ಟ್ ತಂದೆ ತಾಯಿ ಒಳಗಡೆ ಇದ್ದಾರೆ ಅಂದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ಮಲರ್ಡ್ ಸಮ್ ಥ್ರೂ ಥರ್ಡ್ ಪರ್ಸನ್ ಮಲರ್ಡ್ ದೇ ವಿಲ್ ಗೋ ಅಂಡ್ ಫಾರ್ ಮೇಕಿಂಗ್ ಅಟೆಂಪ್ಟ್ ಫಾರ್ ಬೇಲ್ ಅಂಡ್ ಆಲ್ ಮಲರ್ಡ್ ದಟ್ ಈಸ್ ದಿ or that is the information. Next page, my lord, page number 77, my lord. He given the information, my lord, that none of the persons is visited.
Survive. If this boy is not able to earn anything and how are they going to survive?
That is the problem. my lord. Why would- Even my lord, suspected mobile numbers also they furnished to us, my lord. Even we also traced and we also requested to submit these, all the CDRs and all, but none of the information is.
Government advocate has filed a status report along with various documents and submits that all efforts are made by the respondent police to find out the whereabouts of the accused person and the victim girl,
Minor victim.
minor victim girl.
One team is also, my lord, appointed, that is page number 75, my lord. It is-
It is also pointed out from the status report that on 31/10/2024, A2 and A3.
A2 and A3,
A1
yes, yes.
Yes.
have been sent to judicial custody. Full stop. And as per the directions of the Superintendent of Police, Raichur, a team has been constituted to find out the whereabouts of the accused person A1 and the victim girl. Full stop. The learned government advocate has also pointed out to various documents which show the respondent police have visited far off places such as Bengaluru, Hyderabad, and other places. Following the leads given that there are some relatives of the accused persons in those places. So, however, the respondent police have still not been able to find out. The whereabouts of accused number 1 and victim number
2 and 3, accused number 1,
Huh?
accused number 1.
learned government advocate submits that all efforts are being made to find out the whereabouts, and therefore the learned government advocate seeks for adjournment by a week's time. Stop. Next para release this matter on 13th of November. I am sure they will be able to find out.
Please,
After
we are,
all
the team is, my lord, now they are following all the, my lord, procedure and.
Yes.
Seal number 15, KM Ghate.
To appear for complaint, my lord. If I request
Huh?
taken to file rejoinder, I have filed rejoinder to the statement of objections. Filed by the respondents, my lord. And as per the direction issued by this,
So additional statement of objection.
yes, my lord.
You have
they have-
filed.
I have filed rejoinder, my lord. As per the direction of this honorable court, my lord, the respondents 2 and 3 were directed to file an affidavit. But they have not filed affidavit today.
Lordship, additional statement of objections are filed. Lordship, my request is, my lord, only the party has against, my lord, senior counsel, C. Subramania Joyce, and he is coming on 15th, my lord. on short accommodation on 15th, my lord, is coming.
23/9/2024 order.
23/9/2024, my lord. In compliance with that order, my lord, already additional statement has been produced. With that, the complainant has filed, my lord, a rejoinder. Due to some inconvenience, my lord, he is not present with today.
They withdrew the appeal.
Then
The learned single judge's order.
My request, my lord, please have it on 15th, my lord. Senior counsel is coming. Sri Subramanian Joyce.
what?
He going to argue the matter, my lord.
What is there to argue in the matter? Contempt petition. You have withdrawn the appeal.
My lord, appeal was filed,
Ah.
and the appeal, my lord, de novo inquiry was ordered. And then retired district judge was appointed. He hold inquiry. And you see, we are permitted to take action in pursuance with the report submitted by the district judge. Thereafter, my lord, the complaint was terminated from the service. He was terminated
Again,
and now matter is pending before district judge in EC.
that's a fresh cause of action.
No, that is
Now, in terms
subsequent.
of the
Have it on 15th, my lord, he is coming.
Learned single judge, my lord, in the matter disposed of, there was a clear-cut direction regarding reinstatement, my lord.
Yes, but there was also liberty granted to them.
Please, my lord.
To
And,
appeal to the,
Please, my lord, that reinstatement order was not stayed by this honorable court.
sir, they held the inquiry now after that.
No, during pendency, my lord, subsequently, they were supposed to comply the order of the learned single judgment. To that, there was no interim order, my lord.
Liberty is reserved to response number 1 and 2.
Follow.
Initiate fresh disciplinary action against the appellant.
Yes.
Liberty has been given.
Yes, order second, order operative portion, my lord. The respondents 190 in WP number 2000136 of 2022 shall reinstate the petitioner to his post immediately before the date of his suspension. So this order remained without any interim orders of in the writ appeal, my lord. So it was required to be complied.
Five, direction number 5.
In the event of disciplinary proceedings be initiated against the appellate
Not
employee,
initiated. Being not initiated against
Please,
the
Lord.
appellant.
that is with regard to payment of 50% back wages. With regard to reinstatement, my lord, that order is very clear cut order, my lord. That is positive order. They were supposed to have the stay from this honorable court in the writ appeal, or they could have complied it. They did not do both the things. Subsequently, under the garb of that, they have hold the inquiry, and they withdrew the writ appeal, my lord. So therefore, my humble submission, when they withdrew the writ appeal, the order of the learned single judge remained uncomplied, my lord.
They removed they withdrew the appeal
Yes, my lord.
because subsequently inquiry was held and
Inquiry was held.
one more order was passed.
No, that inquiry order was passed after the writ appeal was withdrawn, my lord. They submitted a report before the this honorable court in the writ appeal, my lord. That report was appreciated by this honorable court and they were permitted to pass the appropriate orders. To that effect, my lord, the appeal was permitted to be withdrawn, my lord.
This is the paragraph number 2 of the order of the division bench. Page number 50.
Yes, my lord.
Please read.
This court on 14/7/2023, after hearing so and so, for so and so, for first respondent has permitted de novo disciplinary proceedings by an officer who did not preside over the previous in proceedings, observing that such an inquiry officer preferably should be retired district judge, and this court has also stipulated that de novo proceedings shall be completed within 3 months, while directing the management not to take any decision on the report so submitted without leave of this court. This 14/7 was the order with regard to only payment of subsistence allowance, and since they have undertaken the inquiry to be conducted, so the payment of back wages that was not been taken up. Only subsistence allowance for a limited period I was permitted to be taken, that they have paid, my lord. So far as this direction is concerned regarding reinstatement, my lord, day one when the appeal was filed.
De novo inquiry has been held and again you have been dismissed.
Yes, my lord, that is
There is the
subsequent.
question of
No, no,
reinstatement.
my lord, that is subsequent. During the pendency,
Liberty has been given, sir.
no, no, liberty to hold inquiry, my lord.
No press for that implementation of that order.
But my lord, this was not disturbed, my lord.
Very same judge has given that liberty. So de novo inquiry was held.
Please, my
And
lord,
you are once again dismissed.
please, my lord. And
How can we direct them to reinstate you now?
but in the writ appeal, my lord, kindly the writ appeal papers also.
The request of learned counsel respondent. Really matter on
15th, please, 15th. 15/11,
What is this? Ask him to come on 13.
please.
Yes.
Seal number 16, Raja Venkatappa Nayak. For the accused, my lord, in the
With
matter.
your
There's a
lordship's
mention
view,
of-
I have received the reply affidavit filed by on behalf of respond number 2.
Complaint affidavit has been filed.
I wanted to file the replication against that affidavit, your lordship.
Liberty will be given.
Region. ಡ್ರಾಪ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಕಂಟೆಂಪ್ಟ್ ಅಂದ್ರೆ ರಿಟ್ ಅಲ್ಲಿ ಚಾಲನೆ ನಡೀತಿದೆ. ಮುಗಿಸ್ತಾ ಇದ್ದಾರೆ ಕಂಟೆಂಪ್ಟ್. ಕಂಟೆಂಪ್ಟ್ ಕ್ಲೋಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಕಂಟೆಂಪ್ಟ್ ಕ್ಲೋಸ್.
Who is this advocate for respond number 2?
He is in the online.
You have filed this
Lord, I'm here, my lord.
memo.
Memo filed by, no, he only filed.
Memo with affidavit.
Which one after this, my lord?
On behalf of respond number 2.
Yes.
Huh?
Yes,
I wanted to file a
he
replication.
only
against
filed the
it.
complaints affidavit.
ಇದಕ್ಕೆ ರಿಪ್ಲೈ ಆಗ್ತೀರಿ ಇದಕ್ಕೆ.
Then it comes for respond number 2. Filed a memo dated 4/10/2024 along with compliance affidavit of the managing director among Karnataka Power Corporation Limited. Then it comes for respond number 2 submit. That will come to the directions issued to the learned limited. WP number 201927 of 2022 dated 17/7/2023. The petitioner's application dated 6/10/2005 and representation dated 23/2023 have been considered. And a communication has been issued to the petitioner on 6/11/2023. So, learned counsel is therefore submit that there is compliance with the directions issued by the learned single judge. Stop, next para. When it comes in for the complainant, however, submits that liberty should be reserved to the complainant to raise a challenge to the said communication dated 6/11/2023 given by the second respondent here. Stop, next para. Accordingly, the petition is closed while reserving liberty to the complainant to raise a challenge to the said communication dated 6/11/2023, comma, if
No, regarding 6/11 23, I mean, letter which has been received by the party concerned, and as against this, a detailed reply has been submitted.
reply.
Reply has been already submitted, and your lordship kindly see.
No, no,
page-
whatever you want to do, you do in accordance with law.
Ah.
Now the contempt petition is closed.
No, but I wanted that after filing the reply against that letter, no further reply has been issued.
That's a new cause of action for you.
Yeah,
sir.
but
New cause of action for you. If they have not given a reply,
but
proceed.
two substances are required to be elucidated before this
Direction
honorable
issued by the
court.
learned single judge is
Yeah.
that they should consider your representation and pass order.
Yes.
Now they have passed order. If you are not happy with that, you proceed in accordance with law. We are giving you really that liberty. The complainant is not satisfied with the said communication. Ordered accordingly.
Seal number 17, Emma L. Kulkarni. 17, my lord, risk number 4 is the pro forma party, my lord. I will take notice for R4.
This matter pertains to supermarket committee minutes.
ಮಿಕ್ಕಿದವ್ರಿಗೆಲ್ಲ notice order ಆಗಿದೆಯಾ?
ಆಗಿದೆ. Notice is ordered, my lord. R4, I will take notice, my lord.
Former party.
Also filed the writ appeal, my lord, that is connected, my lord, 17.1. That is, office objections are there, my lord. This is, my lord, pertaining to the supermarket, my lord. Another batch of writ petition they filed. Lordship is, my lord, sitting on 7th, my lord, our review petition. Lordship adjourned by next week, my lord, and 12th, you lordship have it 12th, my lord.
You have a copy of the petition with you?
I'll serve the copy to him.
ಅಲ್ಲ, ಇದೊಂದು
Contempt I have given. They have. the
Contempt,
copy.
yes, madam.
They-
then government advocate, however, submits that a writ appeal in WA number 200-255 of 2024 has been filed at the hands of the respondent state. And the same has been connected, has been listed along with the contempt petition today. Stop. Learned Timothy Emma L. Kulkarni. What is it? Is requested to take notice for
Correspondence,
all the respondents.
please,
All the respondents.
please. Sorry, my lord, that is.
Okay.
Yes, madam.
All of.
Yes. Please.
If I am given the copy.
Yeah. Copy, ಕೊಡ್ರಿ. Yeah. ಆಮೇಲೆ ಕೊಡ್ತೀರಾ? Learned government advocate is directed to serve the copy of the appeal memo along with annexures on the learned counsel for the respondents in the writ appeal.
Please.
Next para, release this matter, these matters on
12th, madam.
12th of November.
Please.
Grateful. Grateful.
Seal number 18, Mrs. Alani. This matter, my lord, last occasion, my lord, I produced
But,
the endorsement, my lord, regarding compliance.
My lord, the content, the issue was, my lord, as on, they became government servants only from 2016. Therefore, the interest is paid only from that date. That is incorrect, my lord. The government, lord, in the very same, my lord, I take page A reply, my lord. Affidavit.
Last occasion, your lordship is made the observation, my lord, in the order.
No, that's exactly. My lord, page 20. My lord, annexure R12, my lord, page 28. Based on this, my lord, your lordship and their contention is that so I became a government servant, my lord, only from 2016. No, my lord, that's incorrect. But the first para, my lord, the Prastavane nodi Swami, 28 nalli, I have that order also. I'll produce it. Mail ivodalla ಅದು. ಅಲ್ಲ, page 28, my lord, same document.
ಅವ್ರ ಹಾಕಿದ document.
ಹೌದಾ?
28.
page 28. ಇಲ್ಲಿ ಪ್ರಸ್ತಾವನೆ ಅಂತಿದೆ. ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 1 ಮತ್ತು 2ರಲ್ಲಿನ ಸರ್ಕಾರದ ಆದೇಶದಲ್ಲಿ ದಿನಾಂಕ 17/2/2003 ಹಿಂದೆ ನಿವೃತ್ತಿ ಹೊಂದಿದ ನಿಧನರಾದ ಅಚ್ಚುಕಟ್ಟು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದ ನೌಕರರಿಗೆ ಪಿಂಚಣಿ, ಕುಟುಂಬ ಪಿಂಚಣಿ ಮತ್ತಿತರ ಸೌಲಭ್ಯ ವಿತರಿಸಲು ನಿರ್ಧರಿಸಿ ಕೃಷ್ಣಾ ಕಾಡಾ ಪ್ರಾಧಿಕಾರದ 35 ನೌಕರರು ಮತ್ತು ಮೈಸೂರು ಕಾಡಾದ 5 ನೌಕರರು ಒಟ್ಟು 40 ನೌಕರರ ಪಿಂಚಣಿ, ಕುಟುಂಬ ಪಿಂಚಣಿಯನ್ನು ನಿವೃತ್ತಿ ಹೊಂದಿದ ನಿಧನರಾದ ದಿನಾಂಕ 31/15 ಬಾಕಿ ರೂಪದಲ್ಲಿ. Lord, there is an order for the payment of company. They extended that benefit. I have that order, Lord. I'll produce it. I'll pass on. In 2003 itself, the government extended, and he is entitled to it. If I am permitted, my lord, there are other judgments in respect to the very same authority. I'll file a counter, my lord, counter. ಅಲ್ಲ, ಮೇಲ್ ಇಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ಪ್ರಸ್ತಾವನೆ, my lord. That is ರಾಜ್ಯದ ಅಚ್ಚುಕಟ್ಟು ಪ್ರದೇಶಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ನೌಕರರಿಗೆ, ರಾಜ್ಯ ಸರ್ಕಾರಿ ನೌಕರರಿಗೆ ದೊರೆಯುವಂತೆ ನಿವೃತ್ತಿ ನಂತರ ಪಿಂಚಣಿ ಮತ್ತು ಇತರೆ ಸೌಲಭ್ಯಗಳನ್ನು ಕಲ್ಪಿಸಬೇಕು ಎಂದು ಪ್ರಾಧಿಕಾರದ ನೌಕರ ಸಂಘ ನೌಕರರು ಸರ್ಕಾರಕ್ಕೆ ಮನವಿಗಳನ್ನು ಸಲ್ಲಿಸುತ್ತಾ ಬಂದಿದ್ದಾರೆ. ಕರ್ನಾಟಕ ಅಚ್ಚುಕಟ್ಟು ಪ್ರದೇಶಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ಕಾಯ್ದೆ 1980 ಸೆಕ್ಷನ್ 3 ಅನ್ವಯ ರಾಜ್ಯದಲ್ಲಿ ಒಟ್ಟು 6 ಅಚ್ಚುಕಟ್ಟು ಪ್ರದೇಶಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರಗಳನ್ನು ರಚಿಸಲಾಗಿದೆ. ಕಾಡಾ ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮಗಳು 87 ದಿನಾಂಕ 12/3/96 ಜಾರಿಗೆ ಬಂದಿದೆ. ಈ ಎಲ್ಲ ಅಚ್ಚುಕಟ್ಟು ಪ್ರದೇಶ ಪ್ರಾಧಿಕಾರಗಳಲ್ಲಿ ಕಾಡಾ ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮಗಳು 87 ಅನ್ವಯ ಜಾರಿಗೆ ಬರುವ ಪೂರ್ವದಲ್ಲಿ ಮತ್ತು ಜಾರಿಗೆ ಬಂದ ನಂತರ ಸುಮಾರು 835 ನೌಕರರು ನೇಮಕ ಮಾಡಲಾಗಿದೆ. ಕಾಡಾ ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮಗಳು 1987 ನಿಯಮ 25ರಲ್ಲಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಸಾರ್ವಜನಿಕ ಸೇವೆ 1957 ಅನ್ವಯ ರಾಜ್ಯ ಸರ್ಕಾರಿ ನೌಕರರಿಗೆ ಎಲ್ಲಾ ಸೌಲಭ್ಯಗಳನ್ನು ಕಲ್ಪಿಸಲಾಗಿದೆ. ಆದರೆ ನಿವೃತ್ತಿ ನಂತರ ದೊರೆಯಬಹುದಾದ ಸೌಲಭ್ಯಗಳನ್ನು ಕಲ್ಪಿಸಲಾಗಿರುವುದಿಲ್ಲ. ರಾಜ್ಯದ ಕಾಡಾ ಪ್ರಾಧಿಕಾರಗಳು ತನ್ನದೇ ಆದ ಆದಾಯವನ್ನು ಹೊಂದಿರದೇ ಇರುವುದರಿಂದ ಹಾಗೂ ಇವು ಸ್ವಾಯತ್ತ ಸಂಸ್ಥೆಗಳಾಗಿರುವುದರಿಂದ ಪ್ರಾಧಿಕಾರಗಳ ಸಿಬ್ಬಂದಿ ವೇತನವೂ ಸೇರಿದಂತೆ ರಾಜ್ಯ ಸರ್ಕಾರವೇ ಹಣವನ್ನು ಅನುದಾನ ಮೂಲಕ ನೀಡಲಾಗುತ್ತಿದೆ. ಮೇಲಿನ ವಿವರಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ರಾಜ್ಯ ಸರ್ಕಾರವು ವಿಷಯವನ್ನು ಕೂಲಂಕಷವಾಗಿ ಪರಿಶೀಲಿಸಿ ರಾಜ್ಯದ ಅಚ್ಚುಕಟ್ಟು ಪ್ರದೇಶಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ನೇಮಕಾತಿ ಸಕ್ರಮತೆಗೊಂಡು ನೌಕರರಿಗೆ ಕಾಡಾ ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮಗಳಿಗೆ ತಿದ್ದುಪಡಿ ತರುವುದನ್ನು ಬಾಕಿ ಇರಿಸಿ ಇನ್ನು ಮುಂದೆ ರಾಜ್ಯ ಸರ್ಕಾರ ನೌಕರರಿಗೆ ದೊರೆಯುವಂತೆ ನಿವೃತ್ತಿ ನಂತರ ಪಿಂಚಣಿ ಮತ್ತು ಇತರೆ ಸೌಲಭ್ಯಗಳನ್ನು ಕಲ್ಪಿಸಲು ತೀರ್ಮಾನ ಕೈಗೊಂಡು ಅದರಂತೆ ಕೆಳಗಿನ ಆದೇಶವನ್ನು ಹೊರಡಿಸಲಾಗಿದೆ. ಕಾಡಾ ಅಧಿನಿಯಮ 1980 ಅನ್ವಯ ರಚಿಸಲಾಗಿರುವ ರಾಜ್ಯದ ಅಚ್ಚುಕಟ್ಟು ಪ್ರದೇಶಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದಿಂದ ನೇಮಕಾತಿ ಹೊಂದಿ ನಿಯಮಾನುಸಾರ ಸಕ್ರಮತೆಗೊಂಡಿರುವ ನೌಕರರಿಗೆ ಕಾಡಾ ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮಗಳು 87ಕ್ಕೆ ತಿದ್ದುಪಡಿ ತರುವುದನ್ನು ಬಾಕಿ ಇರಿಸಿ ಈ ಆದೇಶ ಹೊರಡಿಸಿದ ದಿನಾಂಕದಿಂದ ಇನ್ನು ಮುಂದೆ ಅನ್ವಯವಾಗುವಂತೆ ಕಾಡಾ ಪ್ರಾಧಿಕಾರ ನೇಮಕಾತಿ ಹೊಂದಿ ಸಕ್ರಮ ಸೇವೆಯಲ್ಲಿರುವ ನೌಕರರಿಗೆ ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ನಿಯಮಗಳನ್ವಯ ನೌಕರರಿಗೆ ನಿವೃತ್ತಿ ನಂತರ ದೊರೆಯುವ ಪಿಂಚಣಿ ಮತ್ತು ಇದರ ಸೌಲಭ್ಯಗಳನ್ನು this has been come into effect from 13/2/2003. In pursuit, they did not do it. There are many writ petitions are filed. Went to Supreme Court, confirmed it, and they have in the rules, CADA rules, they have adopted in 5(3) the KCSR. Therefore, Supreme Court, this honorable division bench and the single lord bench and the Supreme Court confirmed the same that they are entitled for it. They have all the orders, my lord. If I am permitted, my lord, I produce by way of affidavit, my lord, counter affidavit. They say that I have become a only government. No, that is incorrect. In the preamble, they only say that also. This is an order. ಆಮೇಲೆ ಇದ್ರ ಪ್ರಕಾರ they sent a proposal to the government, my lord. One is conveniently ignored.
But this is, my lord, 2016, my lord, which is referred, my lord, page number 25, my lord.
2003.
But that is, my lord, that is referred, my lord, another order is referred, my lord, 1/6/2016, page number 25, my lord.
Already in this order,
Yes, ma'am.
dated 15/10/2024, where is the reference to this
But-
earlier government order?
But that is, my lord, not applicable for, that is the reason, my lord, this is the government order 2016, my lord, this, may I pass on this one, my lord. That is referred in the, my lord, page number 29, my lord. 29, page number 29. ತದನಂತರ, ವಾಟ್ಸ್ಆಪ್ ಹೇಳಿ. ತದನಂತರ ವಿಳಂಬವಾಗಿ ಪಾವತಿಸಲಾದ ಪಿಂಚಣಿ ಮತ್ತು ಮತ್ತಿತರ ಸೌಲಭ್ಯಗಳ ಮೇಲೆ ಬಡ್ಡಿ ಪಾವತಿಸುವ ಸಂಬಂಧ ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 5ರ ಟಿಪ್ಪಣಿಗಳಲ್ಲಿ ಆರ್ಥಿಕ ಇಲಾಖೆಯು ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸು 13/9/94 ಅನ್ವಯ ರಾಜ್ಯ ಸರ್ಕಾರಿ ನೌಕರರಿಗೆ ಮಾತ್ರ ವಿಳಂಬವಾಗಿ ಪಾವತಿಸಲಾದ ನಿವೃತ್ತಿ ಸೌಲಭ್ಯಗಳನ್ನು ಬಡ್ಡಿಗಳನ್ನು ಪಾವತಿಸಲು ಅವಕಾಶ ಕಲ್ಪಿಸಲಾಗಿರುತ್ತದೆ. ಸದರಿ ನೌಕರರು ಕಾಡಾ ಅಚ್ಚುಕಟ್ಟೆ ಪ್ರದೇಶಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದ ನೌಕರರಾಗಿದ್ದು ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸು 2011 ದಿನಾಂಕ 1/6/2016 ನೌಕರರುಗಳಿಗೆ ಪಿಂಚಣಿ ಕುಟುಂಬ ಪಿಂಚಣಿಯನ್ನು ಪಾವತಿಸಲು ಆದೇಶಿಸಿರುವ ಹಿನ್ನೆಲೆಯಿಂದಾಗಿ ನಿವೃತ್ತ ಸೌಲಭ್ಯಗಳಿಗೆ ಅರ್ಹರಾಗಿರ್ತಾರೆ. ಆದ್ದರಿಂದ ದಿವಂಗತ ಚಂದ್ರಕಾಂತ್ ರೆಡ್ಡಿಯವರಿಗೆ ಪತ್ನಿ ಶ್ರೀಮತಿ ಜಯಶ್ರೀರವರಿಗೆ ತಡವಾಗಿ ಪಾವತಿಸಲಾದ ಕುಟುಂಬ ಪಿಂಚಣಿ ಮತ್ತು ಉಪಧನ ಮೊತ್ತಗಳಿಗೆ ಬಡ್ಡಿ ಪಾವತಿಸಲು ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ 13/9/2094 ಅನ್ವಯ ಅವಕಾಶವಿರುವುದಿಲ್ಲವೆಂದು ತಿಳಿಸಿದೆ. ಆದರೂ ಹಾಗೂ ಸದರಿ ನೌಕರರು ಕಾಡು ಪ್ರಾಧಿಕಾರದ ನೌಕರರಾಗಿರುವುದರಿಂದ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ತೀರ್ಪಿನನ್ವಯ ಆಡಳಿತ ಇಲಾಖೆಯಲ್ಲಿಯೇ ತಮ್ಮ ಹಂತದಲ್ಲಿ ಪರಿಶೀಲಿಸಿ ಸೂಕ್ತ ತೀರ್ಮಾನ ಕೈಗೊಳ್ಳಲು ತಿಳಿಸಲಾಗಿರುತ್ತದೆ. ನೆಕ್ಸ್ಟ್ ಒನ್. ಸರ್ಕಾರದ ಅಪರ ಮುಖ್ಯ ಕಾರ್ಯದರ್ಶಿ ಅಧ್ಯಕ್ಷೆಯಲ್ಲಿ ನಡೆದ ವಿವಾದ ಮಂಡಳಿ ರಿಟ್ ಪಿಟಿಷನ್ಸ್ ವಜಾಗೊಳಿಸಿ ಹೊರಡಿಸುವ ತೀರ್ಪಿನ ವಿರುದ್ಧ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿ ಸೂಕ್ತವಲ್ಲವೆಂದು ತೀರ್ಮಾನ ಕಳ್ಳಲಾಯಿತು. ಅದರಂತೆ ಸದರಿ ಸಭಾ ಅಗತ್ಯ ಕ್ರಮಗಳನ್ನು ನಿರ್ದೇಶಕರು ಕಾಡು ನಿರ್ದೇಶಕರಿಗೆ ನೀಡಲಾಯಿತು. ಶ್ರೀಮತಿ ಜಯಶ್ರೀ ಇವರಿಗೆ ತಡವಾಗಿ ಪಾವತಿಸಿದ ಪಿಂಚಣಿ ಮತ್ತು ಇತರ ಸೌಲಭ್ಯಗಳ ಮೇಲೆ ಬಡ್ಡಿ ನೀಡುವಂತೆ ಕೋರಿ ಮಾನ್ಯ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಪೀಠ ಸೋನ್ಸ ಆದೇಶವನ್ನು ಈವರೆಗೂ ಪಾಲನೆ ಮಾಡಿಲ್ಲವೆಂದು ಸದರಿಯವರು ಕಂಟೆಂಪ್ಟ್ ಅನ್ನು ದಾಖಲಿಸಿರುತ್ತಾರೆ. ನಂತರ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಆಡಳಿತಾಧಿಕಾರಿ ಕಾಡಾ ಭೀಮರಾಯಗುಡಿ ಇವರು ಶ್ರೀಮತಿ ಜಯಶ್ರೀ ಇವರು ರಿಟ್ ನಂಬರ್ ಸೋನ್ಸೋ ತೀರ್ಪಿನಂತೆ ಹಾಗೂ ಮಹಾಲೇಖರ ದಿನಾಂಕ 17/10/2019 ಕುಟುಂಬ ಪಿಂಚಣಿ ಮಂಜೂರಾತಿ ಪ್ರಕಾರ ಬಾಕಿ ಪಾವತಿಸಲಾದ ಮೊತ್ತಗನುವಾಗಿ ಶ್ರೀಮತಿ ಜಯಶ್ರೀ ಇವರಿಗೆ ನೀಡಬಹುದಾದ 1/6/2016 ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್ ಅಕ್ಟೋಬರ್ 2019 ಬಡ್ಡಿ ಲೆಕ್ಕಾಚಾರ ಮಾಡಿ ಒಟ್ಟು ಮೊತ್ತ 45,687 ಪಾವತಿ ಮಾಡಲು ಸರ್ಕಾರದಿಂದ ನಿರ್ದೇಶನ ಕೋರಿರುತ್ತಾರೆ. ಪ್ರಸ್ತಾವನೆಯನ್ನು ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿ ಸರ್ಕಾರವು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಕಲಬುರಗಿ ಪೀಠ ದಾಖಲಾದ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಡೇಟೆಡ್ 1/10/2021 ರಂದು ನೀಡಿರುವ ತೀರ್ಪಿನನ್ವಯ ದಿವಂಗತ ಚಂದ್ರಕಾಂತ್ ರೆಡ್ಡಿ ಸಹಾಯಕರು ಭೀಮರಾಯಗುಡಿ ಇವರ ಪತ್ನಿ ಜಯಶ್ರೀ ಅವರಿಗೆ ತಡವಾಗಿ ಪಾವತಿಸಲಾದ ಪಿಂಚಣಿ ಮತ್ತು ಇತರ ಸೌಲಭ್ಯಗಳ ಮೇಲೆ 12% ಬಡ್ಡಿಯನ್ನು ಪಾವತಿಸಲು ನಿರ್ಧರಿಸಿ ಈ ಕೆಳಗಂಡಂತೆ ಆದೇಶಿಸಿದೆ. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಮಾನ್ಯ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಪೀಠ ಇಲ್ಲಿ ದಾಖಲಿಸಲಾದ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಸೋನ್ಸೋ ದಿನಾಂಕ 1/10/2021 ರಂದು ನೀಡಿರುವ ತೀರ್ಪು. Yes, my lord. So as per the government order, my lord.
That you have ignored this government order by which directions were given. ಇಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರು ಮುಖ್ಯವಾಗಿ that will apply, that government order will apply only to government servants. And it will not apply to them because they were CADA employees.
Please.
He was saying, no, the earlier order is there and he is today pointing out on 17/2/2003, copy?
He ಕೊಟ್ಟಿದ್ದಾರೆ.
There's a clear direction that all of them will be treated as government servants.
And this issue, my lord, was taken in the division bench, and
How can you
division
ignore
bench
that one?
dismissed it. And there are two more orders referring to the even name of the husband of the, my lord, the, as a complainant. My lord, based on this, the 17 to 2003 order,
ಈ
they sent to the government for the,
ಹೊರಡಿಸಿದ ದಿನಾಂಕದಿಂದ ಇನ್ನು ಮುಂದೆ ಅನ್ವಯವಾಗುವಂತೆ ಕಾಡಾ ಪ್ರಾಧಿಕಾರದಿಂದ ನೇಮಕಾತಿ ಹೊಂದಿ ಸೇವೆ ಸಲ್ಲಿಸಿರುವ ನೌಕರರಿಗೆ ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ನಿಯಮಗಳನ್ವಯ ಸರ್ಕಾರಿ ನೌಕರರಿಗೆ ನಿವೃತ್ತಿಯ ನಂತರ ದೊರೆಯುವ ಪಿಂಚಣಿ ಮತ್ತು ಇತರೆ ಸೌಲಭ್ಯಗಳನ್ನು ಸರ್ಕಾರವು ಮಂಜೂರು ಮಾಡಲು ಆದೇಶಿಸಿದೆ. This order was passed in the year 2003.
This was taken into consideration, my lord, in the 2016, my lord. The 2016 order is, this is the order, my lord, kind of. Subsequent order, my lord, this is the 2016. This is the order, my lord. As per this order, my lord, we consider this.
These people as not government servants. That is contrary to this order. It is contrary to this government order.
That is, my lord, in this order, my lord, government order, my lord.
Cancel ಮಾಡೋ ಪ್ರಶ್ನೆ ಇಲ್ಲ bro. How can they cancel it?
and the division bench, my lord, has taken that view, and Supreme
But
Court. has
even, my lord,
confirmed
that is also, that order also referred, my lord, this order, that earlier order also referred in this, my lord. That's why, my lord, I am reading.
17 to 2003 government order really
Yes,
refer ಆಗಿದೆ.
ಇದರಲ್ಲಿ ಸ್ವಾಮಿ ಇದು, ಈ subsequent 2016 order ದಲ್ಲಿ, which is referred, my lord, in the, my lord, page number 29, that 1/1, that is order dated 1/6/2016, my lord. This is the government order, my lord. May I read, my lord? This
There
is
is
a,
reference to this 17 to 2003 order, government order. ಅದರಲ್ಲಿ
yes, my lord, yes, my lord. Yes, my lord. 2003, my lord, that is.
17 to
ಉಲ್ಲೇಖದಲ್ಲಿ ಇದೆ 17 to 2003. ಹೂ ಹಿಂದೆ ನಿವೃತ್ತಿ ಹೊಂದಿದ ಅಚ್ಚುಕಟ್ಟು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಕ ನೌಕರರ ಮನವಿ. This is the, that is the order. ಸರ್ಕಾರದ ಆದೇಶ 17.
Please give it here. What do you have? ಈ order
ಫಸ್ಟ್ ಒನ್ಲಿ ಫಸ್ಟ್ ಉಲ್ಲೇಖ 1ರಲ್ಲೇ ಇದೆ. ಉಲ್ಲೇಖ 1.
When did this person die?
98, my lord.
98.
98.
98.
98. And this rule came,
ದಿನಾಂಕ 17/2/2003 ಹಿಂದೆ ನಿವೃತ್ತಿ ಹೊಂದಿದ ನಿಧನರಾದ ಅಚ್ಚುಕಟ್ಟು ಅಭಿವೃದ್ಧಿ ಇವರಿಗೆ ಪಿಂಚಣಿ ಸೌಲಭ್ಯ ಇತರ ಬಗ್ಗೆ. So this will apply.
may pass on one more, lord, the order.
Here also you had opposed this court.
Yes, I think.
2011 there were all directions given. ಅದನ್ನೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಹೇಳಿದಾರಲ್ರಿ.
ಇಲ್ಲ ಅದನ್ನ they say that, my lord, earlier not for this, for the, my lord, the appointment and release of the that other benefits. Based on this 2003 order, my name is, my husband's name is there, my lord, in these two orders. This they are referred to the forward to the government. And there are two judgments of this honorable court.
ಚಂದ್ರಕಾಂತ ಪಿ ರೆಡ್ಡಿ.
Yes.
This speaks of payment of pension. So as a one-time measure, as per the request of CADA and the employees, this order was passed on 1/6/2016.
Yes, ma'am. They only given the representation.
ಸದರಿ ನೌಕರರಿಗೆ ಪಿಂಚಣಿ, ಕುಟುಂಬ ಪಿಂಚಣಿಯನ್ನು ನಿವೃತ್ತಿ ಹೊಂದಿದ ನಿಧನರಾದ ದಿನಾಂಕದಿಂದ 31/12/2015 ಬಾಕಿ ರೂಪದಲ್ಲಿ ಒಂದು ಬಾರಿಯ ಸಂದಾಯಕ್ಕಾಗಿ ತಗಲುವ ವೆಚ್ಚ 2,39,52,17 ಗಳಾಗಿರುತ್ತದೆ. ಸದರಿ 40 ನೌಕರರ ಹೆಸರು, ಹುದ್ದೆ ಮತ್ತು ಪಿಂಚಣಿ, ಕುಟುಂಬ ಪಿಂಚಣಿಯನ್ನು ನಿವೃತ್ತಿ ಹೊಂದಿದ ನಿಧನರಾದ ದಿನದಿಂದ 31/12/2015 ಒಂದು ಬಾರಿಯ ಸಂದಾಯಕ್ಕಾಗಿ ತಗುಲುವ ಒಟ್ಟು ಮೊತ್ತದ ವಿವರವನ್ನು ಅನುಬಂಧ 1ರಲ್ಲಿ ಲಗತ್ತಿಸಿದ್ದು ಸದರಿ ಪ್ರಸ್ತಾವನೆಗೆ ಸರ್ಕಾರದ ಅನುಮೋದನೆ ನೀಡಲಾಗಿರುತ್ತದೆ.
Yes, ma'am.
So it was all settled
Please,
at
ma'am.
that point of time itself,
Please.
2016.
Yes, and his name is there, Lord.
Correct.
His name is there.
So pension was accordingly
Yes,
paid.
Paid.
Now you are only
only
speaking regarding payment of interest,
Interest that.
isn't it?
Yes, that is only from 2003, my lord. I may be entitled because that rule came into effect from 2003.
2003.
And they have, instead of giving in 2003, they gave it in 2016. When they gave the settle the pension in 2016, they said that is the date they are entitled for the pension.
See, as a one-time measure, it was done.
Yes,
Everything totally was given in terms of this notification,
Yes.
government order. Where is the question of payment of interest again?
delayed payment, my lord.
ಬರೋದಿಲ್ಲ. As a one-time measure, all this was taken into consideration and this government order was passed on 1/6/2016, settling all the payments of pension and the family pension.
ಇಲ್ಲ, ಅದು 2003 ಆಗಿತ್ತು ಸ್ವಾಮಿ. ಅದನ್ನ ದಿಸ್ ಇಸ್ ದ ಗವರ್ಮೆಂಟ್ ಬ್ಲಾಡ್.
That has been taken into consideration, sir.
ಇಲ್ಲ,
Please see this.
2011 you kindly have the
ದಯವಿಟ್ಟು ನೋಡಿ, the first reference is 17/2/2003.
ಅಲ್ಲ, ತಾವು ಹೇಳ್ತಾ ಇರೋದು ಅಷ್ಟೇ. ಅಲ್ಲ, ತಾವು ಹೇಳ್ತಾ ಇರೋದು 2016 as a one time measure it was settled ಅಂತ. It one time measure was settled.
Back again. Please see that.
ಇಲ್ಲಿ
Government order was passed on 1/6/2016 as a one-time measure. This complete amount was given in respect of 40 employees. We'll continue at 2:30.
Please.
My lord, may I permit to file a counter along with all this? There are division bench, so judgment considering this issue also, they went in appeal challenging the very same contention was taken in the writ appeal. Writ appeal came to be dismissed, my lord. Finally, they paid it. Therefore, I want to produce all that document.
These were all.
ಅಲ್ಲ, futile exercise ಅಂತ ನಾಗಲ್ಲ.
These are all matters that were required to be considered by the court which is considering your writ petition.
ಅಲ್ಲ, ಅದರಲ್ಲಿ ನಾನು ಹೇಳಿದ್ದೀನಿ, ನಾನು
Contempt jurisdiction now.
ಯಾವ್ದು ಕರೆಕ್ಟ್?
How can we go into all?
ಅಲ್ಲ, that was the contention taken in the writ petition also.
Huh?
That the 40 list of the 40 members who have been given as one-time measure, that list also I have produced it. I have produced this saying that though he has died in 1998, he may not be entitled from the 98, but they are entitled from the date of order, that is 2003.
2003 notification.
2003
considered here in this government order.
ಇಲ್ಲ, government order.
One-time measure, everything has been.
ಅಲ್ಲ, one-time measure is prior to that, my lord. One-time measure is prior to that.
Or you want an adjournment, you will adjourn the matter.
My lord, 1 week I'll produce the document. 1 week.
These are not
ಇಲ್ಲ,
matters.
no, it's only, my lord.
Please understand, these are not matters that the contempt court will consider.
No, my lord, only thing is,
No clarity, then you'll have to go back for the court which has passed the order.
Illa,
That is the
my lord, I'll take chance to convince your lordship.
No, we can't go into all this aspects.
Illa, their own documents.
Supreme Court judgment ಕೊಟ್ಟಿರೋದು.
Lords, one submission, my lords.
Next week, my lord, next week, Monday, next week, Tuesday, my lord.
Lords, one submission, your lordship.
Next week, Tuesday, my lord.
My lords, one submission, my lords.
2:30.
Serial number 30.
Yes.
Next week, Tuesday, it may be taken, my lord.
29. 29.
My lord, it may be taken up. Because child is been waiting. He has issues, health issues, my lord.
Is it a case where we'll have to consider in the chamber or in the open?
Chambers.
Huh?
My humble request is for chamber.
Who is on the other side in this matter?
My lord, I'll intimate him. He was here, my lord. I'll intimate him.
What was the issue?
My lord, it is modification of visitation right.
We'll consider.
Is the next week, my lord, sir.
Maybe taken up.
Please go.
उसी साथ है सर अपील फाइल
कहाँ है? उसमें है क्या देखो?
क्या बोले
नीचे है क्या देखो? लेक्चर चलो.
My lord, permission.
Seal number 18? It's a salary?
Now, let us see the order which you are seeking implementation.
Yes,
Have they considered all these aspects there?
yes, best Lord. 2000, the learned single judge has referred to 2003 order extending the benefit, my lord, page 15, my lord. Para 3. It is seen from the annexure that the government had issued an order dated 17/2/2003 extending the pensionary benefit to the employees of the Command Area Development Authority. It is also seen from annexure D that the name of the petitioner was shortlisted for fixation of the family pension. And this was considered, and in view of this, is the entire writ petition is only for the payment of interest, my lord. And my lord, I take your lordship, my lord, the para 6, my lord.
Will pay interest the petitioner at the rate of 12% per annum from the date the pension petitioner became entitled to the family
Pension till the date the same was released to the petitioner. This shall be complied with in sort of. Lord, again, this, my lord, I take your lordship to the writ appeal they filed. It was failed, my lord. Came to be dismissed, upholding the order of the learned single judge, page 53. And now, my lord, the respondents are trying to interpret, my lord, virtually, my lord, in my view, amounting to overreach the order passed by the learned single judge and the division bench confirmation.
Please see
They did not say all these things.
paragraph number 5 of the order of the division bench.
Please.
Was your contention that he is not entitled for interest for the delayed period as per government order dated 13/9/1994.
Entire interest, my lord, entire interest is denied, my lord, in that 1994. my lord. Thereafter, my lord, 2016, my lord, they were taken with the decision that, my lord, who are not taken but lump
You
sum.
should have brought all that to the notice of the division.
Yes,
You have not
that-
done that.
That was, my lord, but they say, my lord, when they are entitled.
We can't allow you to now go on taking your own decisions
Not
as to when it will be entitled to know.
Not a single judge.
When you
my
have
lord.
suffered an order at the hands of the division bench, that is the end of the matter. Otherwise, you should go before the.
That is, our appeal is dismissed, my lord. Our appeal is dismissed and
Correct.
according to the order of the learned single.
Correct.
Kindly see the learned single judge order. my lord.
Yes.
What the learned single judge, my lord,
Yes.
directed us.
The government order dated 17/2/2003 has been considered.
Why, yes, my lord. In the government order, my lord, that is considered. That is government order 2016, my lord, that was considered. Then, my lord, we considered the 2016 and he is entitled from the date of.
You can't do that.
My lord, that is my kindly see, my lord. Learned
Go
single
get a
judge order, my lord.
clarification. Otherwise, we will proceed to.
Or learned single judge order, my lord, for a moment.
No, sir.
And even
Supreme
similar
Court judgment.
circumstances.
We can't go into all these aspects, sir. We are in contempt jurisdiction. We are not sitting in appellate jurisdiction. The Supreme Court has said in this matter, if the judgment or order does not contain any specific directions regarding a matter, or if there is any ambiguity in the directions issued therein, then it will be better to direct the parties to approach the court which disposed of the matter for clarification of the order. We can't sit in judgment. We are not sitting in appellate.
I'm absolutely.
So if you want to get a clarification, please get it. Otherwise, you will have to pay the interest of having regard
But
to the.
if lordship permit me, my lord, but he filed the contempt, my lord. Alala, one nimsham, my lord. But kindly see, my lord, another order, my lord, passed by the contempt proceedings, my lord. My lord, another judgment, another coordinate bench, my lord. In contempt, my lord, kindly see, my lord, this is there is a same ground raised by the, my lord, similar employee, kindly see, my lord, for a moment. In contempt petition also. But that is rejected. They issued the endorsement. If you want, you can challenge it. Same ground also, even there also, my lord, they are entitled that interest and all. That was, my lord, considered fully, my lord, that our endorsement is issued. Last para, my lord, last, that document, my lord, learned single judge order, my lord. Learned single judge order last, my lord, that. Thereafter, my lord, they filed the contempt.
ಅಲ್ಲ ಯಾವ್ದು
Last
ಅದರಲ್ಲಿ
paragraph.
ಮಲೋಡ್ ಐ ಥಿಂಕ್
ಅಲ್ಲ, ಒಂದೇ ನಿಮಿಷ
ಅಲ್ಲ
ಕೊಡ್ತೀನಿ.
ಅದರಲ್ಲಿ ಓನ್ಲಿ ಟು ಕನ್ಸಿಡರ್ ಇನ್ ಅಕಾರ್ಡೆನ್ಸ್ ವಿತ್ ಲಾ ಅಂತ ಇತ್ತು.
ಅಲ್ಲ, ಇದೈತೆ. This is the order, my lord. Pass on, my
ದಟ್
lord.
ಈಸ್ ಓನ್ಲಿ ಕನ್ಸಿಡರ್.
ಅಲ್ಲಿ ಇದ್ರೆ
ಯಾವ್ದು
ಕೊಡಿ. ಅದು ಆರ್ಡರ್ ಐತೆ ಇಲ್ಲ ಅದ್ರ ಇದರಲ್ಲಿ ಇದೆ.
ಗೀತಾ ಮೇ ಬಿ ಮಲೋಡ್ ದಟ್ಸ್ ಗೀತಾ ಕೇಸ್.
Representation of the
Yes.
company in a period of 1 month.
Yes,
Yeah,
ma'am. Their,
that
my
is-
lord,
that
contention
is
is,
the-
my lord,
my lord.
they're entitled, but that is also entitled, that then, my lord, we issued the endorsement. That endorsement is the next page, my lord, that is.
Ah.
That is endorsement dated 19/9/2022.
Ah.
We rejected that one, kindly see there, my lord, they are not entitled the interest and all, that is all rejected.
Ah.
Thereafter, they filed the contempt. In contempt, my lord, kindly see, my lord, there, para 4, my lord.
So they were asked to challenge that endorsement.
Yes, yes.
We are not concerned with
But
that.
here also, my lord, we referred the order of the.
Direction of the learned single judge that you are required to pay interest at the rate of 12% from the date when he became eligible.
Yes, my lord, eligible only for 16, my lord. That is our contention, my lord.
That is your contention.
Yes, ma'am.
Therefore, you should have got a clarification at the answer of the division bench. That not having been done, we cannot do it.
Lord, that, because, my lord, it is a public, my lord, amount, my lord. This is, my lord,
Get a clarification. You can't take your own decision.
but the even,
We are only required to consider whether the orders passed by the court are complied or not.
yes, my lord, that is,
If you had any clarification, you should have done it before the court, either before the learned single judge or before the division bench.
the lords may give the liberty, my lord, then I will approach to the, my lord.
On the previous date of hearing, that is 21/10, 20/24. This court had placed on record, had taken on record the submissions made by the learned government advocate. That the compliance report has been filed. In terms of government order dated 15/10/2024. However, objections were raised at the end of the learned council for the complainant that the finance department has wrongly taken into consideration that the petitioner's husband was not a government employee, and he being an employee of HADA was entitled for pension and interest thereon only in terms of government order dated 1/6/2016. Full stop. Today, learned counsel for the complainant has placed before this court copy of government order dated 17/2/2003 and submits that this government order has been considered by the learned single judge and has directed the respondents to pay interest to the petitioner at the rate of 12% per annum from the date the petitioner became entitled to family pension. Full stop. Learned counsel would further add that the respondents have failed in their attempt to assail the order of the learned single judge. Next para. Having regard to the judgment of the Honorable Supreme Court in the case of Chareshwar Prasad Paul and another versus Taraknath Ganguly and others, bracket 2002, close 5 SCC 352. Come on. If at all, any clarification is required to be obtained, comma, the respondents are required to obtain the same.
But even it applies to the petitioner also, my lord, because learned single judge, my lord,
No, no.
he said, my lord, only entitled, that's all. From where is entitled, my lord, that is not clarified by the learned single judge. Even to them also, my lord. ಅಲ್ಲ, ಅಲ್ಲ,
You have to pay.
ಅಲ್ಲ, ಅವ್ರಿಗೆ
You have to pay, sir.
that is true, my lord, yes.
Pay from 1996.
ಅಲ್ಲ, ಅವ್ರು ಹೇಳಿದ್ಬೇಕಾದ್ರೆ
Yes, they say I'm entitled from 1996 or 2003. Who is to get the clarification? Because you have to pay.
that's true, my lord.
Won't get the clarification. Otherwise you pay.
Yes, I will get it.
Either at the hands of the learned single judge to pass the order or before the division bench. So, for that purpose, 3 weeks time is granted to the respondents. List this matter immediately after 3 weeks.
Please.
Yes.
Bill number 29. Gita Anara Sajjan Shakti.
My lord, in this matter, petitioner and the child were directed to be present before the honorable court.
Yes.
They are there, my lord. My lord, ನಮ್ಗೆ ಏನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ ಮಗುಗ್ ಭೇಟಿ ಮಾಡ್ಸಕ್ಕೆ, ಬಟ್ ಪ್ರತಿ ಸರಿ ಮಗು ಭೇಟಿ ಆದಾಗ ಮಗುನ್ ಮೇಲೆ ಪರಿಣಾಮ ಆಗ್ತಾ ಇದೆ. ಅವನಿಗೆ ಆಕ್ಚುಲಿ from birth he is fitted with a heart pacemaker in his heart, my lords, and his physical health is in a delicate condition, and child is also been diagnosed with depression. ಅವನಿಗೆ ಹಿಯರಿಂಗ್ ಕೆಪಾಸಿಟಿ ಕೂಡ ಕಡಿಮೆ ಆಗಿದೆ. We are only seeking modification of visitation, that physical visitation rights ಬೇಡ, ಅವರಿಗೆ via video call ಮಾಡ್ಲಿ and every 2 months ಇರ್ಲಿ ಅಂತ ಸ್ವಾಮಿ.
ಏನಪ್ಪ ನಿನ್ನ ಹೆಸರು? ಚಿನ್ಮಯ್. ಓದ್ತಾ ಇದೀಯಾ? ಓದ್ತಾ ಇದೀಯಾ?
ಸ್ಟಡೀಸ್ ಮಾಡ್ತಾ ಇದೀಯಾ?
ಓದ್ಲತ್ತೇನಂತ ಸ್ಕೂಲಿಗೆ ಹೋಗ್ತಿಲ್ಲ?
ಹೋಗ್ತೀನ್ರಿ.
ಓದ್ತೀಯಾ? ಯಾವ ಕ್ಲಾಸ್?
ವಾಣಿವಿಲಾಸ ಪಬ್ಲಿಕ್ ಸ್ಕೂಲ್.
ಎಷ್ಟನೇ ಕ್ಲಾಸ್?
ಕ್ಲಾಸ್
5th ಇಂಗ್ಲಿಷ್ ಮೀಡಿಯಂ.
5th.
ಅಲ್ಲ, ಅಲ್ಲಿ ಇದ್ದಿದಾರಲ್ಲ ಅಲ್ಲಿ ಅವ್ರು ಇನ್ ಕಡೆ ಅಲ್ಲಿ ಇದ್ದಿದಾರಲ್ಲಪ್ಪ, ಅಲ್ಲಿ ನೋಡಲ್ಲಿ.
ಅಲ್ಲಿ ನೋಡು, ಅವ್ರಿಗೆ ನೋಡು.
ನೋಡಲ್ ನೋಡ್ಬೇಕು.
ಅವ್ರು ಯಾರು ಗೊತ್ತಾ?
ಗೊತ್ತಿಲ್ರಿ.
ಗೊತ್ತಿಲ್ಲ. ಅವ್ರು ಯಾರು ಅಂತ ಗೊತ್ತಿಲ್ಲ.
ಏನ್ರಿ?
ಅವ್ರು ನಿಂಗ್ ಪರಿಚಯ ಇದಾರ ಅಂತ ಕೇಳ್ತಾ ಇದಾರ. ಗೊತ್ತಾರ ಅವರು?
ಗೊತ್ತಿಲ್ಲ.
ಅವ್ರ ಹೆಸರೇನು ಗೊತ್ತಿಲ್ಲ.
ಅವ್ರ ಹೆಸರು ಏನಿದೆ ಗೊತ್ತಿಲ್ಲ.
ಅವ್ರನ್ನ ಯಾವತ್ತು ಭೇಟಿ ಮಾಡಿಲ್ವಾ?
ಭೇಟಿ ಆಗಿದ್ದೆ ಅವ್ರಿಗೆ? ಅವ್ರಿಗೆ ಭೇಟಿ ಆಗ್ತಾ ಇಲ್ಲ. ಅವ್ರಿಗೆ ಎಲ್ಲಾರು ನೋಡಿದಿ ಮೊದಲ? ನೋಡಿಲ್ಲ.
ಯಾವಾಗಾದ್ರೂ ಭೇಟಿ ಮಾಡಿದ್ದೀರಾ ಮಗುನ?
ವೀಕ್ಲಿ ಸೆಕೆಂಡ್
ಈ
ಸಂಡೇ ಮತ್ತೆ ಫೋರ್ತ್ ಸಂಡೇ.
ಈ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಮೇಲೆ, ಈ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಮೇಲೆ ನೀವು ಯಾವ ತರ ಭೇಟಿ ಮಾಡಿದ್ದೀರಾ ಮಗುನ?
ಲಾಸ್ಟ್ ವೀಕ್ ಕಂಟೆಂಟ್ ಸರ್, ಅದಕ್ಕೆ ಮೊದಲು 2 months ಲೀವ್ ಹಾಕಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಮುಂಚೆ ಆಲ್ಟರ್ನೇಟ್ ತೊಗೊಂಬರೋದು ಬರೋದಿಲ್ಲ ಬಂದ್ರೆ ಹುಡುಗ ನಮ್ಮ ಜೊತೆ ಮಾತಾಡೋದು.
ಅಲ್ಲ, ಎಷ್ಟು ಸರಿ ಭೇಟಿ ಮಾಡಿದ್ದೀರಾ ಮಗುನ?
ಒಂದು 10 ಸರಿ ಆಗಿದೆ.
10 ಸರಿ ಭೇಟಿ ಮಾಡಿದ್ದೀರಾ? ಇಲ್ಲ ಅಂತಾನೆ, ಏನ್ ಗೊತ್ತಿಲ್ಲ ಅಂತಾನೆ.
ಅಲ್ಲಿ ಒಂದು ಸಬ್ಮಿಷನ್ ಮೇಲೆ ಅವ್ರಿ ಡೇಟ್ ಅಲ್ಲಿ
ಕರ್ಕೊಂಡ್ ಬರ್ತಾರೆ, 11 ಗಂಟೆಗೆ ಬರ್ತಾರೆ, 15-20 ನಿಮಿಷ ಕೂಡ್ತಾರೆ, ಮಗು ಭೇಟಿ ಆಗ್ತಾ ಇದ್ದಂಗೆ ಹೋಗ್ಬಿಡ್ತಾರೆ. ಬಟ್ ಅವ್ರು ಈಸ್ ನಾಟ್ ಹೆಡ್ಲೈನ್ಸ್ ಮಾಡ್ಕೊಂಡ್ ಬರ್ತಾ ಇದಾರೆ ಅಷ್ಟೇ. ಮಗುನ ಮಾತಾಡಕ್ ಅವಕಾಶನೇ ಕೊಡ್ತಾ ಇಲ್ಲ ಅವ್ರ ಮಮ್ಮಿ. ನಾವು ಕರೆಸಿ ಮಾಡಿ ಹುಡುಗ ಆಕ್ಚುಲಿ ಟ್ರೈ ಮಾಡಿದ್ರೆ, ನಾನು ಹೇಳಿದೆ 2 yearsಲಿಂದ ಪ್ರಯತ್ನ ಮಾಡ್ತಾ ಇದ್ವಿ. 2 yearsಲಿಂದ ನಿಧಾನಕ್ಕೆ ಬರುತ್ತೆ ಮಗು, ಚಿಕ್ಕ ಮಗು ಇದೆ, ನಿಧಾನಕ್ಕೆ ಸ್ವಲ್ಪ ಡೈಲಿ half an hour ತಂದೆ ಜೊತೆ ಇದ್ರೆ ಬೇರೆ ಇತ್ತು ಅಂತ ಹೇಳಿ. ಅವ್ರು ಓನ್ಲಿ half an hour ಕೂಡ್ತಾರೆ, ಹೋಗ್ಬಿಡ್ತಾರೆ. ಕೈಂಡ್ಲಿ ಆಫ್ ಪ್ರೊಡ್ಯೂಸಿಂಗ್ ದಿ ಆರ್ಡರ್ ಶೀಟ್ ಆಫ್ ದಿ ನೀರ್ ಓನ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಆಫ್ ಇದು
My lords, may
ಅಟೆಂಡೆನ್ಸ್ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ.
So you have taken divorce by mutual consent.
yes.
Yes, sir.
And what were the terms of the agreement by which there was a mutual divorce?
Custody would be with the wife.
ಮಗುನಾದ್ರು ನೋಡೋದಕ್ಕೆ ಒಂದು ಅವಕಾಶ ಕೊಡಬೇಕು ಅಂತ ತಾನೇ ಒಂದು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಇರುತ್ತೆ.
Yes, my lords, and actually after divorce he never bothered to see the child or anything. 2016ನಲ್ಲಿ ಡಿವೋರ್ಸ್ ಆಗಿದೆ. 2022ರಲ್ಲಿ ಅವ್ರು ಆದ್ಮೇಲೆ ಇನ್ನೊಂದ್ ಮದ್ವೆ ಮಾಡ್ಕೊಂಡ್ರು ಇತ್ತೀಚೆಗೆ ಹಸ್ಬೆಂಡ್. And 22 he got divorced from the second wife. And then he filed one custody application for seeking custody, wherein the family court decided to only give visitation rights. ಅವಾಗ ಅದಾದ್ಮೇಲೆ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಸ್ವಾಮಿ. And we didn't come immediately running to the high court challenging anything because we wanted to comply. But every time the meeting is happening, ಅವನು ಹೆಲ್ತ್ ಮೇಲೆ ಅಫೆಕ್ಟ್ ಆಗ್ತಾ ಇದೆ. ಅದಕ್ಕೆ CDP ಅವ್ರು ಕೂಡ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅಲ್ಲಿ ಪ್ರತಿ ಸರಿ ಮೀಟಿಂಗ್ ಆಗುವಾಗ ಅವರು ಜೋರಾಗಿ ಕಿರ್ಚ್ತಾರೆ, ಎಲ್ಲ ಮಾಡ್ತಾರೆ. ಅದರಿಂದ ಮಗುನ್ ಮೇಲೆ ಮತ್ತೆ ಪರಿಣಾಮ ಆಗ್ತಾ ಇದೆ. And and even he is diagnosed with the depression. Child is also diagnosed with depression, my lords.
See, but you should understand one thing. So there is a divorce by mutual consent. He continues to be the father of the child.
Yes, my lords, we have no actually issues. Only thing is that
For the betterment of the child, you should ensure that he meets the father as often as possible, so that he will also have that confidence. Yes, I have a father. ನೀವು ಹಿಂಗ್ ಮಾಡ್ಕೊಂಡು ಇಲ್ಲ ಭೇಟಿ ಮಾಡೋದೇ ಬೇಡ ಅಂತ ನೀವು if you try to get excuses, then it will be difficult for the child also in future.
my lords, we are not asking for dispensation completely, my lords. We are only seeking that.
The use of
ಯಾಕೆಂದ್ರೆ ಅವನಿಗೆ ಅವನ ಹಾರ್ಟ್ ರೇಟ್ ಎವ್ರಿ ಟೈಮ್ ಈ ಮೀಟ್ಸ್ ಅವನ್ದೇನ್ ಪೇಸ್ ಮೇಕರ್ ಇದೆ ಅಲ್ಲ ಅದು ತುಂಬಾ ಜಾಸ್ತಿ ಆಗಿ ಬೀಟ್ ಆಗ್ತಾ ಇದೆ. ಅದಾದ್ಮೇಲೆ ಮಷೀನ್ ಅಫೆಕ್ಟ್ ಆಗುತ್ತೆ. ಸೊ ದೇರ್ ಫಾರ್ ದ ಡಾಕ್ಟರ್ ಇಸ್ ಆಲ್ಸೋ ಅಡ್ವೈಸ್ಡ್ ಇಫ್ ಸಚ್ ಸರ್ಕಮ್ಸ್ಟಾನ್ಸಸ್ ಆರ್ ಅವಾಯ್ಡೆಡ್, ಅಂಡ್ ವಿ ಹ್ಯಾವ್ ಆಸ್ಕ್ಡ್ ಫಾರ್ ಗಿವ್ ಇಟ್ ಇನ್ ರೈಟಿಂಗ್, ಬಟ್ ನನ್ ಆಫ್ ದ ಡಾಕ್ಟರ್ಸ್ ವಾಂಟ್ ಟು ಗಿವ್ ಇಟ್ ಬಿಕಾಸ್ ದೇ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಕಮ್ ಅಂಡ್ ಡಿಪೋಸ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್. ಸೊ ದೇ ಡೋಂಟ್ ವಾಂಟ್ ಟು ಡೂ ದಟ್, ಮೈ ಲಾರ್ಡ್ಸ್.
If a child is meeting some stranger, all these things will happen. But he will remain a stranger if these things go on. Once the child gets a rapport with the father, all these things will vanish. You should have a little bit of patience.
My lords, I have no problems only, my lords. Child is having problems, so therefore, my lords may have one look at the CDPO report, my lords.
ಜೋರಾಗಿ ಮಾತಾಡೋದು ಅದೆಲ್ಲ ಮಾಡೋ ಪರಿಸ್ಥಿತಿನೇ ಇಲ್ಲ ನಿಮಗೆ.
ಮೈಲಾಡ್ ಸಬ್ಮಿಷನ್ ಮೈಲಾಡ್ ನಾವು ಕರ್ಕೊಂಡು ಹೋಗಿಲ್ಲ, CDP ಆಫೀಸ್ ಅಲ್ಲೇ ವಿಸಿಟಿಂಗ್ ಮಾಡ್ತಾ ಇರೋದು ಅಷ್ಟೇ. CDP ಬಿಫೋರ್ ದಿ CDP ಐ ಆಮ್ ನಾಟ್ ಕರ್ಕೊಂಡು ಹೋಗಿಲ್ಲ ನಾವು ಇಲ್ಲಿವರೆಗೆ. CDP ಆಫೀಸಲ್ಲೇ ಹೋಗ್ತಾರೆ. ಐ ಆಮ್ ಪ್ರೊಡ್ಯೂಸಿಂಗ್ ದಿ ಅಟೆಂಡೆನ್ಸ್. 11 ಗಂಟೆ ಬರ್ತಾರೆ CDP ಆಫೀಸಿಗೆ, 11:45 12 ಗಂಟೆಗೆ ಹೋಗ್ಬಿಡ್ತಾರೆ. ಟೈಮಿಂಗ್ ಇರೋದು ಆಸ್ ಪರ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
CDP ಆಫೀಸ್ ಅಲ್ಲಿ ಇದು CCTV ಕ್ಯಾಮ್ರಾ ಇದೆಯಾ?
ಏನು ಇಲ್ಲ ಅದು. CCTV ಕ್ಯಾಮ್ರಾ ನೀವು ತರಿಸಬಹುದು, ನಾವು ಏನೂ
Yes,
ಮಾಡಿಲ್ಲ.
my lord. And my lordsmen direct them to.
ಅದರಲ್ಲಿ CCTV ಇದಾವೆ. ಎವ್ರಿ ಟೈಮ್ ಇಲ್ಲಿಂದ ಇವಾಗ ಬೋರ್ಡ್ ಕಾಂಗ್ರೆಸ್ ಪಕ್ಕ ಬಿಲ್ಡಿಂಗ್ಗೆ ಶಿಫ್ಟ್ ಆಗಿದೆ. ಅಲ್ಲಿ CCTV ಫುಟೇಜ್ ಇಲ್ಲ. ಅಲ್ಲಿ ಶಿಫ್ಟ್ ಆದ್ಮೇಲೆ ಫಸ್ಟ್ ಟೈಮ್ ವಿಸಿಟ್ ಮಾಡಿಲ್ಲ. ಮೊನ್ನೆ ಸಂಧ್ಯಾ
ಮಗು ತಾನ
ಚಿಕ್ಕ ಮಗು ಸರ್, ಅವ್ರು ದೊಡ್ಡವರಿದ್ದಾರೆ ಸರ್.
ನನ್ ತೋರ್ಸಕ್ಕೇನೋ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ ಸರ್. ನನ್ ಮಗನ ಹೆಲ್ತ್ ಮೇಲೆ ಪರಿಣಾಮ. ನನ್ ಮಗುನೇ ಇಲ್ಲ ಅಂತ ಬದುಕ್ತಾ ಇದ್ದೀನಿ ಇವಾಗ. ನಾಳೆ ಅವನಿಗೆ ಏನಾದ್ರು ನಾನು ಯಾರು ಬದುಕು?
ಹೌದಮ್ಮ,
ನಾನ್ ತೋರ್ಸಕ್ಕೇನು ಇದಿಲ್ಲ. ನಾನು ಆಲ್ರೆಡಿ ಮದ್ವೆ ಆಗಿದ್ದೀರಲ್ಲ, ನನ್ ಮತ್ತೆ ಮಗುಗೆ ಅದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
ಅದು ಆಗಿದೆಯಲ್ಲ, ಅದು ಡೈವೋರ್ಸ್ ಆಗಿದೆ.
ಅದು ನನ್ ಮ್ಯಾಟರ್ ಅಲ್ಲ ಸರ್, ಅದು ಪ್ರಾಬ್ಲಮ್ ಅಲ್ಲ.
ಅದು ನಿಮ್ ಪ್ರಾಬ್ಲಮ್ ಅಲ್ಲ. ಆದ್ರೆ ಕಾನೂನಿನ ಪ್ರಕಾರ,
ಮಗು ತೋರಿಸ್ತಾ ಇಲ್ಲ ಅಂತ ಇಲ್ಲ.
ಕಾನೂನಿನ ಪ್ರಕಾರ ಅವರು ಈ ಮಗುವಿನ ತಂದೆ, ಅವ್ರಿಗೂ ಅಧಿಕಾರ ಇದೆ ಅದ್ರ ಮೇಲೆ.
ಸರ್, ನನ್ ಮಗು ತೋರಿಸ್ತಾ ಇಲ್ಲ ಅಂತ ಇಲ್ಲ. ಸ್ವಲ್ಪ ಏನಾದ್ರು ನನ್ಗೆ ಅನುಕೂಲ ಮಾಡ್ಕೊಡಿ. ಅದು ಮಗುನ
ಏನ್ ಅನುಕೂಲ ಮಾಡ್ಬೇಕು? ಇವಾಗ ಯಾವ
CDP ಆಫೀಸ್,
Child Development
Child
and
Development.
Protection Officer.
ಅವರ ಆಫೀಸಲ್ಲೇ ಈ ಮಗುನ ಭೇಟಿ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂದ್ಮೇಲೆ ನಿಮ್ಗೆ ಏನ್ ಭಯ? ನಿಮ್ಗೆ
ವೀಕ್ಲಿ 1 ಟೈಮ್
ಹೊರಗಡೆ ಭೇಟಿ ಮಾಡ್ತಾ ಇಲ್ಲ?
ಹೊರಗಡೆ ಇಲ್ಲ.
My lords, let the CDPO be present and let them only give a, because they have given their report before the execution
given a false
court
report,
also, my lords, wherein
When I
they have
given
said
the
that
complaint,
it's having.
When I given the complaint to the CDP office, you are not proper comply the order. Then they have given the report against the petitioner. Man. The trial court is also called for the CDPO to complete the report, my lord.
The grievance of the appellant mother seems to be that the child who has a pacemaker gets adversely affected whenever he meets the father. Therefore, this appeal has been filed seeking modification of the orders passed by the family court, by reducing the number of hours as well as the visitation. It is further requested that the father may be directed to speak to the child through video call and not in person. Full stop. Next paragraph. We had directed both the parties to be present before this court along with the child. Stop. We have interacted with the child and the parents. Full stop. We have been informed that after directions were issued by the family court, the father has been meeting the child in the office of the
Child Development and Protection Officer.
Child Development and
Protection Officer.
Protection Officer.
Project.
Protection of project amadu.
Issue Yojana.
Yojana.
Project.
Project
Officer. Stop. We are therefore of the considered opinion that this arrangement should continue for the next 2 months. Full stop. The CDPO, the concerned CDPO is directed to ensure that the meeting of the child and the father is enabled in terms of the directions issued by the family court in a cordial atmosphere. Full stop. The CDPO is also requested to ensure that the meeting may be held in a place where CCTV cameras are installed. Full stop. This would enable the court to have a first-hand information as to what exactly takes place when the child and the father meet. Full stop. In that way, scope for making unwanted allegations would be reduced. Full stop. Next para. Copy of this order is directed to be served on the learned government advocate, who shall immediately inform the CDPO of the directions issued by this court. CDPO Kalaburagi, na?
Kalaburagi.
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 Full stop. The appellant hearing is directed to ensure that the directions issued by the family court are complied for the next 2 months. Full stop. Next para. List this matter after 2 months.
No, no, our parents is also meeting order.
Order IA number 1 of 2024. This application filed by the appellant seeking continuation of delay of 471 days in filing the appeal is allowed while condoning the delay.
My lord, also parents is also meeting order.
Huh?
Parents meet order is fathers and fathers parents also meeting.
Comply with the directions issued by the family court of Delhi.
Yes, yes.
Yes.
Serial number 19, Sharan Basappa M. Patil.
Hearing for the complainant, my lords. Council submission is that, my lord, translation of Kannada representation given to the officers, my lords, accused officers. The representation order complying the order of the writ order, my lords. Representation was given to the officers, my lords, in Kannada, my lord. The same is may be exempted, my lord. Same may be. That is, my lord, note that is Parvat Reddy is the petitioner before the writ petitioner, my lords. But in the writ order, it is mentioned as Parvati Reddy, my lord. I has been. And one more submission is that, my lord, translation is required, has been requested by the registry, my lord. But the same may be overruled, my lord, because due to urgency, translation of representation, my lords. Submission, my lord, council submission, my lords. The annexure B, my lords, annexure B, which is in Kannada.
English translation of annexure B.
Yes, my lord. The same may be overruled.
Office objection at serial number 14 regarding translated copy of annexure B is overruled. Yes.
And
the submission of the learned counsel for the complainant regarding the note put up below the first title is also accepted. Yes.
My lords, as per the direction of the honorable in the writ court, my lords, the land was utilized for the purpose of bridge cum barrage, my lords. That page number 9, my lords, page number 9,
para 3, my lords. The petitioner has filed writ petition before, writ petition, my lords. Thereafter, the honorable court has directed the issued mandamus for the, to present the representation before the authorities, my lords, and to consider within 8 weeks, my lords. But till today, they have not made any attempt to, nor any particular disobeyed the order of the learned single judge order, my lord. So I am before this honorable court for the contempt. Para number 3, my lords. Page number 9, my lord. It is the grievance of the petitioner that the land belonging to the petitioner.
Response number 224.
Yes.
Learned government advocate is directed to take notice for response number 1. Learned counsel for the complainant is also directed to serve copies of the contempt petition.
Yes.
Along with annexures on the learned government advocate.
Already served.
Huh? This matter on 21st of November.
Please.
For 20, Ulepa Road.
I request password.
Huh?
Password, my lord.
ಯಾವ್ದು ಪಾಸ್ ಅವ್ರಿ
20.
ಪ್ರೋಸೆಸ್ ಫೀ ಕಟ್ಟಬೇಕು.
PF is not paid.
My.
Issue of notice to all.
Weeks time is granted. The petitioner to take steps for service of notice on respond number 4.
Seal number 21, hearing on a Siddharam Reddy, Venkana Paraddi.
My lord, it is the case of injury, my lord. And there is a delay of 120 days in filing this appeal, my lord. My lord, the date of extent is of 2014, my lord. Tribunal has considered the income only 6,000 rupees, my lord.
Cholamandala.
Satisfied for all two.
ಆಗಿದೆಯಾ? ಏನಕ್ಕೆ ಬಂದಿದೆ? Condonation of delay, 120 days. Whatever. There is no representation for the respondents. Deal with this matter on 13th of November.
Seal number 22, RF Siddhapurkar.
Here for respondents.
This is a writ appeal by challenging the learned single judge order wherein conversion order is granted by the
Yes. You had submitted.
last time, my lord, I had submitted that a survey will be conducted. And if the area, if it is found
The prohibited zone.
prohibited zone, and then we will withdraw the case and due to this work problem, my lord, they were not able to conduct the survey.
Matter stands adjourned to 20th of November 2024 to enable the appellant to make submission as to whether the property in question falls within the prohibited area or outside.
Seal number 23, Ravindra Reddy.
Same for the respondent 2 and 3.
There is a delay of 86 days.
Huh?
There is a delay of 86 days in filing.
Ah. Issue.
Yes, ma'am. Notice have been served.
Matters.
Yes, ma'am.
Huh?
Delay may be condoned, may be posted for a preliminary.
Delay may be controlled.
Delay of 86 days in filing the appeal control. IF 1 of 2022 is accordingly disclosed.
But it may be listed on 13th, my lords.
Huh?
13th, serial number 13th. my lord.
14.
ಇಲ್ಲ 13 ಗೆ identical matter list ಆಗಿದೆ. Serial number 34.
Different ಇದೆ. Of course, same judgment, but the issue is totally different.
ಒಂದೇ ದಿವಸ.
If you are appearing on that day, you can.
Yes, yes.
ಅದು
Please.
please.
Really matter on 13th of November.
Okay.
Seal number 24, Mahesh Kiran Shetty.
Appear for appellant in this matter, my lords.
There is 61 days delay, my lord, that may be considered, my lord.
Delay of 61 days in filing the appeal.
Appeal.
Control. A number 2 of 24 is accordingly disposed.
Agreed by the judgment dated 27/3/2024.
It has come up only for hearing on IA.
Please,
Yes.
for consideration of another, any date may be fixed.
2024 matter raised.
Stay in Swami Idhara. Construction is going on in the agricultural land. There is no order on the stay application.
So the learned single judge is not convinced. What can we do? Yes.
Seal number 25.
Once
Arun
submission,
Kumar
my lords,
Kundapur.
the lordship permits me. The matter is pertaining 10/10/1950, 556, the 8 acres of land was granted to the appellant, my lords. And he is in possession. Now he has been disposed as a result of the order of the single judgment in the writ petition passed. My lords.
He is possessed.
Please, my lords, he was a,
Passed to the learned.
please,
You had filed the petition, isn't it?
please, my lords.
Then what
For
was your
consideration of representation to enter my name in the column number 9 of the RTC, my lords. So that was been rejected by issuing an endorsement, my lord. That endorsement came to be challenged in the writ petition, and in the writ petition is dismissed, saying that the endorsement is justified in nature.
If there is a dispute.
Please.
you will have to civil.
Suit is already filed. Suit is already filed.
Yes, next matter, please.
Seal number 25,
Great.
Arun Kumar Amarkundappa.
This contempt is filed by the petitioners alleging, my lord, disobedience of learned single judge direction. Page 14, my lord, para 6. The third respondent, my lord, though my father purchased property, subject property.
This application is filed by the complainant seeking dispensation of production of translated copy of Annexure B. For the time being, the complainant is for the time being, dispensation, the production of translated copy of Annexure B is dispensed. IA 1 of 2024 is accordingly disposed of.
Direction, my lord, issued by learned single judge, my lord, page 15, para 6. There is a specific direction to respondent to consider the grievance of petitioner and make mutation, sanction mutation in terms of, my lord, sale deed executed, registered sale deed executed in the year 1991 in favor of father of complainancy.
Along with annexures of the learned government.
Please.
Returnable by 20th of November.
Seal number 27, Arun Kumar Amarkundappa.
Lord, in this case, by the order, learned single judge directed the respondent number 1 hearing to consider the representation.
Same IA.
Page 14 is a direction.
Directed. Pass appropriate orders.
My lord, he was enlisted in the rowdy sheet, my lord. My name was included in the rowdy sheet without I being, my lord, did not involve in any criminal activities. I made a representation to remove my name from the rowdy list.
Despite that, my lord, my name continued in the rowdy list, and concerned authority, that is respondent number 1, has not considered the representation.
Take on, government statement, copy to serve 20th of November.
Serial number 3030, Prashant B. Vajantri.
For the petitioner, my lord. Start for dispensation of production of translated copies, my lord.
Same order. Dispensation for the time being. Sorry, matter come up for preliminary hearing?
No, my lord, it's come up for hearing on IA. I'm ready with preliminary hearing also, my lord. Your lordship may.
For dispensation, adhan nakadama modlu. This is matter for preliminary hearing on 11th of November.
Please.
Serial number 31, RJ Busare.
Appearing for a petitioner.
Fresh matter guna ivaru dispensation.
Fresh matters.
Same order.
Notice, my lord.
IA number 1 of this is matter for preliminary hearing.
Notice issue adru, sir. Notice maybe. Yes, my lord.
There is no all government,
My lord, respond number 1, government, my lord. 2, Lokayukta. Subhash Mallap.
Government for respond number
1, government. 2, Lokayukta Subhash Mallap.
Then it comes to 3, Subhash Mallapur is
Please.
for respond number 2.
2.
Will
it? Yes.
Then it comes for petitioner is directed to serve copies of the petition along with annexures and the learned counsel for the respondent.
Serial number 32, Bapugoda Siddhappa.
For the appeal, the claimant's appeal for seeking enhancement notice. The insurance company has also filed the appeal notice in this Manjunath Mallaya Shetty for respond number 2, take to notice to the respond number 2. Notice has to go to respond number 1. Issue notice to the respond number 1.
The appeal memo along with annexures and learned counsel on number 2. This matter along with MFA.
Yes, ma'am.
204053 of 2023.
Serial number 33, Bapugoda Siddhappa.
Claimant's appeal for seeking enhancement, the notice to the respond number 1 may be dispensed. The insurance company has satisfied the award amount. The second respondent, branch manager, National Insurance Company.
Yes, sir.
Sharanbasappa M. Patil.
Sharanbasappa M. Patil.
Yes, sir.
Then it comes to Sharanbasappa M. Patil, who is present in the court, takes notice for
Respond number 2, my lords.
respond number 2. Then it comes for the appellant has filed a memo seeking dispensation of notice to respond number 1 on the ground that respond number 1 is the owner of the vehicle and the liability has been passed on respond number 2. Stop. Next, at the risk of the appellant, notice to respond number 1 is dispensed. Then it comes for the appellant is directed to serve copies of the appeal memo along with annexures.
Delay of 44 days.
Huh?
Delay of 44 days in filing the appeal.
Delay of 44 days in filing the appeal is condoned. IA 1 of 2024 is accordingly disposed.
Matter may be referred to Lok Adalat.
Matter stands referred to.
My lord, I'm sorry, my lord. I tender apology. Item number 20, my lord. It was listed for orders. Madam Ratna Shivagimats may be directed to take notice for respond number 4 in this. Yes, my lord. Item number 20. I am sorry, my lord. I was just item number 20. R4. My matter.
For the
Respondent number 4. Jilla Panchayat. Jilla Panchayat. Yes. Day after tomorrow. Day after tomorrow. Day after tomorrow. Matter most urgent.
hearing ಬಂದ್ ಹೋಗಿದ್ಯಲ್ರಿ?
ಬಂದ್ ಹೋಗಿದೆ ತಾವು ನಾನು ಲ್ಯಾಬ್ಸ್ ಇಟ್ ಇಸ್ ಮೈ ಲ್ಯಾಬ್ಸ್ ಐ ಓನ್ ಇಟ್ ಐ ಪೇಡ್ PF I could not but I have served copy to government.
Once the matters come for preliminary hearing.
Yes.
There is the question of once again listing it for preliminary hearing again. Notice has been issued.
Issued my lord.
Is not convinced of your interim prayer.
Illa.
And no interim prayer is granted.
Now that day my lord said have directed me to take out notice. Thereafter your lordship said they will consider later on after hearing them. That was the my lord court's observation. Therefore day after tomorrow. Most my lord injustice caused to me. Kindly have it day after tomorrow.
Matter for preliminary hearing.
Yes.
On
Day after tomorrow. 8.
12th of November.
Yes. Great.
Seal number 35. DP Ambekar.
I am filing impeding application, short impeding option filing, short accommodation. I am filing impeding application, respondent number 3, short accommodation.
Then at Council Sri
DK Eramat.
DK Hiremat submits that an impleading application will be filed in this writ appeal.
Yes.
And therefore a week's time may be granted.
Yes.
Stop. Release this matter on 13th of November.
My lord, 13 may inconvenience, senior is out of state zone, date may be
Out at
15, 14.
19th of November.
Much of.
Yes.
Seal number 36, PS Mali Patil.
For appellant, my lords. Kindly have it for tomorrow, my lords. There is a loss of life in the family, my lords.
Yes.
Kindly have it for tomorrow, my lords. Senior is not available, my lords, today. Kindly have it for tomorrow, my lords.
Tomorrow not.
Tomorrow, day after, my lords. Monday is also fine. There is some urgency in the matter, my lords. For Monday, my lords.
Matter on 11th of November.
Please, my lords.
Seal number 37, DP Ambekar.
My lord, it's a different number 2 has prepared this appeal, my lord. One more appeal is connected with my kindly may. One more appeal is pending, my lord. That may be connect with this appeal, my lord. In that may appeal, this honorable court has issued notice, my lord. Yes, my lord.
18th of November.
Much obliged.
Along with
RFA number 200216 of 23.
0021.
Much obliged.
Seal number 38, SS Mamadapur.
For the appellant, notes this appeal is by the plaintiff, suit for partition and separate possession, seeking notes 1/3 share in the suit schedule properties.
Coming up for hearing on IN.
Admission along with I.
Huh?
Admission along with I.
Admission.
Fresh matter.
Caveat ಹಾಕಿದಾರ ಅವರು?
Oh,
Anandra Reddy.
genealogy lots I have produced that page number 7. Nearly 40 acres of land was sought to be sold at rupees 32 lakhs in favor of defendants 4 and 5. Defendant number 1 is the mother, 2 is brother, and the defendant number 3 is the sister. And lots under 2 different sold plaintiff
For
partition seeking 1/3 share. I am not a party to the lots sold it in favor of defendant number 4 and 5. Lots trial court relationship between the parties is admitted, nature of the suit property is admitted, and what trial court holds that lots house.
You have filed a suit
Yes.
against your
mother, brother,
and brother and sister.
sister, defendant 4 and 5, they are the purchasers of the suit schedule property. They have purchased first suit schedule property in the D4. He has purchased on 8/12/2015, survey number 407, 19 acres, 17 guntas for 25 lakh rupees. Exhibit D5 sale deed in favor of D5, 12/4/2016. Defendant 1 and 2 and one sale deed by defendant 1 and 2, witnessed by defendant number 3. They had entered into an,
Chronological clearly.
yes,
Correct, parties numbers. Who is
Uh,
the dependent number 3?
ಚೈತ್ರ ಅದನ್ನ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1 ಅಂತ ಆಗೈತೆ ಸ್ವಾಮಿ, ಅಲ್ಲಿ 3 ಆಗ್ಬೇಕು. ಹೌದು. Kasturi is wife, my mother, defendant number.
Property is sold by mother and son.
Mother and son in favor of,
Her daughter is a witness.
yes, in one of the sale deeds in favor of defendant number 5. Now, lords, yes, 1/3 share.
Not alienate.
Not to alienate. So what status quo? Now they are in a hurry to lords create third party rights. Let lords there be
Appearing for whom?
4 and 5 purchasers.
Purchaser.
Oh,
We will direct you not to alienate the property. Then it comes to the Manavendra Reddy has entered appearance for response number 4 and 5. To notice to response number 1 to 3. Next para. During the pendency of the appeal, respondents number 4 and 5 are directed not to alienate the suit schedule property.
yes. Ittu. Trial court ಅಲ್ಲಿ ಇತ್ತು. Trial court records may be called for. Appeal may be.
Huh?
Trial court records may be called for. Please.
Bill number 39, Santosh Kumar B.
I am the plaintiff before the trial court and I filed the suit for specific performance against the respondent hearing. On 5/8/2021, the respondent entered, executed the sale agreement, registered sale agreement in favor of the appellant, and the total sale considered was 15,80,000, and I have paid earnest money of 12,60,000, almost 80% of the sale consideration. And the trial court framed the total 3 issues. And the first issue was where the plaintiff proves that defendant has executed an agreement sale deed dated 5/8/2021, bearing document in favor of agreeing to sell the suit schedule property for 15,80,000. And whether plaintiff proves that she was and is ready and willing to perform her part of agreement, whether plaintiff is entitled for the relief as claimed in the plaint. For the first 2 issues, the court finds the affirmative. For the first 2 issues, court has given the findings affirmative, that there was an agreement of sale and executed, and I am always ready and willing. And the third, whether the plaintiff is entitled for the relief as claimed in the plaint in a negative, by giving an alternative remedy that the respondent shall refund the money with a 6%. My lordship, the reason assigned in the judgment is that there was a prior sale agreement executed by this respondent in favor of other person, and that person has not at all filed any suit for specific performance, and it is a time bar. And the second, reason is that there is a loan pending on the property by the bank. For the 2 reasons, the trial court has not granted a specific of a contract, only given alternative remedy. My submission is, as per this 2018 amendment, specific amendment, sections 10.
Did you have the benefit of temporary injunction?
Yes, my lordship, I had. I continue. I have an order that is temporary. My lordship. My lordship, I have. It's the entire order sheet. My lordship.
Identity injunction.
Not to alienate.
The respondent is also directed not to alienate the suit citizen's property till the next date of it.
Also, trial court records, ma'am. Called for trial court records.
Call for trial court.
Selam Patti, Harshvardhan Gowda Patil.
Please.
Lords, filing objection.
Appeal against conviction, my lords.
My lords.
Copy ಕೊಟ್ಟಿದ್ದೀರಾ?
Kotidaar. Let's appeal against conviction, my lords, for the major offense under section 302 of IPC. Lord, the gist of the prosecution case is that, my lord, the one of the relative, that is by name Durgappa, was murdered in the year 2005. And the complainant and his family members were arrayed as the accused persons in the murder of Durgappa, my lord. And after 3 years, they got acquitted by the trial court. Because of this anonymity, my lord, so there was the fight between the family of the present appellants accused and the complainant. And on the alleged date of incident, my lord, that is on 6/9/2010, there was a festival, that is Durgamma Devi fair was going on in the village. And during the procession, the present accused, my lords, from 1 to 18, they came up in a gang and stabbed the deceased by name Sharanappa. And because of the stab injury, my lord, he succumbed to death. And based on this, my lord, to prove the case of the prosecution in all has examined 16 witnesses. And the trial court has convicted the entire 18 members for the offense under section 302. And my lord, my major argument is that, my lord, there are 7 eyewitnesses being examined. That is PW 1 to PW 7 are the eyewitnesses, my lord, and all the eyewitnesses are the relatives of the complainant. Except the complainant, except the relatives of the complainant, no any independent eyewitnesses have been examined. And the alleged stab is only by accused number 3. Except that, my lord, there is no any major overtax by the other accused. And there are, my lords, it is very specific case that accused number 5 to 18, my lords, were surrounding and stopping the other people from entering into the, or to stop the ongoing fight. Except this, my lord, there is no case for the prosecution to say that why, because, my lord, the incident was being taken place at the huge mob. There was a festival. As per the case of the prosecution itself, there was a procession being taken of the Durgamma Devi from Maruti temple to the Durgamma Devi temple. Why there is no any independent witnesses being examined when there were several eyewitnesses being present at the spot? What was the need to examine only the independent, only the relative eyewitnesses? This is one point, my lord. And there are 2 punch witnesses who have been examined, but they have also turned hostile. That they say that the weapon was not being seized at their instances, and they have not signed the Mazar in the spot, but the Mazar was being signed in the police station. That is their statement.
The overtax was committed only
by accused number 3, my lords.
That is appellant number 3 here.
Appellant number 3 here.
But you are making this prayer on behalf of all of them.
All the accused. All the accused.
Including respondent.
Including appellant number 3. Because, my lord, it is only the case of the prosecution is that he has stabbed. But to prove that also, my lords, there is a necessity for an independent eyewitness being examined. My lord, the case of the prosecution itself. Pardon, madam?
It is long.
Please. Lord,
That
independent witnesses have to be examined. Please, my lord, I'll provide, my lords, I'm relying on 3 judgments, my lords. Okay. One second. ಇನ್ನೊಂದ್ ಸತಿ. Please, ಕೊಡ್ತೀನಿ.
Sir, the law is very clear. It is not that an interested witness's evidence cannot be considered at all.
Indeed, very true, my lords. But the Honorable Apex Court recently, my lord, in the March 2024 has clearly held it is not a bar that an independent witnesses, it is a necessity that, it is not a case that where independent witnesses cannot be relied upon. But to the contrary, when there are independent witnesses available to the prosecution, only taking the interested witnesses will cause harm to the prosecution case. It is the observation, my lord. My lord, at 2024 live law SC 244, my lords, I have produced. In the case of Periyaswamy versus the state, in that, my lords, Supreme Court has held the second head note I would like to read, my lords. Indian Evidence Act, independent witnesses. No independent witnesses were examined. The non-examination of the independent witnesses would not be fatal to the case of the prosecution. But if witnesses examined are found to be interested, then examination of the independent witnesses would assume importance. It is hard to convince how the trial court concluded that despite being the first cousin of D1 and himself a person injured in the incident, PW1 was not an interested witness. Further, considering the categorical statement, the wine shop is in the main road and the wine shop would be covered always, the joining of the independent witnesses ought not to have been a difficult task, but yet it remained unachieved. In the present case also, my lord, they themselves admit there was a crowd, there was a procession being taken in front of their house.
On that ground, can the accused be acquitted?
No. On that ground, my lord, I am saying there is an arguable case on behalf of accused number 3. That is, since it is the initial stage, my lord, that is what my submission is. I am not telling that it is the ground for acquittal, but at this initial stage, my lord, on this ground, he may be entitled for bail. That is what my humble submission is. And my lord, on the next judgment which I have produced, my lord, in the 2021 SCC online, Lord, on the very same point at paragraph number 69, if my lords may kindly note, paragraph number 69. In SCC online one judgment put in. 2021 part 13 SCC 716.
Same line.
On same lines. Paragraph number 69.
My lords. First, I would like to draw their attention, my lords, on page number 32 of the judgment. Judgment. Lower court judgment. That is the par number 64 minutes. Married males. In the present case, the PW 127 have categorically deposed that some of the accused stood by and cheered up. 64 minutes. 64.
Paragraph.
Page number
32,
paragraph
my
number
lords.
64.
Inner page of the judgment. But that is 44 in word.
Ink page number 44 minutes.
Ink page number 44, inner page number 32, 64 para. In the present case, the PW 127 have categorically deposed that some of the accused stood by and Shenappa held his hands backward. Some other accused encircled him and thereafter accused number 3 stabbed Shenappa on his left chest with the jambia. And the accused number 4 assaulted Sharanappa on his back with Barchi. Accused number 3 and 4 have assaulted. And they have also spoken the genesis of the incident. The statements of the PW 127 is consistent and credible. In the present case, the PW 1 to 7 have deposed the motive of the accused and how the incident took place. And also, my lord, all the accused, accused number, appellant number 3 and 4 have assaulted with Jembe and Barki, and all have encircled the Sharanappa. The other side argument is, my lord, there were lots of witnesses available, but prosecution has not examined those witnesses. My lord, nobody will come and adduce their evidence in the village. It's a true fact, my lords. And there is no bar at all to examine the relatives. Why their evidence is discarded? For which, my lords, the lower court has meticulously appreciated the evidence of PW 1 to 7, and also the medical evidence corroborates the evidence of PW 1 to 7. And also, my lords, the investigating agency, even though the Panchayat has turned hostile, that doesn't mean that the recovery is not been done. So that has been, so IO has stated pertains to the recovery of the Jembe. Of course, my lord, the Barchi has not been, Jembe andre adu knife kinta ಸ್ವಲ್ಪ ದೊಡ್ಡದಿರುತ್ತೆ ಅದರಲ್ಲೇ ತಲ್ವಾರ್ ಅಲ್ಲ, ತಲ್ವಾರ್ ಇಸ್ ಡ್ಯಾಗರ್, ನೈಫ್ ಅಂದ್ರೆ ಡ್ಯಾಗರ್ ಡ್ಯಾಗರ್ ದೊಡ್ಡದಾಗುತ್ತೆ ಇಷ್ಟೇ ಇರುತ್ತೆ. ಹೌದು, ಇಷ್ಟೇ ಇರುತ್ತೆ. ನೈಫ್ ಸ್ವಲ್ಪ ದೊಡ್ಡದಿದೆ, ಸ್ವಲ್ಪ ಅಲ್ಲ ಬಹಳ ದೊಡ್ಡದಿದೆ. ಡ್ಯಾಗರ್ ಕಿಂತ ಸ್ವಲ್ಪ ಚಿಕ್ಕ. ಬರ್ಚಿ ಅಂದ್ರೆ ಇವು ಉದ್ದ ಇರುತ್ತೆ ಸರ್, ಹಿಂಗ ಸ್ವಲ್ಪ ಮುಂದೆ
ಬರ್ಚಿ ಅಂದ್ರೆ ಈಗ
ಲಾಂಗ್ ಇದೆ ಸರ್. ಎಸ್ ಎಸ್, ಲಾಂಗ್ ತರ ಇರುತ್ತೆ ಸರ್. ಎಸ್,
but Barchi
and my submission would be, my lords, the after appreciation of the evidence
not seized.
that has not been seized video,
And there is no
and
injury
clearly
from Barchi also.
the trial court has opined his opinion that, my lords, even though that has not been seized, that will not be the fatal to the prosecution, because the Jembe has been seized and all the PW 1 to 7. My lords.
If the allegation that court
Yes, my lords.
assaulted
With Barchi.
on his back with
Barchi.
And if that is not recovered,
That has not been seized.
how can you say that it is not paid?
So I don't have any.
As far as accused number 4 is concerned.
Yes, my lord.
And also, my lord, there is no
I have
injury on
I have
the
not
back.
interfered.
Please,
while-
sorry,
while
sir.
I'm arguing.
Sorry, my lord,
Huh?
sorry, sir.
My lords, my submission would be, I do not have any papers, the trial court papers at presently. So let me get the papers, my lords. I'll submit and elaborately I'll submit before the honor. What the evidences that have been deposed before the court, I don't have any depositions also. And the medical evidence, what the doctor has opined, what the PME report is there. So I'll have to go before the, so I'll get it and I'll submit. Why the Barchi has not been seized?
Court come to conclusion that by encircling this person
Yes.
mean that there was a conspiracy,
Yes.
they had planned it in
Yes.
such a way.
Yes.
Has the court come to such a conclusion?
No, my lords, the court, my lord, has, my lord, the court, what the trial court has done is, it has drawn the inference on the basis of the cross-examination questions which has been posed to the witnesses. For example, my lord, the advocate has posed a question that there is no any injury by Barchi on the backside of the deceased. ಅಲ್ಲ ಈ ತರ ಕ್ವಶನ್ ಕೇಳಿದ್ದಕ್ಕೆ
Accused number 3 and 4.
Lord, four also. Yes.
Because it is said they encircled.
Yes, only on the section 149, my lords, it is the common motive. They are all liable for 302 until conclusion ಗೆ ಬಂದಿದ್ದಾರೆ trial court. On that basis,
Unlawful assembly.
unlawful assembly.
114 ಇದೆ, abatement ಇದೆ.
Yes, my lords.
ಬರೇ 140 ಏನಲ್ಲ.
Yes.
ಹೊಡೀರಿ ಅವನ್ನ ಹೇಳ್ರಿ ಅಂತ ಹೇಳಿ.
ಹೊಡೀರಿ ಅಂತ ಹೇಳಿ ಅಂದಿದ್ದಕ್ಕೆ only, yes, only on that perception, my lord, the trial court has convicted entire 18 accused persons for 302. And also, my lord, so far as accused number 4 is concerned, the allegation is that there is assault on the back of the Sharanappa, deceased Sharanappa from Barchi. But in the PM report, the doctor himself has clearly stated that there is no injury on his back and there is no injury from Barchi and there is no recovery of Barchi at all. That allegation on accused number 4 is completely being negated by the very witnesses. They are deposing falsely, and in the examination of the witnesses, they say that there is an injury on the back. But in the PM report itself, it is very clear that there is no any injury on the back of the deceased Sharanappa. Paragraph number 20 of the judgment, my lord, speaks about the PM report, wherein only it speaks about the injury on the chest, that too by the Barchi and not by, sorry, that too by Jambe and not by Barchi. So, my lord, the allegation against accused number 4 entirely goes false. There is no use of Barchi at all, and it is specific case of the prosecution that accused number 4 has assaulted on the back. And the medical report clearly says that there is no any injury on the back.
He can be equated to the other accused person.
Sorry, my lord?
He can be equated to the other accused
Yes,
person.
yes, yes.
You leave away that
Yes,
word
yes,
back.
yes, please, please. Please, my lord.
Order nahi hai. ಇದು 18 ಜನಕ್ಕೂ ಆಯ್ತಲ್ಲ ಇದು?
18 ಜನಕ್ಕೂ conviction ಮಾಡಿ. They and all were on the benefit of bail
Application
during
is
the
filed
trial.
For
Application
suspension of
on the
sentence under section 389 subclass 1 of Code of Criminal Procedure read with 430 of PMSS. To suspend the sentence, passed by the third additional district and session judge Raichur sitting at Sindhur, veterinary at Ling Subur in SC number 5004/2024. Bracket old SC number 53/2011 dated 17/8/2024. By releasing the accused on bail till the disposal of the criminal appeal. This application is supported with the memorandum of facts of the accused counsel, of the appellant counsel, in which he has stated that all the witnesses examined by the prosecution are the relatives of the deceased. As such, they have supported the case of the prosecution. The trial court only, basing on the evidence of interested witnesses, have convicted the accused, which is highly erroneous and same is not tenable under law. The only independent witnesses are the official witness and PW 8 and 9, who happens to be the punch witness, and they have not supported the case of the prosecution. The trial court, in the absence of any independent witnesses, and also when the punch witness turned hostile, has convicted the accused persons without there being any iota of evidence. Further, it is stated that the appellants were enlarged on bail and were having a benefit of bail throughout the trial. As such, they may be kindly be enlarged on bail. All these don't sought for allow this application. The learned additional SPP has filed a statement of objection containing that PW 1 to 7 have deposed that the present incident of stabbing Sharanappa took place at 8 PM. There is consistency in the evidence of these witnesses about timing of incident. There is no contradiction in respect of time. The PW 1 to 7 have deposed as to the alleged incident. The trial court has properly appreciated the evidence on record in accordance with the law and facts. There are minor discrepancies in the evidence of PW 1 to 7, and no importance can be given to such minor discrepancies. On all these grounds sought for dismissal of this application. You have heard the arguments on both sides and there will be materials placed before this court. The learned counsel for the appellant would submit, would reiterate the averments made in the memorandum of facts, and further he would submit that in para number 64 of the judgment, the trial court has observed that accused number three stabbed Sharanappa on his left,
4 assaulted with birch.
on his left
That
chest
has not been seized.
with the jambia,
3. Yes, ma'am.
and accused number 4 assaulted Sharanappa on his back with birchi. Absolutely, there is no direct evidence against other accused. And so far as accused number 4 is concerned, the alleged birchi used for the commission of offence by the accused number 4 has not been seized by the prosecution. Even in the PM report,
Yes,
PM report does not disclose as to the injuries caused through birchi.
yes.
All the accused were on bail.
All the accused were on bail.
During all the accused were on bail by the during the
course of
during
the
the
trial.
pendency of the case before the trial court. And all the appellants are ready to abide the conditions imposed by this court. The appellants have not violated the bail conditions which were imposed by the trial court. On all these notes sought for allow this application. Next, as against this, the learned additional SPP would support the judgment of conviction and sentence passed by the trial court and sought for rejection of this application. You have examined the materials placed before this court. The Circle Inspector of Police Linksogur has filed the charge sheet against the accused number 1 to 18 for the commission of offence under section 143, 147, 148, 504, 114, 341, 302, 109, read with 149 IPC. The main allegation of the prosecution is that the accused number 3, Ambrish, is that on the alleged date of incident, accused number 1 to 18 formed unlawful assembly. The accused number 3 / Amrish was holding Zambia. Accused number 4 Balappa was holding Burchi. And some of the remaining accused were holding club in their hands. They formed unlawful assembly in order to commit murder of Sharanappa, and they came near the house of Basappa Mali Gowda by shouting against the family of Sharanappa. Further, it is alleged that accused number 4, 5, 8, 10 and 11 stood on back of Sharanappa and held his hands backside. The accused number 13, 14, 15, 17 and 18 encircled Sharanappa. The accused number 5 to 18 instigated the accused number 3 and 4 to commit murder of Sharanappa. Thereafter, the accused number 3 stabbed Sharanappa with Zambia on his left chest, and accused number 4, Balappa, stabbed Sharanappa on his back with Burchi. The trial court has also appreciated the evidence on record and observed in para number 64 of the judgment that accused number 3 stabbed Sharanappa on his left chest with Zambia, and accused number 4 assaulted Sharanappa on his back with Burchi. On careful examination of these materials at this stage, it is crystal clear that the accused number, that there is sufficient evidence against the accused number 3 as to the murder of the deceased with Zambia. Admittedly, the prosecution, the investigating officer has not seized the Burchi, which is used for the commission of offence by accused number 4 Sharanappa. PM report also does not reveals as to the injuries caused to the deceased with Burchi. Next one. Considering the facts and circumstances of the case and nature of the gravity of offence and accusation made against the accused number 1 to 4 to 18, the role of the said accused, except accused number 3, and considering the antecedents of the accused, the previous the order passed by the trial court as to the release of accused on bail, we are of the considered opinion that the just and proper to allow this application, except accused number 3, appellant number 3, appellant number 3, with conditions. Accordingly, we proceed to pass the following order.
One more, my submission will be, my lords, my submission may be noted. It's 2 lines. Merely, my lords, they were on bail. That is not the criteria to grant a bail. An apex court that
is one of the ground.
Yes.
That is not the main ground.
No, my lords. What my submission would be, that has to. After appreciation of the evidence only, they have been convicted.
Submission alli, the learned SPP further would submit that merely because the accused were on bail during the trial is not a ground to release to suspend the sentence passed by the trial court, as the alleged commission of offence are heinous in nature.
And it is after appreciation of the evidence by the trial court.
the sentence passed by the learned third additional district and session judge, Raichur, sitting at Sindhanur, itinerary at Lingsubur, shall be suspended against accused number 1, 2, 4 to 18 till the disposal of this appeal, subject to condition that the accused number 1, 2, appellant number 1, 2, 4 to 18 shall execute a personal bond of rupees 2 lakhs each with one surety for like sum to the satisfaction of the registry. Next, the accused, the appellants shall appear before this court or any other court whenever directed to do so. The appellant shall not leave the country without prior permission from this court.
Please, grateful. And may I request to admit the appeal also, not since it is the conviction.
Appeal is admitted.
Paper book may
Call for TCR.
Please, grateful.
You reason to substantiate his arguments, he relied on the decision so and so. Illino, I'll considering as well to keeping in the mind of the decisions of the Honorable Apex Court relayed by the learned counsel for the appellants. Adonda.
Grateful, months. Highly blessed.
Seal number 41, Srinivasappa M. Patil.
Hearing for appellant, my lord, this suit seeking custody of the minor son was filed before the family court, my lord. The same came to be dismissed, my lord. Hence, I am before this agreed by that order. My lord. No, ma'am.
Seal number 42, B group matters, Mahesh Patil.
Here for the respondent, my lord. Last occasion, my lord, your auspice directed me to produce the, my lord, service rendered at, my lord, 2 places. One at Kalagi and one at, my lord, Kalaburagi. But he is served the more than, my lord, 8 years. Kindly similar. He don't want to give leave from the Kalaburagi. But his prayer is, my lord, we included in the, my lord, list for a compulsory transfer. That is challenged before the tribunal. Tribunal kindly similar to order is tribunal. Page number 146, my lord. Even, my lord, 2003-4, my lord, accommodative care is already over, my lord. That is the, my lord, direction by the tribunal. Still, my lord, in of the entry order, my lord, is continued in the present place.
May I make one submission, my lord, kindly? My lord, here, my lord, on the last occasion, my lord, it was, my lord, the court, my lord, had opined, my lord, that my lord, the 3 years, my lord, has to be taken into consideration. And since it's not in, my lord, the case of deputation, because it is within the same, my lord, department, it is a case of transfer. Again, my lord, they are, my lord, making the same, my lord, the arguments, like, my lord, it's a case of transfer, my lord. Please.
But this is the academic year, my lord, 2022-23, my lord.
Correct again.
Yes.
What we have pointed out is correct.
That is, my lord, previous year, my lord.
Still trying to substantiate. No, he was working in Kalaburagi only.
Yes, my lord, that is, my lord, permit 2004, my lord, to 16, my lord, is worked at Kalaburagi. That is, my lord, after deputation, my lord, this is after deputation sent again to the Kalaburagi.
Yes, deputation is Artha entry.
But deputation is not a transfer, my lord. It is one, he is drawing the salary at Kalaburagi only. But I produced it even attendance register also. but he will only for working there and he draw the salary at Kalaburagi only.
Easy then.
So it is only
So
that,
you simply have to say deputation, not transfer.
that is the my lord, rule is provided, my lord, for sending the deputation.
Deputation means sending a person from one department to another.
This is not the my lord,
How can you call this deputation, sir?
that is, he is not challenged that one, my lord. He is not challenged, my lord.
You may have used the word deputation.
But here, my lord, he already completed, my lord. Kindly see, my lord, serial number 1, my lord. Serial number 1, 28/10/2004 to 2016, my lord, is worked at Kalaburagi.
I see, yes, between 28 to 2018, 23/8/2021, he has worked at Kalagi.
That is, my lord, deputation of even previous.
Deputation is Artha MD,
Alla,
we
alla.
are not able to
But
understand.
I'm not previous, if previous period is taken, my lord, he is entitled, my lord, in the, we input the list, my lord. But that is, my lord, 2004 to 16, my lord, is worked at Kalaburagi.
How can you take that one into consideration now?
But here, my lord, that counting of service we have to take, my lord.
You have to count this also.
But this is, my lord, excluding that one also, my lord, as in today, my lord. But serial number 3, my lord, kindly see, my lord. Serial number 3, 2017 to 2018 is work. Serial number 3, my lord. At Kalaburagi. There is 1 year, my lord, that is.
Yes.
If lordship, my lord,
ಅದಾದ್ಮೇಲೆ 3 ವರ್ಷ ಬೇರೆ ಕಡೆ ಕೆಲಸ ಮಾಡಿದಾರಲ್ರಿ.
ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ 18 ಲಿಂದ 21 ವರೆಗೆ ಮಾಡಿದ್ದಾರೆ. Provision is says, my lord, that is, my lord, even tribunal also says, my lord. Last order, my lord, kindly see page number 146, my lord. Last, my lord, 146. Para 6, my lord, that is a reasoning, my lord. It is necessary to consider that initially on filing of the application, this tribunal order notice dated 9/2/2022, subject to the clarification from the department 23/12/2022, this tribunal granted interim order of status quo. It is urged by the parties that in lieu of the granting status quo in respect of the applicant, the other candidates who were called for counseling as chosen and reported for duty to their places. Since the applicant has not participated in the counseling as continued by virtue of the grant of interim order. In view of the same, the authority is required to consider now, in view of the situation, applicant is required to be disturbed from the present place by the end of the academic year or not and take to decision in this matter. End of the academic year, 2023. Thereafter, page number 146, my lord. Respondent authority is directed to consider the case of the applicant in view of the circumstances and take decision to continue the applicant in the present place for academic year in view of the fact that the counseling is already over and the candidates have already chosen the place and reported for the duty and pass appropriate order. Now, my lord, again he filed the writ petition before the Salem court. The Salem court is also granted the interim order. For that is the reason, my lord, we have not taken any decision against this petitioner. Now, my lord, that academic year itself is over. Then, my lord, we may be permitted to, my lord, that Kalagi post is still vacant, my lord. That is, nobody is transferred to that place.
So from 4/8/2021, serial number 5.
Please, my lord.
4/8/2021.
Yes, till date, my lord, is working. Yes, my lord.
He has worked at Kalaburagi.
Yes, my lord.
And therefore, the minimum tenure is over.
Yes, my lord.
You are entitled to reconsider.
Please, my lord. That is your lordship, my lord, dispose of with the direction to us, my lord.
Lord, may I make one submission, my lord, kindly? Here, my lord, admittedly, my lord, by virtue of my lord, the interim order, my lord, I am continued, my lord. But my lord, here, my lord, now, my lord, there is, my lord, counseling, my lord, is over. I have no, my lord, places to, my lord, choose. And my lord, still, my lord, I have left, my lord, I have been left with my lord, another 1 year, my lord, in, my lord, take, if it is taken into consideration, my lord, that these 3 years of where I worked in Kalagi, my lord. Whenever, my lord, I complete, my lord, by taking into consideration, my lord, these 3 years, my lord, in Kalagi, my lord, whenever, my lord, I fall due, my lord, for, my lord, transfer, compulsory transfer, my lord, I may be.
Sir, you have spent the minimum tenure at Kalaburagi now.
No, 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 still.
4/8/2021.
It is 4 years, my lord, 4 years.
Let them consider.
After 4 years, my lord, let them.
If you have completed the minimum tenure and if you are entitled for transfer, you will be transferred.
Yes, my lord. Now, my lord, I have not completed it, my lord.
We are not going to say that.
Please.
We are leaving at it as was directed by the tribunal.
Yes.
My lord, but my lord, if, my lord, these, my lord, the period.
Consider if you have completed the minimum tenure, whether you can be transferred. If they feel, yes, you have completed the minimum tenure, then you will be transferred. If you are aggrieved by such an order, we will see.
My lord, but my lord, but taking into consideration, my lord, if those 3 years, my lord, if my lord, if that is left open, my lord, the same situation remains again.
What is left over?
My lord, here, my lord, still, my lord, if those 3 years, my lord, is taken into consideration, my lord, for my lord, counting, my lord, for computing minimum tenure, my lord, then, my lord, my lord, still it is 1 year left, my lord, insofar as, my lord, the minimum tenure of 4 years is concerned. That, my lord, ಅದು ಟ್ರಾನ್ಸ್ಫರ್ ಅಂತ ಅವ್ರು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ, my lord, whenever, my lord, I fall due, my lord, after that, my lord, let them, my lord, chose me, my lord, for counseling.
Your contention is that minimum period of tenure is 4 years.
Yes, my lord, 4 years in terms of the 2021 rules.
When you are transferred to Kalaburagi.
Please, my lord.
ನಿಮಗೆ whenever it is suitable for you, you will accept it, even if it is transferred before the completion of the tenure.
No, my lord, even, my lord, even when my lord, I was transferred back from Kalki to Kalaburagi, my lord, I had made, my lord, several representations to them saying as to, my lord, those 3 years, my lord, they should consider this as transfer, my lord, and my lord,
You wanted to continue at Kalki?
no, my lord, I am presently working at Kalaburagi.
All right.
Please.
Government Polytechnic College from Kalaburagi. Is before this court aggrieved of the improved order passed by the Karnataka State Administrative Tribunal in application number 21004 of 2022 stated 3rd of March 2023. The petitioner had filed the application before the tribunal. Seeking to quash transfer order dated 3/12/2022. Whereby the petitioner Where is that impugned order? Transfer order? Please, sir.
Lord,
Annexure A12, my lord.
it's 64. Lord, page 69, Lord, serial number 3.
A12, my lord. He challenged the A12, my lord. That is the least, my lord. Along with the A4, least is produced, my lord. His name is included.
For counseling.
Yes, my lord.
Ah.
Because he completed the 4 years.
Ah.
But that is the reason, my lord, we included. That is challenged before the tribunal.
At 69, my Lord, serial number 3. My Lord, they show, my Lord, that I have worked there for 18 years, 1 month and 4 days.
Lord, your lordship, get it, my lord, serial number 3, my lord, page number 69, my lord. That is the least. Bharat.
Bharat.
Yes, my lord. Bharat. His name is Bharat, my lord. Petitioner before lordship, my lord.
They show, my Lord, that since I'm working since
Name
from
is included.
2010,
We stated, my lord, that one number of days worked in the present college.
Ah.
That is, my lord, 18 years, 1 month, 4 days. For that is the reason, my lord, we included in the list. That is challenged before the tribunal. Tribunal, my lord, given the finding that, my lord, regular posting and lien.
See, if you see this, in page number 143.
143, yes, ma'am.
Type page number 8 of the impugned order.
Please, ma'am.
Where they have extracted a rule 4.
Yes, yes, ma'am.
It is the same as the transfer policy.
Yes, ma'am. That is,
Nothing
ma'am.
different.
But
The teaching staff completing minimum length of service at the place of regular posting
yes, ma'am.
shall be compulsorily transferred in the interest of public service through a process of counseling subject to restrictions imposed in sub-rule 3. The minimum length of service to be completed at the place of present regular posting for the purpose of transfer shall be 4 years.
Yes, ma'am. That is true, my lord. But further, my lord, kindly see, my lord, from the said provision, it is clear that the teaching staff completing minimum length of service at place of the regular posting shall be compulsorily transferred in the interest of public service through the process of counseling. The regular posting is also defined under Rule 2K of the Rich Order. Regular posting means place of the posting of the teaching staff where the lien of the teaching staff lies. When the place of posting teaching staff where the lien of the teaching staff lies in the rules line is also defined as Rule 2H of 3 agenda. Has the same meaning as defined in the Karnataka Civil Service. Thus, it is clear then that the mentioning in lien as KCS Rules 1958, in view of the provision, it is clear that the regular posting of teaching staff where the line of the teaching staff lies, it is an admitted fact that the applicant is working. Pardon, madam?
What do you mean?
But lien, that is true, madam. He is admitted.
Karnataka Civil Service.
2H,
It is not
madam.
enough if you say lien means this one. The question is whether the lien is shifted. Once this person is being transferred from Kalagi to Kalaburagi, where is the question of transferring the lien? Because he is working in the same department.
That is the malad finding.
Without even considering what is the meaning of leaning, even a lien, even in terms of Karnataka Civil Services rules.
That is
This
malad.
order has been passed.
Lien is not a transfer. That is the malad taken the view of the
See,
criminal. Yes.
He is,
You-
see, he is being shifted. You
Yes,
have been
yes, yes,
shifted
yes.
from Kalaburagi to Kalagi,
Same,
Kalaburagi to Kalvi.
Yes.
Only ಇದೆ ಎರಡೇ ಜಗ್ಗಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾರೆ.
ಹೌದು ಹೌದು ಮಾಡಿದ್ದಾರೆ.
Huh?
ಹೌದು.
What happens to the lien?
That is correct, my lord.
My lord, insofar as lien, my lord, may I make
Further
one
finding,
submission?
my lord, further finding.
My lord, this honorable court, my lord, Rule 20, my lord, lien interpreted, my lord, in a, my lord, reported decision, my lord, of coordinate bench. My lord, wherein, my lord, it is, my lord, held, my lord, that, my lord, only lien gives a right to lien up to the employee, but it is restricted to the extent of only leave and pension and nothing more. Only for the purpose of leave and pension. It should not be taken for transfer, my lord.
Content that his lien continued in Kalaburagi, although he was deputed to Kalagi.
That is,
What information do you have?
that is, my lord, information. That is the my lord. As in today, my lord is working there only in
Really?
Kalaburagi. In Kalaburagi only, my lord.
ಗೊತ್ತಾಯ್ತು.
That is true, my lord.
Want that period which he worked at Kalagi
Kalagi.
to be construed as deputation.
Deputation only.
Andre, what you are trying to say is the lien continued at Kalaburagi.
Yes, my lord.
He was only deputed to Kalagi.
Yes, my lord. He is also drawn the salary at Kalaburagi only. That is the finding, my lord.
Ah.
That is the finding. But I'll read, my lord. It is an admitted fact that the applicant is working from 2004. Even now, he is working at Kalaburagi. In turn, he has been posted to Kalagi while he was discharging his duty at Kalaburagi in deputation. In view of Rule 4.1, it is clear that the person who have completed minimum length of service for 4 years on regular posting will have to be considered for compulsory transfer. In this case, the applicant, the respondent have mentioned the service of 18 years, 1 month, 4 days. Therefore, he has become eligible under Rule 4.1 of the considering the case of for compulsory transfer. On the other hand, throughout the applicant has worked at Kalaburagi and it is not disputed that he drawn the salary at Kalaburagi. Under these circumstances, there is no illegality.
That is you are doing. You asked him to go and work at Kalagi, but you asked him to draw the salary at Kalaburagi.
Deputation, my lord, where only, my lord, parent department only, he has to draw the salary.
Correct. Is there a change in the department?
But same, not changed in the, my lord, only college is changed.
Call it a deputation then.
That is, my lord, can't,
Even otherwise, what is understood by deputation is a short stint because of some exigency.
yes, yes.
Administrative exigency. ಯಾರು ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇಲ್ಲ, but there is a requirement of urgency. And therefore, you are deputed to do the work there for a few days,
Yes,
or a few weeks ಅಷ್ಟೇ.
yes.
ನೀವು 3 years ಗೆ ಅಲ್ಲಿ ಕಳಿಸ್ಬಿಟ್ಟು ಡೆಪ್ಯುಟೇಷನ್ ಅಂದ್ರೆ ಅರ್ಥ ಏನು?
ಅಲ್ಲ ಅವ್ರು ಅಲ್ಲೇನೆ ಕಂಟಿನ್ಯೂ ಮಾಡಕ್ ಲೈಕ್ ಆದ್ರು ದಟ್ ಇಸ್ ದ ಕಂಟಿನ್ಯೂಡ್ ಓನ್ಲಿ ಪ್ರೆಷರ್ ಆಫ್ ನೋಡಿ ಈಸ್ ರಿಕ್ವೆಸ್ಟ್ ಓನ್ಲಿ ದಟ್ ಇಸ್ ಕಂಟಿನ್ಯೂಡ್.
No, that is public interest, my lord. That is not true.
He doesn't objected, my lord, when he posted to the Kalburgi. Accepted and gone. 1 year, my lord, we posted here Kalaburagi, my lord. There we sent the deputation. He has to challenge that one, my lord. He is not challenged.
No, it's
He
incorrect,
ready to
my lord.
go there only.
It's incorrect, my lord.
That means, my lord, as per our instruction, my lord, that is 4 years is already completed by the petitioner before lordship. But he is eligible for counseling, transfer under the counseling.
Please read the definition of the term lien.
Lien.
Lien means the title of a government servant to hold substantively, either immediately or on the termination of the period or periods of absence, a permanent post, including a tenure post to which he has been appointed substantively.
That is the lien.
Therefore, if he is working at Kalagi, as a substantive post,
Please.
Andre, if he applies for any leave, he will not be permitted to come and join services there again.
Yes.
If it is not a substantive post.
Correct.
For 3 years, he has worked at Kalagi, and he was entitled for applying leave and going and again joining and continuing his services there. If that is the meaning, that can be attributed to lien. Can you now say, no, although he worked for in Kalagi for 3 years, his lien continued in Kalaburagi, he was drawing salary at Kalaburagi. Who asked you to do all this? Then what is the meaning of this rule 4.1?
4.1.
How you read rule 4.1?
4.1. That is, my lord.
The minimum length of service to be completed at the place of present regular posting for the purpose of transfer shall be 4 years.
Please, sub rule 3, minimum length of service to be completed at the place of permanent. That is true, my lord. That's true, my lord. Here, my lord. Now, my lord, even otherwise, my lord, he, as per benefit of the interim order, my lord, he enjoyed, my lord, we are not. But till, my lord, next academic year, my lord, that is, my lord, 2000 March, my lord, let him continue, but because, my lord, we are no option. Because, my lord, now, my lord, we cannot disturb to anyone. Till then, my lord, you will also permit us to, my lord, include his name, my lord, next academic year, my lord.
That will permit you to do only in accordance with law.
But that is true, my lord. Even, my lord, that will come in the middle of the, my lord.
Feel he has completed the minimum period of 4 years, then you can do it.
But that is true, my lord.
Otherwise, no.
Counseling will start, my lord, only in the month of March, my lord. His period, if it is taken into consideration as per your lordship, my lord, direction, my lord. His period is taken, my lord, that is, my lord, 4/8/2021, my lord. That will be expired, my lord, 2025 August only.
Correct.
Middle of the academic year, my lord. But we are not, there is no option for us, my lord.
Minimum ಅಂತ ಹೇಳೋದು. Not that immediately it has to be done.
That's my lord.
That is completed. He may have 4 or 5 months extra. So what?
But that is, my lord.
How are you agreeing?
But he enjoyed, my lord, so many years, my lord. 18 years he enjoyed, my lord. Till, my lord, that.
Years and you don't want to exclude the period where he worked in Kalagi. That is the problem.
That, my lord, yet.
The deputation.
That is the, my lord.
Forgetting the fact that he has worked there for 3 years.
That is our officer made mistake, my lord, to send them, my lord. But till, my liberty, my lord, to next academic year, my lord. But we will continue him.
If you feel that he has completed the minimum tenure of 4 years, you can do it. Otherwise, he will challenge it again. To the Karnataka State Civil Services bracketly regulation of transfer of Department of Technical Education closed 2021 being brought into force. Rule 4(1) therein provides for compulsory transfer of teaching staff who have completed minimum length of at a particular place, that is 4 years. To start. Accordingly, hearing was enlisted having been identified and eligible for compulsory transfer having regard to the said provision in Rule 4(1). Stop. According to the respondents and the list prepared in terms of annexure A12. The petitioner herein has put in (18 years, 1 month and 22 days. 4 days. 18 years, 4 months and 4 days at the Government Polytechnic College at Kalaburagi. Stop. Feeling aggrieved of the said enlistment of the name of the petitioner in the list for counseling, the petitioner filed an application before the tribunal. Full stop. The tribunal accepted the submission of the respondents that although the petitioner was posted to Kalagi, he was discharging his duties on deputation. Full stop. Further, the tribunal is also of the opinion that since a regular posting inward commonly has been defined in Rule 2(2) of the rules to mean place of posting of teaching staff where the lien of the teaching staff lies. Stop. It also noticed that the term, lien has the same meaning as defined in Karnataka Civil Services Rules 1958. Stop. Having regard to all these aspects, the tribunal came to conclusion that the applicant, bar petitioner herein, did not dispute the fact that he was drawing salary at Kalaburagi, although he was working at Kalagi. Full stop. On that ground, it was concluded that the petitioner herein continued to work at Kalaburagi, where his lien continued and he was drawing salary for the said period of 18 years, 1 month and 4 days. Full stop. Nevertheless, the tribunal also noticed the fact that while issuing notice, by order dated 9/2/2022, the tribunal granted interim order status quo. Full stop. It was urged by the parties that in view of granting status quo in respect of the petitioner hearing, the other candidates who were called for counseling had chosen to report for duty at their given places. Full stop. However, since the petitioner hearing did not participate in the counseling and continued by virtue of the interim orders passed by the tribunal, the tribunal was of the considered opinion that instead of disturbing the postings of the teachers in the midst of the academic year, it would be better to direct the respondents to consider the case of the petitioner for counseling after completion of the academic year. Full stop. Nevertheless, the petitioner filed the present writ petition before this court.
29/3/2023.
Filing.
Filing date.
Interim orders ಏನಿಲ್ವಾ?
Yes, my lord. Interim order is there.
ಯಾವಾಗ?
Interim order, my lord. On
Is 26/6, my lord. 26/6/2023.
yes.
And an interim order was passed on 26/6/2023, directing the respondents not to relieve the petitioner from his current posting till the next date of hearing. Stop. He said interim directions have been continued till date. Full stop. Next para. the learned counsel for the petitioner, not the learned government advocate. And on perusing the petition paper, we find that the term lien has been defined in a rule 8-26 of the Karnataka Civil Services Rules as ಇಂತಾಕೊಂಡು separate ಆಗಿ ಅದನ್ನ extract ಮಾಡ್ತೀನಿ. Lien means the title of a government servant to hold substantively, either immediately or on the termination of a period or periods of absence, a permanent post, including a tenure post, to which he has been appointed substantively. We should also bear in mind the fact that the rules, 2020 was notified 29th of January 2021. Stop. It is also not disputed that the petitioner has worked at the Government Polytechnic College, Kalaburagi continuously between 28/10/2004 to 2/11/2016. Full stop. Thereafter, he has worked at the Government Polytechnic College, Kalagi, between 3/11/2016 to 21/6/2017, and again from 28/2/2018 to 3/8/2021. Full stop. This, however, is sought to be termed as deputation by the respondents. Full stop. Honorable Apex Court in the case of State of Punjab and others versus Inder Singh and others, bracketed in 1997, clause 8 SCC 372, has held that the concept of deputation is well understood in service law and has a recognized meaning. Full stop. In simple words, you know, consider deputation means service outside the cadre or outside the parent department. Full stop. Deputation is deputing or transferring an employee to a post outside his cadre, comma, that is to say, comma, to another department on a temporary basis. This is what we said.
Yes. But in our government law,
Deputation, you can't use that term easily.
in government
Loosely.
guidelines, my lord, that is 147, that is, my lord, that is also indicated in the guidelines. What is the transfer or what is the deputation?
But how can you term this as
ಅಲ್ಲ,
a
ಅದ್ರಲ್ಲಿ
deputation?
ಡೆಪ್ಯುಟೇಷನ್ ದಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ, ಒಂದು ಹೆಡ್ ಆಫ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ವರ್ಕ್ ಮಾಡಿದ್ರೆ ಇಟ್ ಇಸ್ ನಾಟ್ ಅ ಟ್ರಾನ್ಸ್ಫರ್. ದಟ್ ಈಸ್ 147 ಫಾರ್ ಮೂಮೆಂಟ್, ಮಲೋಡ್.
147?
ಆಫ್ ದಿ ಪೇಪರ್ ಬುಕ್, ಮಲೋಡ್. That is last, mallard, 3D, mallard. That is a clarification given by the mallard regarding transfer and guidelines. 147, mallard, last portion. Mallard. Transfer means the posting of the government servant from one headquarters to another.
Deputation.
How the writ petition.
Deputation is B, my lord. It's
The government servant from one headquarters to another headquarters or from one office to another within the same headquarters to take up the duties and new post of income. 147, my lord, in the writ petition paper, my lord. Last portion, yes.
3B.
D for Delhi. my lord.
Transfer.
Yes, ma'am.
ಮೇಲ್ಗಡೆ ಡೆಪ್ಯುಟೇಷನ್ ಇದೆ ನೋಡ್ರಿ, ಅದು
ಅಲ್ಲಿ.
Deputation, yes.
Deputation.
Deputation means transfer of the government servant from one post to the one department to an equivalent post in another.
In one department to an equivalent post in another department.
But here that is not the other department, my lord.
That is why you can't term it as deputation,
Yes,
sir.
but that is word used, my lord. Deputation is a wrong, my lord. It is only lean, my lord.
Just because you use that term, it cannot become deputation.
Yes, that is the, even that order is also produced, my lord, that what capacity, my lord, gone to the Kalgi. That order copy is also produced, my lord.
Page 27, my lord, annexure A5.
Along with memo, I produced that order copy, my lord. Prabhare, Prabhare ಮೆಕ್ಯಾನಿಕಲ್ ವಿಭಾಗ ಇವರನ್ನು ಪ್ರಭಾರೆ ಪ್ರಾಚಾರ್ಯರಿಂದ ನೇಮಿಸಿ ನಿಯೋಜನೆ ಪ್ರಯುಕ್ತ ಬಿಡುಗಡೆ ಮಾಡಲಾಗಿದೆ.
Page 27 is clear, my lord. It's on public interest, my lord. They used instead of transfer as niyojane.
The definition of the term deputation found in the transfer guidelines issued by the government of Karnataka with a government order dated 22/11/2001, government order number DPAR 4 STR 2001 dated 22/11/2001.
The order.
Sorry, 7/6/2013, correct.
DPAR
22 STR 2013, Bangalore dated 7/6/2013. ಅದರಲ್ಲಿ 3 bracket B extract ಮಾಡ್ತೀನಿ. Next para, having regard to the meaning of the word deputation as defined in the transfer guidelines, which were applicable to all government servants, including the government teachers.
In the order, my lord, we not used any deputation also, my lord, in the order, which I produced along with memo, my lord. Only we asked him to go there and work.
No, there is a clear order.
That
Page
is not the
27.
challenge, my lord, by him.
No,
That is
no.
not the challenge.
Question of challenging, sir.
ಇಲ್ಲ ನಿಯೋಜನೆ ಅಂತ ಇದೆ.
ನೀವು ಅದೇ
ನಿಯೋಜನೆ ಎಂಬ word use
ನಿಯೋಜನೆ
ಮಾಡಿದೆ.
ಮೇರೆಗೆ ಅಂತಿದ್ರೆ
ನಿಯೋಜನೆ ಅಂದ್ರೆ ಡೆಪ್ಯುಟೇಷನ್.
ನಿಯೋಜಿಸಿದ ಪ್ರಯುಕ್ತ.
ನಿಯೋಜನೆ ಅಂತ ವರ್ಡ್ ಇದೆ.
till the new rules were formulated in terms of rule 2020. It is clear that the posting of the petitioner to Government Polytechnic College at Kalagi between 28/2/2018 to 3/8/2021, cannot be construed as deputation. Full stop. Since the posting is not from one department to another department. Full stop. Merely because the petitioner drew the salary at Kalaburagi, although he worked at Kalagi, that by itself cannot be construed as no change in the lien. Full stop. In fact, the question of change in the lien does not arise in the present context because the petitioner continued to work as a teacher in the same department. Full stop. In that view of the matter, we are of the considered opinion the grievance raised by the petitioner is genuine and was required to be considered in accordance with law. Full stop. Next paragraph. At this juncture, learned government advocate will submit that even in terms of the law governing the transfer of government teachers in terms of rules 2020, if the petitioner has completed the minimum tenure at the Government Polytechnic College at Kalaburagi, is liable to be transferred in terms of rule 4(1) of rules 2020. Full stop. Next paragraph. Consequently, we allow the writ petition partly. Full stop. Nevertheless, we hold that consequently we grant liberty to the respondent authorities to reconsider as to whether the petitioner has completed the minimum tenure of service as lecturer at the Government Polytechnic College at Kalaburagi, commencing from 4/8/2021. Stop. If according to the respondent authorities, the petitioner has completed the minimum tenure in terms of the new rules, 2020, they may proceed in accordance with law. Full stop. Ordered accordingly.
Great.
Seal number 43, Mahesh Patil.
Wait for the respondent.
Release this matter on 19th of November.
Please.
Seal number 44, SV Deshmukh.
Release this matter on any urgency. Release this matter on 20th of November.
Seal number 45, Ganesh Nayak.
Release this matter on 20th of November.
Seal number 46, Shivkumar Kallur.
21st of November.
Seal number 47, Ratnayan Shivayogimat.
My lords, I am appearing. And the last date of hearing is my lords had asked me to come out with some judgments that adoptive son property. ತಂದಿದ್ದೀನಿ sir.
ತಂದಿದ್ದೀರಾ? Next week ಹಾಕ್ಬೋದಾ?
ಹಾಗೆ ತಮ್ಗೆ ಯಾವ್ದು any short date my lords?
14th of November.
Seal number 49, HPP.
Twenty-fifth of November.
Seal number 51, Girisham Patil.
25th of November.
Seal number 52, Sangan Gowda V. Biradar.
Last date, my lords, other side council ಒಂದು judgment ತಗೊಂಬರಕ್ಕೆ ಹೇಳಿದ್ರಿ.
14th of November.
Seal number 53, Sachin M. Mahajan.
21st of November.
Seal number 54, Bapu Goda Sidappa.
I am appeal for the appellant. Last date of hearing was in the chamber in the both the parties are present no for the a child is also in the at the time of present. The wife has want to divorce from the husband of the on the ground of cruelty. Both the last occasion, last date of hearing notes, the both the parties are present before the chamber notes. The last week notes, 28th of this month. Last month.
Marathi ಮಾತಾಡ.
ಇಲ್ಲ. And Gujarati notes. Gujarati. Yes. Yes notes. I read the argument notes, the short. They're not on any notes convenience, but they're not convenient the appellant.
13th of.
Yes, notes.
Seal number 55, AM Biradar.
22nd of November.
My lord, with permission, my lord.
Ah.
So, your lordship passed the order in GMCPC for clubbing the order. Now, I filed one more application for clarification and moved the before the registry, my lord. The registry advised me to move the before your lordship. That's why.
Tell them they can have it on 15th. I will be sitting there.
Much obliged.
15th.
Much obliged.
Yeah.
Sir, ಆ number ಇದೆಯಾ?
Sir, WP number 24689.
Number ಹೇಳಿ.
24,689 of 2024 GMCPC
24.
689 24689
24,689.
2024 GMCPC
2024.
24 DD date 9/9/24.
WP 24689 of 24, sir.
ಹೌದು ಸರ್ GMCPC classification.
24689 of 24, GMCPC.
ಡೇಟೆಡ್ DD ಡೇಟ್ 9/9/24.
ಹಾ.
ಇಲ್ಲಿ ರಿಜಿಸ್ಟ್ರಿ ಮುಂದೆ ಇವತ್ತು ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀನಿ ಇವತ್ತು.
ಅದೇ ಹೇಳ್ತಾ.
ಪ್ಲೀಸ್ ಸರ್, ಪ್ಲೀಸ್ ಸರ್.
ಅಲ್ಲಿ ನಂಬರ್ಗೆ
ಸರ್ ಇಲ್ಲಿ ರಿಜಿಸ್ಟ್ರಿಗೆ ಹೇಳ್ಬಿಡೋದಲ್ಲ.
ಹಾ, ನೀವು ಹೇಳಿ, ನಮ್ಮ ಮೇಡಮ್ ಕೂಡ PS ಕೂಡ ಹೇಳ್ತಾರೆ. ಬೆಂಗಳೂರಿಗೆ ಫೋನ್ ಮಾಡಿ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಹಾ, ಮೇಡಮ್.